ಮೇಡಮ್ ಇದು ಡೈರೆಕ್ಷನ್ ಮ್ಯಾಂಡಮಸ್ ಮ್ಯಾಟರ್. ಡೈರೆಕ್ಷನ್ ಇದೆ ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟಿಗೆ. ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಪ್ಲೀಸ್. ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್. ಸ್ವಲ್ಪ
order for expeditious disposal. May I request for Monday, Your Honor?
You give all the GMCPC memos.
It's an old matter. Liberty was granted.
On submission,
Monday.
Give all the memos.
on submission, can I submit it?
Date be
No,
fixed.
ನಾಳೆಗ್ ಆಗಲ್ಲ.
Can I submit it?
Friday
Please be
or
fixed.
Monday.
Could it please be fixed on Monday, Your Honor?
Can I submit?
You give all the memos.
Monday. Interim order was passed, giving liberty for you to comply with authorizations within 3 weeks. I complied, but the lower court was told that I have not complied with authorization within 3 days. And that's why the interim order is not being accepted. Can I submit it? Can I submit
Tomorrow,
it?
Friday.
Submit your honor. For fresh matter, 4834 Millard. It is previously filed at the time of FIR stage for quashing.
Successive writ.
But once, it is, which is that.
You ಕೊಡಿ sir, successive writ ಬರುತ್ತೆ ಕೊಡಿ.
It may be posted day after tomorrow, your honor, 12th,
Else day after tomorrow is a half day.
11th or 12th.
It will come on Monday.
Yes, please.
ಕೊಡಿ. Give all the memos, sir. Give all the memos.
We have challenged the order of the learned trial court who have rejected our common 11.
Give, sir. CRP ಆದ್ರೆ Thursday.
My lords,
ನಾಳೆ-
matter
ನಾಳೆ-
relating to land acquisitions, my lord, there's some urgency.
Give it, sir.
My lords,
Come on Thursday, give it.
Madam, Thursday.
Tuesday and Thursday land acquisition, they'll come. You know. Yeah, urgency. and-
Now the PTA has cancelled the Khata in my name.
ಅದು urgency ಏನ್ ಬಂತಲ್? It's a matter of final disposal.
Property for action.
ಯಾವಾಗ?
They have mentioned it.
Auction ಯಾವತ್ತು?
27/5/2025 is the date on which the Khata has been.
Auction ಯಾವತ್ತು?
Action ಅದ್ರಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ, it will be action.
ಆಯ್ತು ಕೊಡಿ.
Yesterday,
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್, ನಾಳೆ Thursday ಬರುತ್ತೆ ಕೊಡಿ.
Suit is for the permanent initiative, we are trying to dispossess me from the social property.
Give, sir. Yes.
Yes, sir.
Even is trying to disconnect the electricity power.
Not stitched properly. ನಾಳೆ ತಗೊಳ್ಳಿ.
My lord, suit for eviction, my application for the.
Give it, sir. Yes, give it.
My lords, land ac-
Give it. Give it, sir. It will come. Give it. Yes.
My lord, suit is for the permanent initiative, trying to dispossess.
No, tomorrow, sir. Tomorrow it's already full. Friday or Monday. Give it. Yes.
My lord, they're trying to-
Friday is half a day. We don't know how much. Well, Monday definitely it will come. Give it.
They're trying to
Kind-
dispossess me from the social property, my lord. I'm the tenant in the social property, even they've disconnected the electricity power as well.
Friday.
Lords, kind permission. my
Friday or
lord.
Monday. We'll see.
Lords, I have, this honorable court had permitted me to deposit the 50% of the amount. Before the trial court, I have deposited 25%. And another 25%, the case is on, before the trial court is on June 13th, Friday, my lords.
In GM,
GMCPC. Thursday, my lords, please.
Thursday, Friday.
They issued an IA for additional documents for the commercial.
Give it, madam. Yes.
my lords, Lake ADB matter, my lords. Threat of
Order 11 rule
disposition.
1. Yes.
On Friday.
Rejected.
No, they have not filed objections for a very long time, not to make time.
Oh, ಅಷ್ಟೇ. Monday ಬರುತ್ತೆ.
My lords, KADB acquisition, threat of disposition, my lords.
You threatened Thursday. Yes.
Please.
My lord, two matters, my lord, connected matters, my lord.
Successive.
CRP matters, my lord, the
CRP na ಕೊಡಿ.
coordinate bench has been issued
ಕೊಡಿ
the
sir.
notice, my lord.
CRP ಕೊಡಿ. Yes.
Thursday, my lord.
2:30 CRP ಯಾರು ಕೇಳಿದ್ರು?
WPCPC. The reason is this, yesterday my application came to be rejected.
Hmm.
Not posting it for defendant's argument.
Hmm.
Straight away the trial court has posted it for judgment
When?
to 23rd this week.
Give it. ಏನ್ 2:30 ಗೆ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಕೊಡಿ.
But tomorrow at least.
Monday.
My lord, serial number 39, my lord. Serial number 39, I am for the petitioner, my lord. The connected matter,
Page wise ಕರ್ದ್ಬಿಡಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಇರಬೇಕು.
My lord, my execution proceedings have been stayed by the appellate court subject to deposit of 50%, my lord. They don't deposit this sum, in spite of which the executing court is not proceeding and it has been stayed.
Monday. Yes.
Shivram Karan layout matter, what my
Bench constitute ಆಗಬೇಕಲ್ಲ ಸರ್ ಅದಕ್ಕೆ?
representation to be considered.
I can't do it. Bench constitute ಆಗಬೇಕು. Yes. ನಾವು ಕಾಲ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ಸ್ ಯಾವ್ದಾರು ಇದೆ? ತಗೊಂಡ್ಬಿಡಿ.
serial number 5, my lord.
5. One moment.
Kindly out on Thursday, my lord. On the same caption, the council on is stuck in other matter.
5.
I am for ask number 3, madam. Immediately.
5 next Tuesday.
Thursday, my lord.
Next Tuesday.
Please.
Yes. 17. Admission. Wait, sir. Yes.
Serial number 23.
23 and 23 respondiga. Petitioner barli wait. Yes. Next.
Serial number 26, Lordships. The
Ah.
petitioner is deceased, Lordships. We have to bring LRs. Kindly
Senate
fix
counsel
next.
for the petitioner seeks a week's time to bring the legal representatives of
Kindly
the
fix the
deceased
date.
petitioner, comma, if any. Yes, next.
Kindly fix the date, Lordship, next week.
List on, no. Put up immediately after steps taken. Next.
Please.
Thirty-three to 35, page 8. 36 to 41.
Serial number 39, my lord. I'm for the petitioner in this case, my lord. The connected matter is posted on 26, my lord.
List the matter on 26 at the request of the council appearing for the petitioner. Number ಏನು the connected matter?
Madam?
Number ಏನು?
6415 of 23. my lord.
ಏನ್ ಬೇಡ ಬಿಡಿ ಕನೆಕ್ಷನ್ ಇರಲ್ಲ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕನೆಕ್ಷನ್ ಕೊಡ್ಬೇಡಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Page 9, 42 to 46, page 10, 47 to 52, page 11, 53 to 57.
54, my lords.
54.
My lords, 2 weeks time may be granted, my lords, in this.
You inform the other side.
I inform, my lords. I am
At
for
the
the
request of the
respondent.
council appearing for response 2 and 3, list the matter after 2 weeks.
Much of
If there is
it.
any objection, I'll take it up.
No, my lords, I have informed.
Yes.
M.R. Rajgopal sir has.
All right.
Page 12, 58 to 64, page 13, 65 to 71, page 14, 7.
50? Petitioner running. At the request of the council appearing for the petitioner list next Thursday. Yes. Date up. Next Thursday is, I think, 20th. 19th.
Page 14, 72 to 78, page 15, 79 to 83.
Further hearing. Call the case.
List 1, preliminary hearings, number 1.
Objections ಹಾಕಿದ್ದೀರಾ?
Compensation file ಸಿಕ್ಕಿಲ್ಲ, compensation pay ಆಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ, ಅದಕ್ಕೆ 1 week, 1 more week time ಇದೆ.
Compensation ಕೊಟ್ಟಿಲ್ವಾ?
Compensation ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ ಅನ್ಸುತ್ತೆ.
This
I have
court,
also,
what is the last order passed?
this honorable court had directed them to secure instruction with the
This
compensation.
court on 3/6/2025 had passed the following order. The learned counsel for the learned AGA, ಅಲ್ಲ?
1 week, right?
Learned AGA seeks a week's time as the papers with regard to payment of compensation are not traceable. The learned counsel for the petitioner would however reiterate that no compensation is paid as on date. If that be so, on the next date, the matter would be heard and disposed. List the matter next Tuesday,
Much of it.
68.
17th. Start ಆಗಿದೆ ತಾನೆ? Wait.
Number 2.
Yes. Serial number 2,
Government has to file a report.
what report could it?
My lord, see,
There was
kindly
a-
see the 25th
With
April
regard
order.
to, on the last occasion, it came
Yes,
before your
heavy
lordship,
matter.
they were supposed to,
Heavy matter.
ಸ್ವಲ್ಪ heavy ಇದೆ, lot of plan sanction, remodified plan and all.
Hmm.
So they were supposed to have filed a report,
Who, state is it?
the state.
Was also indicated the council submits that the inspection is conducted. Where is the report? Copy? To all of them. ನಾನೇ ಈಗ ರಿಸೀವ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
Yes. For us, they have, yesterday they have served a copy on the BDA.
Oh,
So ನಮ್ ಕೊಟ್ಟಿದ್ದು.
so you have priority over the court.
It appears so much.
Copy ಕೊಟ್ರಾ?
ನಮ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ. ನಮ್ಗೆ ಕೊಡ್ಬೇಕು
Petitioners
first.
ಕೊಡಿ.
First ನಮ್ಗೆ ಕೊಡ್ಬೇಕು.
What is the report?
We'll have to go through this report because it's comprehensive, because the coordinate bench. has
What's the matter
indicated-
about? What's the
ನಮ್ಗೆ-
matter about?
So I'll just explain. My lord, 2001 initial sanction plan, as far as the petitioners are a society of home buyers in this project, Renaissance Prospero.
Hmm.
2001 plan was sanctioned.
Hmm.
The plan, there were some, although relinquishment of 50 feet road was there, this plan mentions only 25 feet road. I'll come to that later. 17 years later, the developer applies for change in modification of that plan. 17 years later, after our rights have been created.
Yes.
According to us, no modification can be done because some portions of the land were relinquished as per the then CDP 1995. 25% was relinquished to BDA. In 2017 years later, they asked for release of that, merge that released land with some other commercial property that they have adjacent, and shift the parks and civic amenity sites into the land in which we have undivided share. All that without our consent. So therefore, my lord, we have challenged the revision.
Here.
There is no interim order. That's, they are going on with the construction. That
You are the developer. No,
That-
first time I am hearing it, yes.
I
So-
think there should be an interim order.
Finally, next Tuesday, nothing. Give a synopsis of
I will.
dates and
We have
events.
filed a convenience
Then
compliance.
it's
We'll
fine.
give a
Then,
synopsis also, my lord.
list of authorities, everything.
List of authorities we have to give, we'll give that also.
Whatever you want to rely on, please give a copy.
And we'll
to the
also file
court
a-
after serving a copy on
Yes,
them.
if a copy of the
And you
report,
stay, whoever it is, all councils who are appearing, because these bulky matters, you just give me a synopsis and a list of authorities. If you give it, we'll consider.
report
So
copy
next-
if they give, we'll file our objection. If we have any
Ella,
objections,
by the
we'll
next
file.
date,
Yes, yes,
things should be over by the next date.
yes.
No more adjourning on hearing. We'll hear it and close it. Just give me a compilation complete. Yes. All of you.
Yes.
We'll take it next Tuesday,
The Tuesday after that, my lord. Only next Tuesday I have some inconvenience.
2 weeks.
2 weeks.
All right, no problem. List the matter.
24th.
24th. List the matter on 24th. The understanding is that the matter would be heard.
Great,
No adjournment on whatsoever ground would be granted on the next day.
great. Take it. Who doesn't have to order?
3.
Final notification mode issued by KADB is challenged before this honorable court.
What,
Final notification mode of KADB mode 28.
ಯಾವಾಗ 2007 ನಾ
Yes.
ಏನು ಮಾಡಿಲ್ವಾ ಆಮೇಲೆ?
Thereafter, my lord, there is no progress insofar as the petitioner's land is concerned. It is only with respect to 30 guntas of land. Now, what has happened, my lord, under 28.3, the SLAO, my lord, has stated that, my lord, it is within the Gram Tanda limits. Now, there is a circular of KADB, my lord, which says property is
ರಾಮಕರಣ ಇದ್ರೆ ತಗೊಳಂಗಿಲ್ಲ.
100 meters. Correct. Yes. Because of that, my lord, there has been development all through, but insofar as
Except in yours.
yes, because it is in the Gram Tanda limits.
Serve on KDB ಯಾರ ಪೇರ? ಇಬ್ರಿಬ್ರ? ಯಾರು ಒಬ್ರು ಹೇಳಿ. ದಿಲ್ದಾರ್ ನಿನ್ನೆ ನಿಮ್ಗೊಂದು ಆಗಿದೆಯಲ್ಲ. ಎಸ್
Please.
ಏನ್ ನಿಮ್ಮ ಹೆಸರು? ದಿಲ್ದಾರ್. ಎಸ್. ಅಬ್ಜೆಕ್ಷನ್ ಜಲ್ದಿ ಹಾಕ್ಬೇಕು. Don't go by your name, I have told you. Yes. Yes. Learned Counsel, Dildar so accepts notice for the second respondent. Learned AGA for the first respondent. List the matter on 26th.
Till then, there will be status quo. my lord.
26th. Status quo be maintained by the parties till the next date of
Please.
hearing. Copy what they call.
Please. Great.
Number 4.
Consider representations for the KHP as to.
Where's your file?
There is one. My colleague is.
Your colleague.
Bharat.
Get the file. Or get some file and stand. Bare-handed, you will not get any order here. Why? Pradeep Kumara. And what is the relief sought? ಎಲ್ಲಿದೆ prayer ಓದಿ?
ಇದ್ರಲ್ಲಿ.
ಇಲ್ವಾ? ಅವ್ರಿಗೂ ಪಾಸ್ ಬರ್ಬೇಕು, ಪಾಸ್ ಬರ್ಬೇಕು. Get the file.
I adjourn 6.
Petitioner seeking to set aside, quash the preliminary notification, my lords. Vishweshwara, my lords. It is dropped from the final notification, my lords.
Dropped.
Please, my lord. Kindly see Annexure D, my lords.
Where is the order?
Annexure D, my lords.
6/2/2025 ಎಲ್ಲಿದೆ? Page.
Annexure D, page 37, my lords. That is the endorsement issued by the respondent, my lords, saying that it is draft.
2012.
Please, my lord.
ಇದು ಎಲ್ಲ, all these endorsements you have seen. Anyway, the counsel for the petitioner places reliance upon an endorsement dated 27/12/2012, which communicates to the petitioner that his property/lands have been dropped from acquisition, and therefore the petitioner now seeks a direction to ಏನ್ ಕೇಳಿದಿರ prayer ಗೆ?
Set aside, quash the preliminary notification.
Now seeks a prayer to quash the notification insofar as it concerns the subject property. Learned BDA ಯಾರು ಮೇಡಮ್? BDA ಯಾರು ಇದ್ದಾರೆ? Murugesh Charati is directed to accept notice for respondents 2 and 3, 1 AGA, petitioner to serve set of papers upon the aforesaid council. List the matter on 1st July.
Public.
7.
Lord, the KDB have acquired the land in the year 2007, my lord.
Hmm.
And as on date, no compensation has been paid. Therefore, the petitioners have.
ಯಾರು KDBಗೆ? ನಾನು ರಾಮಕೃಷ್ಣ ಅಂತ. Yes. Senate Council Shri Ramakrishna accepts notice for the ರಾಮಕೃಷ್ಣ ಅವರೇ ಯಾವ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ? ಕಾಪಿ ಇಲ್ವಾ? 1 and 2 ಎಲ್ಲಾರ್ಗು ನೀವೇ. ನೋ ಸ್ಟೇಟ್ ಇದೆಯಾ? ಎಸ್. 2 and 3, 1 AGA. Copy ಕೊಡಿ. Petitioner to serve set of papers upon Council Shri Ramakrishna forthwith. Yes, 1ನೇ ತಾರೀಕು. ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತರಿಸಿ ಅಷ್ಟರಲ್ಲಿ 1.
Please.
8.
Appearing for the petitioner, my lords, will led by Mr. Holder, my lords, may I seek for a pass-over?
ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
My lords, there is some.
ಅಲ್ಲ, I'll issue notice if you want.
My lords, may I just seek for a
What,
pass-over?
what are you saying? 2000 and 2008. Correct.
My lords, will take a
Heard
short.
the learned counsel appearing for the petitioner. Learned,
My lords, may I,
madam, don't worry, yes. KDB ಗೆ ಹೇಳಿದ್ದಾರೆ.
HN Vasu.
KDB ಗೆ ಇದ್ದಾರೆ. Counsel C. Chennegowda is directed to accept notice for respondent 1 and 2, AGA 3. The, heard the, what's your name?
Priya Kale.
So heard the learned counsel so and so. The petitioner calls in question a preliminary notification dated 7/12/2000 and a final and a notification dated 2008 seeking to acquire the properties of the petitioner and several other properties. The learned counsel for the petitioner submits that since 2008 nothing has happened in the property and therefore the acquisition has lapsed. The matter would require consideration. Status quo, the property be maintained as on today till the next date of hearing,
Oblige me.
1st June. All right. Idhik senior bill. Yes.
9.
I appear for the petitioner, your lordship.
Compensation.
Being dissatisfied with the compensation award, I have filed a petition before the first respondent, who is the arbitrator appointed under.
What
the
happened Ali?
Ali matter was heard and reserved for orders on 8/8/2024.
ಏನು ಆಗಿಲ್ವಾ ಆಮೇಲೆ?
Till date, no.
Yeah. So cost impose ಮಾಡ್ಬೋದಲ್ಲ? ಯಾಕೆ ಅವ್ರು ಕೋಆಪರೇಟ್ ಮಾಡಲ್ವಾ? The petitioner is before this court seeking the following prayer. The learned counsel, heard the learned counsel, you are Rashmi, right?
Yes, your lordship.
Rashmi K appearing for the petitioner. And the learned AGA. Facts in brief germane are as follows. The petitioner is said to be the owner of a land in survey number 75/5 and 75/6 at so and so, Madam, synopsis number 1L. The lands belonging to the petitioner become subject matter of acquisition for the purpose of formation of national highway and is acquired by the national highway authorities on certain compensation. On 1/2/2017, the second respondent, the special land acquisition officer, is said to have passed an award. Feeling aggrieved by the said award, it transpires the petitioner has filed an appeal before the appeal before the arbitrator and deputy commissioner under the act. The deputy commissioner is said to have heard the matter and reserved it. Application, all right, appeal application. The deputy commissioner is said to have heard the matter and reserved it for its orders on 8/8/2024. Close to a year has passed by, and the fate of these petitioners are marooned in thin air due to the inaction of the deputy commissioner in not passing an order on the application so filed by the petitioners. In the light of the aforesaid facts and the prior being innocuous, I deem it appropriate to dispose the petition by issuance of a writ in the nature of mandamus, directing the deputy commissioner to pass an order pronounce the order on the application so reserved on 8/8/2024 within 2 weeks from the date of receipt of the copy of this order. R2 and R3. R2 and R3 in the mele bardbidi. R2 and R3. No notice need be issued to R2 and R3. Next.
Great.
10.
My lords, I'm seeking for the not to disburse the amount, my lords.
Why?
Suit for partition, my lords. The properties which are a joint family property, certain properties among the suit schedule properties in the partition suit has been acquired. My lords, may kindly see page number 55, annexure E.
Who
my
are
lords.
you?
My lords, I'm the plaintiff.
That I know, but
My lords.
CPC.
See, no, my lords,
ADB.
suit
all
for
right.
partition.
Hmm.
Certain joint family properties has been acquired.
Joint family property is acquired.
Yes, my lords.
Where is the plaint?
Annexure B, my lords.
Page.
Page number 24.
When was the acquisition? Acquisition yavaga?
October 2023. Page 55.
Acquisition.
Page number 55. The
When
notification.
did you file the suit?
The suit was filed in 2023, August.
Prior to acquisition? 1 AGA.
Copies
2, 3.
if served the
2,
copy.
3 so and so. ನಿಮ್ಮ ಹೆಸರು ಹೇಳ್ಬಿಡಿ. ಬಸವರಾಜ್ so and so. Emergent notice to the respondents 4
4 to 8. The other respondents may kindly be dispensed.
4 to 8 memo. Emergent notice to respondents 4 to 8. The counsel for the petitioner files a memo seeking dispensation of service of notice upon the remaining respondents as they are not the contesting respondents. This is what is averred in the petition as well. In that light, notice is issued only to respondents 4 to 8. The petitioner shall serve respondents 4 to 8 by way of hand summons as well. List the matter on
My lords,
1st July.
by meantime,
1st July.
not to disperse the amount.
Compensation, if any. The board shall not disperse compensation, if any, determined as on date till the next date of hearing.
Please.
Next.
11.
For petition. The BDA site was allotted to father of the petitioner during 2006, and also later lease deed also and possession certificate also were issued. In 2013, father of the petitioner expired.
To serve on B. Vachan. Counsel B. Vachan is directed to accept notice for the respondent BDA. For the respondents, petitioner to serve set of papers upon the aforesaid counsel. List next Tuesday. Mandamus will close it.
Much of.
Ivatte serve ಮಾಡಿ.
Right.
The petitioner was the owner of the property bearing survey number 48/6. She has constructed the building and she is residing. The notification was issued for acquiring the said land as per the division bench order, my lord.
Division bench. Huh? Mike ತಗೊಳ್ಳಿ sir.
Nadaprabhu Kempegowda layout, my lord. According to writ appeal.
Where is the order and writ appeal?
Ravel, page number 34, annex again.
34.
Yes, my lord, in page 34. As per the division order, we made representation to delete the land from the equation. No action is taken, without considering.
You submitted the
Yes,
representation.
my lord, yes, my lord. Which is at annexure.
That's VDA, is it?
L.
Vasant, sir.
Without considering my application, the notice was issued, calling upon me to
One AGA. One AGA, 2 and 3. Full name Vasanta. So Vasant accepts notice for the respondent BDA petitioner to serve set of papers upon the council forthwith. List next Tuesday.
In the meanwhile, my lord, interim order may be granted.
Meanwhile, next Tuesday close ಮಾಡ್ತೀನಿ.
13.
ಏನ್ ಸಿದ್ದರಾಮಯ್ಯ ಅವರೇ?
Whether my reference application has been rejected on the ground of delay without considering my application for continuation of delay ordered by decision of this honorable court at annex.
Page.
That at page 14 annexure C.
ಅಲ್ಲ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಆಯ್ತು ಕವರ್ಡ್ ಯಾವ್ದು ಅಂದ್ರಲ್ಲ ಕೊಡಿ.
Page 15 annexure D. The similar circumstances, so a general direction has also been issued to
Hemavati canal, respond number 2 has.
ಆಯ್ತು ಈಗ ಕವರ್ಡ್ ಅಂತ ಕ್ಲೋಸ್ ಮಾಡದ? ರೆಸ್ಪಾಂಡೆಂಟ್
ನಾಗಯ್ಯ ಸರ್ಗೆ ನೋಟಿಸ್ ಹೇಳ್ಬಿಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದು.
3 KS.
ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಎಲ್ಲ ನೀವೇ.
Deputy Commissioner is the referring authority.
Referring.
The petitioner is before this court seeking the following prayer. The learned counsel VB Siddaramaiah would submit that the issue in the list is identical to what the coordinate bench has held in writ petition 6330 of 2025, disposed on 12th March 2025. The learned AGA would not dispute the position of law as is considered by the coordinate bench. The coordinate bench has held as follows, page 16 to 19. In the light of the order passed by the coordinate bench where general directions were also issued, the endorsement would necessarily, the endorsement which was prior to the order passed by the coordinate bench would necessarily be obliterated. In that light, the writ petition stands allowed, the so-and-so endorsement stands quashed. The respondent shall consider the case of the petitioner strictly in consonance with what is held by the coordinate bench as quoted supra, with an outer limit of, ಏನು ಹೇಳಿದಾರಾ?
6 months.
4 weeks.
4 weeks.
4 weeks.
With an outer limit of 8 weeks from the date of receipt of the copy of the order.
3 months.
Yes. On contempt ಬರಲಿ.
ECA.
My lord, other 6 cases.
Connected cases.
My lord, other 6 cases may kindly be called tomorrow.
Same.
Same notification.
230 ತರ್ಸ್ಲಾ?
230.
We'll pass the same order.
Yes, please.
230 list ಮಾಡಿಸ್ಬಿಡಿ.
Yes, please.
Yes.
14.
The annexure E has been challenged, madam. Refused to give a.
Refuse to give.
Please. Refuse
What
to give
refuse to give?
the consent for conversion of the land from agriculture to non-agriculture.
Take notice.
It is covered by decision. my lord.
ನೀವೇನ ವಸಂತ್? Covered?
Page number
ಯಾವ್ದು
36.
ಕೊಡಿ? That is page 36.
26. 36.
Covered ಅಂದ್ರೆ close ಮಾಡೋಣ.
ಮಾಡ್ಬೋದು.
Take a decision in the matter. The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits that in identical circumstances, the coordinate bench in writ petition, page 36, in Vijay, has held as follows, quote the entire order. The learned counsel appearing for the respondent Borda BDA. Respondent BDA would not dispute the position of law as is considered by the coordinate bench and its applicability to the facts of the case at hand. In that light, I deem it appropriate to dispose the petition in the same terms that is rendered by, same terms and on the reasons rendered by the coordinate bench. Adu same court madam. Dispose. Yes. Next.
15, disposed.
Petitioner. ಅವರು ವಸಂತ್ accepts notice ಅಂತ ಮಾಡಿ separate ಆಗಿ ಆಮೇಲೆ ಹರ್ಡ್ ಒಂದು ಮಾಡಿ. Yes.
Direction to respondent to execute the sale deed.
ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್?
15, my lord.
BDA. ಎಲ್ಲಿ? Yes, ವಸಂತ್. Mandamus to consider. Next week hakla? Petitioner to serve set of papers upon counsel Vasant representing the BDA forthwith. List on next Tuesday. Close it next Tuesday. Yes. Yes, next. Yes, sir.
I seek my lord's indulgence to appear through video conferencing.
Yes, sir, you can.
But street lights have been disconnected in the BDA approved layout.
In
BDA
connection?
To pay the electricity charges and to provide civic amenities in the layout. Property tax tagotare. Another peculiar thing is even BBMP doesn't do that.
Bescom.
House.
ಎಲ್ಲದಕ್ಕೂ ಇದ್ದೀರಾ ನೀವು? ಬೆಸ್ಕಾಂ 2 and 3 ಅವರು ಮುರುಗೇಶ್ ಚರಾಟ್ ಇನ್ಯಾರಿದ್ದಾರೆ ಬಿಡಿ? BS Sachin. Counsel BS Sachin is directed to accept notice for the first respondent. 2 and 3 Bescom. Interim trial connection agala. We'll take it. Learned Counsel C. Chennegowda, who has now accepted notice for respondents 2 and 3, shall secure instructions as to why the power connection is not rendered to the subject property on the next date of hearing. List the matter on 24th.
Much.
Petition to serve set of papers on C. Chennegowda. Yes, next.
Admission 17.
Yes, for the petitioner in this case.
The SLP has been filed and notice is issued. ಯಾವ್ದ್ರಲ್ಲಿ? ಓ ಮಣ್ಣನ್ನಲ್ಲ ಕೊಡಿ. ಬರೀ ನೋಟಿಸ್ ಅಲ್ವಾ? ಇದನ್ನು ತಗೊಂಡೋಗ್ಬಿಡಿ ಅಲ್ಲೇ.
Matter is set down for final hearing.
Who told you?
On 11/11 notice was issued.
11/11/24.
Look, the file they rejoined. The matter is set.
ಆಗಿದೆಯಾ? ಎಲ್ಲ pleadings are complete.
Pleadings are
This court, in all these cases, on the score that the subject petition stands covered by the judgment rendered by this court on 22/4/2024 in writ petition 24119 of 2022, had granted interim order of stay of further proceedings. Said interim order is continued from time to time on the ground that the apex court is seized of the aforesaid judgment rendered by the court, though no interim order of stay is granted. The learned counsel for the respondent CBI, Rahul Reddy, submits that the pleadings before the apex court are now complete and the matter is set down for its final disposal. In that light, lest the matter after 8 weeks, interim order subsisting in these cases shall continue till the next date of hearing. The counsel shall inform the court with regard to the proceedings before the apex court.
Please.
Yes.
There is one aspect which we failed to convey your lordships. Mannanalli. We were under the impression that the central government would get the records of the review committee. That was the entire gist.
Correct.
But my lords, there is one more endeavor to it of what would be, suppose if it is an illegal obtained evidence.
That is, we'll see. That you have canvas there now.
And we had canvas there. If we have failed there, we may have to canvas. That we have failed earlier, we were under the other.
See, certain circumstances illegal evidence may become non-est. In certain circumstances, yes, the court may consider it at the time of trial.
True. There's one
It-
judgment, my lords,
No, no,
which
it
we
is,
failed to
it
produce.
is like the fruit of a poisonous tree.
Correct. My lords, in fact, I had the occasion to read your
If it is
lordship's
fruit of a
judgment.
poisonous tree, this court would not decipher it and see, but it's only a matter of trial, we'll see.
I'd had the occasion. That's an American doctrine, my lords.
Yeah,
But
that is what, fruit
that's
of
an
a
American
poisonous tree, yes,
doctrine.
is an American doctrine, yes.
But that has been deferred by
I have
the
myself
Supreme
rendered a
Court. Yes,
judgment
yes,
on that.
in the
Asmat
NDPS
Pasha
case.
NDPS case.
But where Supreme Court now is telling that ends can meet the means. So that's a deviation which the
I know
doctrine
means
of
to the,
poisonous
means
tree
to
has
the
taken.
end is now on the reverse, we'll see, yes.
Please.
Krishna bill. Flashing of charge sheet.
Passport,
Charge sheet.
mic ತಗೊಳ್ಳಿ sir.
Charge sheet.
ಏನಾಗ್ಬೇಕು?
Other accused are
Quashed.
quashed.
Which?
Accused number 167, 567 and.
Education Act, yes, Tejesh.
Please.
Please, my lord.
The petitioner is, ಎಷ್ಟು ಜನ ಇದ್ದೀರಾ?
2.
The petitioners are accused.
Accused number 1 and 13.
Sir, 4 and 13.
Sorry, 3 and 13.
4 and 13.
I'm sorry.
ಎಷ್ಟು ಸರ್ತಿ? Yes.
4 and 13.
The petitioners are accused 4 and 13 are at the doors of the court calling in question proceedings in CC, so and so. The learned counsel appearing for the petitioner submits that the other accused on the same allegations, a coordinate bench has quashed the proceeding, following which this court also has quashed the proceedings. In the light of the issue standing answered by the judgment rendered by the coordinate bench as followed by this court, the unmistakable inference would be the obliteration of the proceedings challenged in the case at hand. Learned Learned HCGP Tejesh would not dispute the position with regard to the coordinate bench passing the order in identical circumstances, and this court following the same in the judgment rendered, Madam Ville, page 91 onwards. So adana court, this court following the coordinate bench has held as follows. In that light, same order. Yes. Next.
19.
Sorry for the petitioners. Last night of taking one number soon.
19.
19.
ಏನ್ ಮೂರಿದೆ?
Please note. Release of the amount in for this petitioner.
Oh, without hearing the petition.
Without hearing the petition.
You are the victim.
Please.
Yes, ma'am, I am the victim.
ಈಗ 4.82 crores ಹೋಗಿದೆ ನಿಮ್ಗೆ.
2 crores 36,000. 4 crores.
ಅದು ನಿಮ್ಮದೇ ಅಂತ ಹೆಂಗೆ?
ನನ್ನ ಹತ್ರನೇ ಅದು ತಗೊಂಡಿರೋದು.
ಏನು? ಟ್ರಾನ್ಸಾಕ್ಷನ್
ಕಿಡ್ನಾಪ್ ಮಾಡಿ
ಕಿಡ್ನಾಪ್ ಮಾಡಿ ತಗೊಂಡು.
Yes, my lord, you also kindly see my lord, page 29. ಆದ್ದರಿಂದ ತಾವುಗಳು ನನ್ನನ್ನು
399 402 ಇದೆಯಾ?
Yes. 364A
ಕಿಡ್ನಾಪ್
ಮಾಡಿಸಿ ನನ್ನ ಮೇಲೆ ಕೊಲೆ ಮಾಡುವ ಬೆದರಿಸಿ ಎದುರಿಸಿ ನನ್ನಿಂದ 6,50,00,000 ಸುಲಿಗೆ
6,50,00,000.
ಎಸ್ ಮಾಡಿರುವ ಡಿ.ಕೆ. ಗೋಪಾಲ
ಹೆಂಗ್ ಕೊಟ್ರಿ ನೀವು?
ಕಿಡ್ನಾಪ್ ಮಾಡಿ
ಅಲ್ಲ, ಕಿಡ್ನಾಪ್ ಮಾಡಿದ್ರು. 6 ಕೋಟಿ ಎಲ್ಲಿತ್ತು?
ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಪ್ರಾಪರ್ಟಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಇದೆ.
ಪ್ರಾಪರ್ಟಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್.
ಪ್ರಾಪರ್ಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲಿ ಇದಾಗಿದೆ. No, my lord, lordship's kindness, my lord. The trial court may not considering the my lord.
Allah, the only problem is trial court has handed over the cash to you, handing over the cash to you without hearing.
You heard.
No.
Heard. ಅಷ್ಟೇ ಬೇಕಾಗಿರೋದು. Where is it?
Heard.
Page.
Heard the arguments ಅಂತಿದೆ.
Heard arguments sir, ಯಾರ್ದು?
APP. It's clearly mentioned.
You are the accused.
I'm the accused number 1.
Accused number 1.
Please note.
What happened ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಏನಾಗಿದೆ?
Charge sheet is filed, madam, pending for trial. Charges
framed.
Yes.
ಇರ್ಲಿ ಬಿಡಿ.
Deposit
ಅವ್ರ ಹತ್ರನೇ ಇರ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ, ನನ್ ಬೇಕಾಗಿಲ್ಲ ದುಡ್ಡು.
We will make it subject to the final orders of the court.
Yes,
In the criminal case,
yes,
Final orders of the
My lord,
court.
lordship's kindness, my lord, the order of the trial
ಈಗ ಏನ್
court.
ಮಾಡಿದ್ರಿ ಎಲ್ಲ ಖಾಲಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ,
ಅಲ್ಲ,
we will,
ನನ್ನ
we will
account
produce the amount when and where my lord direct the trial court directs me to produce. I will produce.
my
And also my lord, the order also my lord, petitioner shall
ನನ್ನ-
produce the
ನನ್ನ
said
account
amount.
ಇಬ್ರು ಹೇಳಿದ್ರ
As
ಒಂದ್ ನಿಮಿಷ ಸರ್.
Let him
the
complete.
petitioner shall produce my submission. Well, against this, my lord, he cannot, my lord, direct me to deposit. His prayer is only to deposit the amount before the trial court. Who is he to deposit?
ನಿಮ್ದು ಏನಂತ ಹೇಳಿ ಸಾಕು.
ನನ್ನ
Who is
ಅದೇನು?
he, what to do will do. Yes.
Says, the petitioner said produce the said amount as and when called upon by the court. I will do that. And his prayer is also safe.
Yes, sir. ಅಷ್ಟೇ.
Lordship, kindly see,
Hmm.
my account has been seized. My withdrawal application has been drawn by the investigation officer. 38,60,000 rupees has been withdrawn on behalf of me and taken to the custody of the police. And then you are release amount to the.
The trial court
Your
will
Lordship.
consider everything.
But a trial court is not consider everything. Small. You
Well,
want
it will consider the criminal case which is there. You are
meantime, I'm not.
364A is the allegation against you. You are accused number 1.
My lord, subsequently.
Hatched a conspiracy with others 120B. Therefore,
120 is not there, my lord. Only 364A and 34.
ಸಾಕ್ ಬಿಡಿ.
Your Lordship,
364A and solve.
Subsequently, what
120
happened?
is there.
What happened? One more complaint has been filed against manager H. Kindly see. Again, he request to the police commissioner.
ತೊಂದ್ರೆ ಇಲ್ಲ. Your right is protected. I will reiterate that.
Request, my prayer is very
ಈಗ
simple.
ವಾಪಸ್ ಬೇಕಾ ನಿಮ್ಗೆ?
ನನಗ್ ಬೇಡ.
ಮತ್ತೆ?
At least deposit to the court or deposit to the bank.
ಪರವಾಗಿಲ್ಲ.
Till disposal
How
of
can
the.
accuse direct me to deposit the amount?
Wait, sir. Why are you getting agitated?
Let them deposit to the
ಅವ್ರು
court.
ಹೇಳಿದ ತಕ್ಷಣ ನಾನು ಮಾಡ್ತೀನಿ ಅಂತ.
Let the amount has been deposited to the court till disposal of the trial. Or deposited to the court by this honorable court has been fixed. Till disposal of the trial. Both are, they are enjoying my 4.8 crores rupees they are enjoying.
That is my
Since from,
money.
even though not.
ಎಲ್ಲಿಟ್ಟಿದ್ದೀರಾ? ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ, ತಾವು ತಗೊಂಡಿದ್ದಾರೆ ಅವರು ತಗೊಂಡ್ಬಿಟ್ಟು
ವೇಟ್ ಸರ್. ಎಲ್ಲಿಟ್ಟಿದ್ದೀರಾ ದುಡ್ಡು?
ನಮ್ಮ ಹತ್ರ ಇದೆ.
ನಿಮ್ಮ ಹತ್ರ ಅಂದ್ರೆ ಮನೇಲಿ ಇದೆಯಾ? ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇದೆಯಾ?
Bank ಅಲ್ಲಿ ಇದೆ.
ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಲೆಟ್ ದಮ್ ಪ್ರೊಡ್ಯೂಸ್ ದನ್ ಕೊಡ್ಬೇಕು. ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇದೆ ಅಂದ್ರೆ ಸಾಕು.
ಇನ್ನೇನ್ ಮನೇಲಿ ಕ್ಯಾಶ್ ಇಟ್ಕೊಂಡಿರ್ತಾರೆ.
ಇಲ್ಲ ದೇ ಎಂಜಾಯಿಂಗ್ ದಿ ಅಮೌಂಟ್ ಮೋಲಾಡ್.
ಎಂಜಾಯಿಂಗ್ ಅಂದ್ರೆ ಯಾವ ತರ?
ನನ್ನ ದುಡ್ಡು ನಾನು ಎಂಜಾಯ್ ಮಾಡ್ತೀನಿ.
ನನ್ನ ದುಡ್ಡು ನಾನು ಕೊಟ್ಟಿರೋದು ನನ್ನ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಸೀಸ್ ಆಗಿರೋ 38 lakhs rupees ನನ್ನ ಅಕೌಂಟ್ ಅಲ್ಲಿ
38 ಲಕ್ಷ ಅಷ್ಟೇ, 4 ಕೋಟಿ ಅಲ್ಲಿರೋದು.
ಅಲ್ಲ 4 ಕೋಟಿ ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಮಾರಿ ಕೊಟ್ಟಿರೋದು ನನ್ನ ಥ್ರೋ ಇಂದ ನಾನೇ ಹೋಗಿ ಕೊಟ್ಟಿರೋದು.
ಅದೆಲ್ಲ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್.
ಮೇಕಿಂಗ್ ಅಲಿಗೇಷನ್.
ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್.
That's why ಮೋಲಾಡ್ ಐ asking.
Let it be anyway, it is protected. We will read.
ಅಲ್ಲ ನನ್ನ ಕೋಟಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿ ನನಗೆ ದುಡ್ಡು ಬೇಡ. My prayer is very short, my lordship.
No worries, your money is safe. We will.
I have money not safe. Last time he asked, he is not cooperated with the trial.
We will.
He is not cooperated with the trial also.
That we will see. We will. ಯಾವಾಗಿಂದ ಇದು 19?
No, sir.
In this case, I cannot direct the conclusion of the trial.
I am not asking, only deposit the amount to the trial court or whenever the requires to bank.
The petitioner accused number 1 in SC 1838 of 2022 is at the doors of this court calling in question an order of the learned magistrate dated 5/10/2019 through by which the application dated 31/8/2019 by which the application of the victim, the respondent, comes to be allowed, filed under section 451 and 457 of the CRPC, comes to be allowed, and a direction is issued to transmit an amount of rupees 4 crores
4 crores 86 lakh.
4 crore 86 lakhs to the account of the victim. The amount has already been transferred. The petitioner at this juncture would contend that the order of the concerned court, i.e. the learned magistrate, is without hearing the petitioner, the accused number 1. The petitioner becoming an accused is on account of a fact that a complaint comes to be registered by the second respondent alleging that the petitioner, accused number 1, along with others, have hatched a conspiracy, abducted the petitioner, abducted the victim, and took away 6 crores.
6.5 crores.
Took away 6.5 crores from the hands of the victim. Therefore, the concerned
ನಾನೇ ಕೊಟ್ಟಿರೋದು ದುಡ್ಡು ನನ್ನ ಕೈಯಲ್ಲಿ
ಆಯ್ತು ಸರ್, hands of the victim. All these matters are pending consideration in SC 1838 of 2022, where the offences against the petitioner, accused number 1, is the one punishable under section 364A 120B inter-alia. The concerned court, on an application filed under section 451 and 457, directs payment of the amount into the account of the victim, the allegation is that the accused is not heard. While it is desirable or imperative that the amount, that the accused also be heard in the matter at the time when the victim files an application and the amount gets transferred to the account of the victim, the case at hand does not project such procedural aberration or grave prejudice caused to the petitioner in the light of the order so passed. The order reads as follows, page 16, the concerned court has directed execution of an indemnity bond and also imposed a condition that the victim shall produce the said amount as and when called upon by the court. The learned counsel appearing for the respondent Rajendra Raghavendra.
Rajendra,
Mr. Raghavendra.
colleague.
Sorry. Rajendra Reddy appearing for the respondent would undertake that as and when the amount is required, the same as and when called for by the court of summoning of the amount would be placed before the court, or the document of the amount being at a place be placed before the court as the case would be. Therefore, the amount of the accused that is now transferred is secured. In that light, there is no warrant of interference at this stage. However, if any further amount is to be transferred on any application that would be filed by the victim before the concerned court shall not transfer it without hearing the accused. The learned counsel for the petitioner submits that the complainant victim is not cooperating with the trial because as the amount, a substantial amount is already realized into his account. In the light of the said submission, it is needless to observe that the victim shall cooperate with the proceedings and its expeditious conclusion in SC. SC ordered accordingly.
And one more
Finding no warrant to interfere with the impugned order, the petition stands disposed.
Judgments is there, my Supreme Court judgments in case of seizure of the amount. There are certain circulars are there that depositing the amount or depositing the bank.
Correct, ಅದು ಸುಂದರ್ಬಾಯ್ ತಾನೆ.
Sundarbai Ambalal.
ಸುಂದರ್ಬಾಯ್ ಅಂಬಾಲಾಲ್ ದೇಸಾಯಿ. ಪರವಾಗಿಲ್ಲ, ಆ ಸ್ಟೇಜ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. Anyway, we have protected it, don't worry. Yes.
Let them here produce before the court.
ಅದರಲ್ಲೂ it is not deposited with the court. It is with the victim only.
Only when
Produced whenever needed ಅಂತ. That is a case of gold, sir.
ಇಲ್ಲ cash ಇದೆ.
Cash gold ಎಲ್ಲ.
Cash ಇದೆ.
Victim ಹತ್ರನೇ ಇರುತ್ತೆ ಬಿಡಿ.
He is enjoying Monada since 4.5, 4 Monada since 3 years. Is my money. I sold the property. I established before the trial court.
ಬರ್ಕೊಳ್ಳಿ. The concerned court hearing SC so and so of 2022 shall also bear in mind the factum of the transfer of the amount to the hands of the victim and the interest that it is earning when it is in the custody of the victim, while determining the fact that the amount belongs to whom, the accused or the victim. All right, yes.
Please. All the three matters.
All the three matters. Same order, common order.
20.
So the last two occasions, my lord, the matter was adjourned, my lord, for appearance of respondent number 2. Now the notice is served, my lord.
Saruda, ಎಲ್ಲಿದೆ? ಯಾರು appear ಆಗಿದ್ದಾರೆ? B. Satish. What's the offense?
My lord, section 76, my lord, 351, 115, 119, my lord.
351, 353, 504, 504, 506 I.
Please.
76.
The allegation, my lord, is that when the dog entered, my lord, the house of the respondent. Please, my lord, the dog, the pet of the petitioners, my lord, entered, my lord, the
cats and dogs ಗೆ ಎಲ್ಲ ಪೊಲೀಸ್ನವರು ನಿಂತುಬಿಟ್ಟಿದ್ದಾರೆ.
That is where, my lord, the quarrel between the petitioner and respondent number 2. In fact, a complaint, my lord, has also been filed, my lord, by the petitioners against respondent number 2, my lord.
Police machinery is deployed in investigating into loss of cats and dogs, and human lives are lost. This is the tragedy. Not that they should not be protected, but there should be some semblance. ನಾಯಿ ಬಿಟ್ಬಿಟ್ರು ಮೇಲೆ ಅದಕ್ಕೊಂದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್, ಚಾರ್ಜ್ ಶೀಟು, ಇನ್ನೊಂದು ಯಾವುದೋ ಇದೆ, ಮಧ್ಯಾಹ್ನ ಪ್ರೊನೌನ್ಸ್ ಮಾಡ್ತೇನೆ, ಬೆಕ್ ಕಳೆದೋಗಿದೆ, ಅದಕ್ಕೊಂದು ಚಾರ್ಜ್ ಶೀಟು.
My lord, in this charge sheet is filed, my lord, there are various.
ಯಾವ್ದ್ರಲ್ಲಿ?
in this
ಏನಾಗಿದೆ ಸರ್?
33.
Page 33, my lord.
ಅದೇ I am there only, sir. ಆರೋಪಿ 2ರವರ ನಾಯಿ ಸಾಕ್ಷಿ 1ರ ಮಗನಿಗೆ ಕಚ್ಚಲು ಬಂದಿದ್ದರಿಂದ ನಾಯಿಯನ್ನು ಒದ್ದೋಡಿಸಿದ ಕಾರಣದಿಂದ ದೋಷಾರೋಪಣ ಪಟ್ಟಿ. ನಿಮ್ ಪ್ರಕಾರ ಕಚ್ಚಿಸ್ಕೋಬೇಕಾಗಿತ್ತು.
There are eyewitness, my lord, to this.
ನಾಯಿ ಕಚ್ಚಿದ್ದಕ್ಕ ಕಚ್ಚಕ್ ಬಂತು ಅನ್ನೋದಕ್ಕ
ಅವ್ರ ನೈಟಿ ಕೂಡ ಅರ್ಧ ಹಾಕಿದ್ದಾರೆ. ಆರೋಪಿ 1 ಆಸ್ ಮುಂದಕ್ಕೆ ತಾವು ನೋಡಿದ್ರೆ
ಪ್ರಾಬ್ಲಮ್ ಇಸ್ ನಾಯಿ ಆದ್ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ದೀರಾ
ಅದು
ಇಂಪಾರ್ಟೆಂಟ್. Your accused number?
That's accused number 1 to 4.
All of you are here.
Please.
The other allegations. Nayi is okay, bitpidi.
In fact, in the complaint itself, they say, my lord, there was a previous altercation, my lords, between the parties.
That's all right.
And it was settled, my lords.
Look at A2 and A3. Kai hididu eladadi. Nighty eladadi.
That's out of, please, my lord.
No, you
allegations, my lords,
assaulted the lady.
out of previous, my lords, enmity between the parties.
If you have assaulted the lady, I will not interfere.
and CW2, my lord.
Anyway, let the complainant
4 and 5
counsel
RBI.
come, we'll see. We'll try to get the issue settled. Yes, Burlier, list the mat at the request, sorry. There is no representation on behalf of the counsel for the second respondent. The counsel for the petitioner is heard. List the matter on next Tuesday. Yes. We'll see you on that day.
21.
Petitioner, my lord. My lord, the offence is under section 5, subclause 4 of Karnataka Epidemic Act.
Excise Act.
1920.
Epidemic disease.
Epidemic disease.
What may kindly
Covered
see,
ಎಲ್ಲಿ ಕೊಡಿ ಅದು.
88, my lord. Page
Annexure
number
D, my lord, in page 92, my
They have
lord.
rendered so many orders, sir. ಕೊಡಿ.
Allah, my lord, in the accused number 1 has already been quashed, my lord, by this honorable.
ಅದೇ page annex page 92.
92, yes, my lord. They are the accused number 2
ನೀವು ಯಾವ
2 to
accused,
13. Lord, 2 to 13, my lord.
The petitioners are accused, ನೀವು ಬರ್ಕೊಂಬಿಡಿ. Petitioners are accused 2 to 13 are at the doors of this court seeking the following prayer. Counsel for the petitioner submits co-accused. This court, Annexure D 92, same one. Yes, close. Next.
Good.
This reserved.
22.
Next. I'm little doubtful about the proposition. Karnataka amendment says something else. Have you not seen the Karnataka amendment?
No, but Lordship may kindly say the latest.
No problem, I will see. That's why reserved, yes.
But provision is very clear, my
We'll
lord.
see, yes. We'll give you on Monday. Give the judgment on Monday.
Monday.
Heard reserved. ಇವ್ರು ಕೊಟ್ಬಿಡಿ ಯಾರಿಗೆ?
Orders 23.
We have to respond now. 2 weeks.
Kindly 2 weeks.
Lord, it's a
Kindly
wildlife,
extend interim order.
no, it's a wildlife trophy matter, my lord.
Covered.
There is no ingredients of the Money Laundering Act, my lord. There is not even a single
How did you do
ingredient.
that? Mysore da?
How this?
Animal trophy.
Animal trophy.
I granted stay last time,
Yes.
right?
Not even a single ingredient.
Allah, I would. This court on 29/4/2025 had passed the following order. The learned counsel appearing for the respondent was directed to file statement of objection hakidira.
Objection hakid.
Directed to secure instructions and make submissions as how the provisions of the Money Laundering Act would kick in the teeth of the allegations against the petitioner. The learned counsel appearing for the respondent seeks 2 weeks' time. In the light of the time being sought by the respondent, list this matter on 2nd July. Interim order subsisting will continue till the next date of hearing.
24.
That's
for
in
respondent.
this matter. That's this matter.
Pollution
was just-
control.
No, my lord,
It's a
KDB
KDBA matter.
24 serial
KDB,
number.
sorry.
There is a non-bailable warrant issued for non-payment of cost of 1 lakh by the petitioner.
ಯಾರ್ ಮೇಲೆ?
Petitioner.
That's ಏನಾಗಿತ್ತು
ಅವರು
ಇದು?
ಇಲ್ಲ, petitioner ಇಲ್ಲ.
They're not coming.
They are
my
not
lords.
coming.
There are set of similar petitions.
Where is the NBW order?
My lord, dated 17/4/25.
So what have you done with the NBW order? Why is it not executed? This court, the coordinate bench of this court on 17/4/2025 has passed the following order. The order, the coordinate bench directs non-bailable warrant to be issued against the petitioner in the teeth of non-payment of the cost. If cost is paid, there would be no need for arrest or detention, is the observation. The petitioner is neither present nor is represented by the counsel. The state shall show cause as to why the order dated 17/4/2025 has not been executed as on date. List the matter on Tuesday next. Yes, Sriraj?
25.
There's an office note, my lords, which says that I've not filed an application for bringing the LRs on record.
ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ, ಅದು your lordship may see page 7, my lords. I've made a note. It says page
ಯಾರಿಲ್ಲ?
7 of the writ petition. My lords, they're not necessary because they're my vendors. It says it is
There are
submitted.
vendors.
It is submitted.
What's
as
the
response-
issue about?
My lords, the challenges to the acquisition, my lords, of Nagarbavi layout.
Are you
second
a
stage.
purchaser after the preliminary
I am the
notification?
subsequent purchaser, my lords, but my grounds are different. Your
No
lordship.
right- You have no right to challenge
My
the
lords, I have no
acquisition.
right. My lords, your lordship may have it on the 17th. My lords, your
Yes.
lordship may-
List the matter on
17th.
learned counsel, at the request of the council appearing for the petitioner, list on 17th.
Grateful.
Yes, sir.
26 adjourned, 27.
Petitioner,
Furnishing of FPF.
please, ma'am. I'll furnish it today itself.
Furnish it.
Not received the copies, my lords. I appear for the first respondent.
Learned counsel,
NHAI.
for the- 1 minute, sir. Learned counsel for the petitioner seeks a week's time to do the needful. The learned counsel Giridhar SV submits that no copy of the petition is served upon him. Therefore, the service shall be done forthwith. In the event both the aforesaid are complied, list the matter on Tuesday the next.
Tuesday.
17th, yes.
Interim order like any.
Interim order ಇದೆಯಾ?
ಇದೆ.
ಹಾಗಾದ್ರೆ 24th. Interim order subsisting will continue till the next date of hearing. Yes, next.
Please, oblige.
58.
For the petitioner, my lords.
Challenge to the final notification by the petitioner.
Getting the interim order.
Yes, my lord. After hearing, this honorable court formulated a point and directed me to address this on 8/4/25.
8/4/25.
1 minute. The summoned substance is, my lord, we say that 17 notification, 19 notification under the Coda Act is sufficient. It is in pari materia with section 4 and 6. The learned friend took up the argument saying that it is not pari materia because of section 36 of the Urban Development Authorities Act. So then this honorable court directed me to answer this. The field is quite well covered by this honorable court's judgment as well as offshore holdings judgment. Wherein say section 17 is in pari materia with section 4, 19 is with section 6. If I may be permitted to produce.
That's the Land Acquisition Act and the KDB Act.
Under the Urban Development Authorities Act.
Urban Development.
Section 17/4, 19/6.
All right.
And this has been settled almost about 15, 20 years ago.
Not settled.
ಯಾವ್ದು ಸೆಟ್ಲಿಲ್ಲ. Let me commence my argument.
ಹೇಳಿ.
Lords, this is a proceedings under Karnataka Urban Development Authority Act. This is not the case of compulsory acquisition. This is case of acquisition by consent. Yes. Now, if my lords have a look at the section 15, 16.
Urban
17
development.
Yes. My lords, section 15, kindly see.
15.
15.
All right.
Power of authority to undertake works and incur expenditure for development, etc. The authority may draw up the detailed schemes hereinafter referred to as development scheme for the development of urban area. B, with the previous approval of the government undertake from the time to time any works for the development of urban area and incur expenditure therefore, and also for framing and execution of development schemes. Subclause 2, the authority may also from time to time make and take up any new or additional development schemes. One, on its own initiative if it is satisfied the sufficiency of the resources. Two, on recommendation of local authority, if a local authority places at the disposal of authority the necessary funds for framing and carrying out any scheme. Three, otherwise. Notwithstanding anything in this act or any other law for time being in force, government may, whenever it deems it necessary, require the authority to take up any development scheme or work and execute it subject to such terms and condition may be specified by the government. Then, my lords, have a look at the section 16.
Yes.
That is particulars to be provided for development scheme. Let me skip for time being, my lord, section 16. Then, my lord, this is very important, section 17. This is where the preliminary notification has to be issued for compulsory acquisition. Where a development scheme has been prepared, the authority shall drop the notification stating the facts of the scheme.
17 of KUD Act.
Karnataka Urban Development has been prepared. Authority shall drop the notification stating the fact of scheme having been made and limits of the area comprised therein, naming a place where particulars of the scheme, map of area comprised therein, statement specifying the lands which is provided to be acquired, and of the land in regard to which betterment tax may be levied may be seen all reasonable hours. Next, subclause 2. The copy of the notification shall be sent to the local authority. I'll skip for time being. Subclause 3. That is also causing copy of the notification. Then, my lord, subclause 4. If no representation is received from the local authority within the time specified so and so, the concurrence of local authority to the scheme shall be deemed to have been given. Next, subclause 5. During the 30 days next following the day on which such notification is published in local newspaper, the authority shall serve a notice on every person whose name appears in the assessment list of the local authority or in the land revenue register as being a primary liable to pay the property tax of the land revenue assessment on any land or land in which proposed to be acquired in executing the scheme, or in regard to which authority proposed to record the betterment tax, requiring such person to show cause so and so so and so. Next, my lord, I'll skip section 17. Next, my lord, section 18. This is most important. Sanction of the scheme. After publication of the scheme and service of notice as provided in section 17, and after consideration of the representation, if any, received in respect thereof, the authority shall submit the scheme, making such modification therein as it may think fit to the government for sanction. A description with the full particulars of the scheme, including the reasons for any modification insert therein, complete plans and estimates of the cost of executing the scheme. Next, a statement specifying the land proposed to be acquired. D, any representation received under subsection 2 of section 17. Next, a scheme schedule showing the rateable value as entered in the municipal assessment book on the date of publication of a notification relating to land under section 17, or the land assessed of all the land.
Now, what are you trying to suggest?
My lords, what I want to try to suggest is that, my lords, kindly see section 15, the complaints of section 15, my lords would find it at page number 125. That is section 15 1A. 125.
Section 15
1A.
Page
125. Annexure E.
One moment. All right. Yes.
This is section 15 1A. Karnataka Nagabhiವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಭೂಸ್ವಾಧೀನ so and so ದಿನಾಂಕ 11/2/2015 ಶೇಕಡ 50:50 ಅನುಪಾತದಲ್ಲಿ ಪ್ರಾಧಿಕಾರ ಮತ್ತು ರೈತರ ಸಹಭಾಗಿತ್ವದೊಂದಿಗೆ ವಸತಿ ಯೋಜನೆಯನ್ನು ಅನುಷ್ಠಾನಗೊಳಿಸಲು ದಿನಾಂಕ 26/10/2001 ನಡೆದ ಪ್ರಾಧಿಕಾರ ಸಭೆಯಲ್ಲಿ ಅನುಮೋದನೆ ಪಡೆಯಲಾಗಿದೆ. ವಸತಿ ಯೋಜನೆಗೆ ಭೂಮಿ so and so so and so so and so. Next, my lords, I'll skip, my lords, at last line. There's a survey numbers mentioned. That is 570 ಹಾಗೂ ಇನ್ನಿತರ ಸರ್ವೆ ನಂಬರ್ಗಳು ಅಂದಾಜು 200 ಎಕರೆ ಜಮೀನು ಸಂಬಂಧಿಸ ಭೂ ಮಾಲೀಕರ ಜಮೀನನ್ನು ನೀಡಲು ಒಪ್ಪಿಗೆ ಪತ್ರವನ್ನು ಪ್ರಕಟಣೆ ದಿನಾಂಕದ 30 ದಿನಗಳಲ್ಲಿ ಪ್ರಾಧಿಕಾರ ಸಲ್ಲಿಸಲು ಕೋರಿದೆ. Then, my lords, I take my lords to section 15 subclause 1B complaints, page 136. Page 136, my lords. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಚಿಕ್ಕಮಗಳೂರು ನಗರ ಪ್ರಾಧಿಕಾರ ಸುಮಾರು 200 ಎಕರೆ ಜಮೀನಿನ ಭೂ ಮಾಲೀಕರು ಹಾಗೂ ಪ್ರಾಧಿಕಾರ ಸಹಭಾಗಿತ್ವದೊಂದಿಗೆ 50-50 ಅನುಪಾತದಲ್ಲಿ ವಸತಿ ಬಡಾವಣೆ ಯೋಜನೆ ಅನುಷ್ಠಾನಗೊಳಿಸಿ ಈ ಕೆಳಗಂಡೆ 15 ಅನ್ವಯ ಪೂರ್ಣಾನುಮತಿ ನೀಡಲಾಗಿದೆ ಎಂದು ತಮಗೆ ತಿಳಿಸಲು ನಿರ್ದೇಶಿಸಲಾಗಿದೆ. Next, my lords, kindly see section 17, that is preliminary notification, page 139.
Yes,
This is also speaks about consent.
all right.
Then, my lords, kindly see section 18, subclause 1, page 180.
180.
180.
Yes.
180. My lords, got it, my lords?
Yes, I'm there.
My lords, page, I'm sorry, kindly see page 182. Last pet, one para, ಮುಂದುವರೆದು ರೈತರೊಂದಿಗೆ ಹಂತ ಹಂತವಾಗಿ ಸಮಾಲೋಚನೆ ನಡೆಸಿ 203 ಎಕರೆ 28 ಗುಂಟೆ ಪೈಕಿ ಇಲ್ಲಿವರೆಗೆ 138 ಎಕರೆ 31 ಗುಂಟೆ ಜಮೀನನ್ನು ಭೂ ಮಾಲೀಕರಿಂದ ನೋಂದಾಯಿತ ಒಡಂಬಡಿಕೆ ಪತ್ರ MOU ಮಾಡಿಕೊಳ್ಳಲಾಗಿರುತ್ತದೆ. ನೆಕ್ಸ್ಟ್ 31 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನಿನ ಭೂ ಮಾಲೀಕರು ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ ದಿಸ್ ಒಪ್ಪಿಗೆ ನೀಡಿರುತ್ತಾರೆ. ಉಳಿಕೆ 33 ಎಕರೆ 21 ಗುಂಟೆ ಪ್ರದೇಶ ಭೂ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಕೈಗೊಳ್ಳಬೇಕಾಗಿರುತ್ತದೆ. My case falls within 33 acres.
These 33 acres to ಒಪ್ಪಿಲ್ಲ.
Then, my lords, I take my lords to
Acquisition proceedings had to be initiated.
Yeah, had to be initiated. Then I take my lords to page number, that is page 191. What the government has said kindly, that is page number 191. This is a government approval, page 192. Serial number 12.
Yes.
ಚಿಕ್ಕಮಗಳೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ವ್ಯಾಪ್ತಿಯ ಚಿಕ್ಕಮಗಳೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಇಂದಾವರ ಗ್ರಾಮದಲ್ಲಿ ವಸತಿ ಬಡಾವಣೆ ನಿರ್ಮಿಸಲು ಉದ್ದೇಶಿಸಿದ ಪ್ರಸ್ತುತ ಪ್ರಾಧಿಕಾರವು ಕರಾರ ಒಪ್ಪಂದ ಮಾಡಿಕೊಂಡು 170 ಎಕರೆ
ಸಾಧ್ಯವಾಗದಿದ್ದಲ್ಲಿ 2013 ಆಕ್ಟ್ ಅಲ್ಲಿ ಅಕ್ವಿಸಿಷನ್
ಮಾಡಬೇಕು as per section 36.
Correct.
Now kindly see section 36 of
acquisition.
This thing, Urban Development Authority Act.
ಇದ್ರಲ್ಲೇ 36.
Yes. Let's kindly see section 35 first. Section 35.
Yes, sir.
Authority to have the power to acquire the land by agreement. This is what exactly the case falls.
Enter into an agreement.
Yes.
Yes.
Subject to the provisions of this act and with the previous approval of the government, the authority may enter into an agreement with the owners of any land or any interest therein situated within urban area for the purchase of the such land.
All right.
Now, section 36. The acquisition of land under this act, otherwise than agreement, within or without the urban area shall be regulated by the provisions so far as they are applicable of right to fair compensation.
Land Acquisition Act.
How? This is not done. Now what they did is that after this approval, now they have issued a final notification, including my land also in the final notification, which we are objecting for an acquisition at the initial stage itself.
Where is that?
Grateful. And its final notification, I have placed it to account, which is a subject matter of challenge at page number 71.
Now your land is included in
Included, page number 72.
without resorting to acquisition.
Acquisition proceedings. This is what exactly which was argued on last occasion, and this question, my lords, which was
Book ಬೇಕಾ?
And better.
Book
Kindly see judgments that I have. Directly on the point, same set of facts, similar kind of contentions are raised at an earlier. 3 judgments are.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀರಾ?
Kindly see the order sheet dated 8/4/25 is exactly on the same section.
That I have seen. Yes.
Now I'll have to establish that section 17 is section 4, section 19 is section 6, man. May I request my lord to kindly see the second judgment in page 17. Urban Development Authorities Act, my lord, is in pari materia with the BD Act. Same, the wordings also are the same, my lord. Kindly see in page 17. This is the judgment of this honorable court. wherein they have extracted the VDA Act and the Urban Development Authorities Act, and this court has held that they are one and the same. Section, may I read, madam? Section 17 and 19, notification, acquisition of fifth so and so, after 4 lines, madam. On facts held, question as to whether the formation of a new residential layout for development of Belgaum city is required or not is a pure question of fact which is to be decided by the concerned Urban Development Authority. Court will not substitute its own opinion in the matter. Further held, special procedure is prescribed under the CUDA Act in the matter of issuing acquisition notifications after finalization of the scheme. Notification under section 17 and 19 of the CUDA Act should themselves be treated as preliminary and final acquisition notification. Therefore, the scheme formulated, sanctioned, set for implementation under the CUDA Act cannot be stultified or rendered ineffective or unenforceable by the provisions in the Central Act. Acquisition proceedings cannot be held to be vitiated in any manner, and there is no valid reason to interfere with the impute notification. The set of facts, my lord will get it in page 18, last 3 lines. Same contentions are raised at an earlier point in time. And the answer to that, my lord, is in page 20, para 6 and 7.
Para 6 and 7.
The question in page 20. The question as to whether the formation of a new residential layout for development so and so, the same para 7. The contention of so and so advocate notification under 17 are not the acquisition notification, but are issued only during the course of finalization. The scheme cannot be accepted. At this stage, it is relevant to note that the provisions of section 15 to 19, 35 and 36 of the CUDA Act and section 15 to 19, 35, 36 of the Bangalore Development Authorities Act, which are on pari materia with each other, as could be seen from the following chart. Entire this thing is culled out, my lord. So 19 and 17 are same. Para in page 26, para 27. Provision so and so. Thus, it is clear that the aforesaid provision of the City of Bangalore Improvement Act 1940 is on par with section 36(1) of the BD Act as well as section 36(1) of the CUDA Act. Apex court in the case of so and so Land Improvement Trust Board versus Narayanaya while holding. This next last 3 lines. 27 page 2. Madhyadalli. The observation made by the Apex court in the case cited supra are aptly applicable to the case on hand. Though chapter 4 of CUDA Act deals with the acquisition of land, section 36(1) of the CUDA Act makes it clear that the acquisition of land under CUDA Act within or without urban area shall be regulated by the provision so far as they are applicable of the Land Acquisition Act. The words so far as they are applicable used in section 36(1) of the CUDA Act cannot be construed or read as far as they are specifically mentioned with regard to the procedure prescribed in the land. Ultimately, offshore holdings, they say it's a legislation by incorporation and legislation not by reference so far as section 36 is concerned. Wherever it is applicable, this court has held. Then section 36, if this act itself is exhausting, section 17 and 19, when it is in pari materia with 4 and 6, his only grievance is that I should not have taken 17 and 19. It should have been under section 4 and 6. Therefore, I submit, kindly see the Apex court. This BD Act was challenged. Section 17 and 19 was challenged.
Para 36, state enactment will prevail over the central enactment.
May I read one?
I have read it. I have read all your paragraphs. Yes. Yes, sir.
Their point.
Development.
Development actually 206 acres only. 176 acres, more than 200 crores have already been spent. I have the photographs to also bring on the point.
Why did this state pass an order saying that you have to enter into acquisition?
That is because now acquisitions are taking place
Correct.
by means of an agreement. 90% of the people have agreed. They are very happy.
All right, somebody may not agree.
May not agree. That's
You'll
what
have to initiate proceedings.
I will give him compensation and acquire. He is still in possession. He is still in. I am yet to take possession. This is the third round of litigation that he has come.
This is a judgment round.
First 2 rounds
My lords, what had happened was this. No, let me place it on record.
Right.
First, my lords, I filed a writ petition. I was not knowing about the acquisition. Since there was a threat of disposition, I filed a writ petition. Then along with the writ petition, they filed a statement of objection indicating that there was a notification, everything. Then, my lord, this court has granted me interim protection. and granted him liberty to approach this court by keeping open all the contention. my lords. Thereafter, my lords, what had happened was that I filed an objection and they have rejected my objection to the preliminary notification. I have specifically stated that this is not a case of compulsory acquisition. This is a case of acquisition by consent. And they rejected my grievance on the ground that your objection is belated. That endorsement.
No, you want compensation under what?
No, my lords, I am not talking about the compensation.
ಅಲ್ಲ, ಅಂದ್ರೆ
My lord, this is an agricultural land.
Yes, they have to acquire ಅಂದ್ರೆ.
ಕೊಡ್ಲೇಬೇಕು. My lords, this is a case of if they want to resort to compulsory acquisition, they can do so. They should give, my lords, as per section 15, they should go as per the scheme. My lords, they should resort to compulsory acquisition. Then what happens is that, my lord, as per section 18, they should consider my objection and they should submit a report to the government. My objection has to be considered by the government and it should be an approval has to be granted. And this case on hand, my lords, the government has not approved. Government has said that insofar as the acquisition by consent, approval is granted. But insofar as
33 acres under 2013.
correct. My lord, section 36.
Now, even if you want to acquire, you will have to initiate proceedings.
Fresh
under the
proceedings.
I need not. Section 17, 19 is over.
No.
I have to take possession, give him compensation
Compensation.
under 2013 Act.
My lords,
And then he has the opportunity to seek for enhancement.
That is a difference.
That is a difference.
no, my lords, they should resort to section 17, 18, and they should pass an order.
So 17, 19 is over under the Urban Development Act.
My lords, that's the reason why. Again, I want to impress upon the court is that 17, 18 procedure is complied in
Different
those
from
cases who are given a consent,
ಗೊತ್ತಾಯ್ತು.
and not those cases where the landowners has not given a consent. My case is
Does
not.
not deal with compulsory acquisition. is
Acquisition.
what you say.
My lords, and in addition to that, if they want to resort to compulsory acquisition, they should consider my objection in with proper application of mind. Now, my lords, this court, kindly see it, my lords, in the earlier round of litigation, this court has passed an order. Kindly see the order, my lords, kindly see page number 216. My lords, my contention is noted at para number 3, page 220. Then my final order is that, kindly see the final
220.
order.
Reason is at 224.
Yes, sir. Page 227 is the final order.
Correct.
Now kindly see what this court has directed to consider my representation and to pass an order by giving an opportunity. Page 227.
All right.
Now annexure A also is the subject matter of challenge. Now kindly see how they have decided my objection in a light-hearted manner, which there is no proper application of mind. Kindly see page number 51.
You should be light-hearted.
My lords, that's
Heavy
what
heart
the,
arbiter kashta hai.
my lords, Apex court says that when you are considering the
You
objection
should
filed by the
consider with heavy
landowner,
heart.
there
Yes.
should be a proper application of mind, because you are taking away somebody's property.
Correct.
So therefore, my lords, it's an agriculture property, my lords. We are situated in the Chikmagalur, where 22 acres of coffee land, including pepper, is grown in the subject land. That is only the main source of my livelihood, which they cannot take away in a light-hearted manner. Kindly see page number 51. What they say is that already there is a development which has been taken place and it's for a public purpose. Therefore, we are rejecting it. My lords, kindly see the decision of the Apex court. While considering the objection, how it has to be dealt with, it has been decided by the Apex court.
Kodi.
First decision, here decision. Yes,
ಅದು ತೆಗಿಬೋದು.
sir.
ಅದು ತೆಗಿಬೋದ?
My lords, first decision is Kamal
Paragraph
Trading Private Limited versus
Paragraph
State
ಹೇಳಿ.
of paragraph number 10, 11, 15, 16 and 19.
Para 10,
Yes, sir.
11, 15, 16 and 19.
Yes, sir.
All right, next judgment.
What it says is that there should be a proper application of mind with regard to the objection.
That is too rudimentary to even look into a judgment.
Yes, sir.
Yes.
Then my lords, next decision, my lords should find it at page number 8.
Para 23 to 26.
Yes, sir. My lords, in that important, my lords should find it at page number 10.
Yes.
At para number 8.
Yes. That is the third judgment.
Yes.
Yes, Ashana.
ಒಂದೇ ನಿಮಿಷ ಸರ್ 2 ನಿಮಿಷದಲ್ಲಿ ಮುಗಿಸ್ಬಿಡ್ತಾನೆ. My lords, in that, what I want to impress upon the court is that one of the objection raised by the landowners is that the land is a main source of income. The land should not be acquired. Para number 7. My lords, then my lords should find it at para number that is 23. Para 23, second paragraph. It is fundamental that compulsory taking of the man's property is a serious matter, and the smaller than the man, the more serious the matter. Hearing him before depriving him is both reasonable and preemptive of the arbitrariness. Denial of the administrative fairness is a constitutional.
Sachin.
Yes,
I've seen.
Then my lords, page number 17. Then my lords, another decision which directly deals with the provisions of Karnataka Urban Development Authority Act, page number 19. Paragraph number, my lords should find it at para number 12, page 23.
Oh, old one. Yes, all right.
Para 12. Then my lords, then another important submission before my lords is that before acquiring the land, there is a requirement of taking environment clearance. That is a law which is laid down by the apex court. My lords should find it at page number
285, 271.
Yes, sir. That is, I applied under RT Act. They have stated that in reply at page number 299.
No environment clearance.
No environment clearance is being given.
Correct.
The decision of the apex court also is placed on record.
MC Mehta is followed and Kenchappa.
Yes, sir. That is page number
271.
271.
Yes,
General directions has been issued by all acquiring authority to take environment clearance.
Yes, sir.
Before acquiring the land.
Page 290.
Yes, sir.
Yes.
Then my lords, so another important thing is that my lords, the subject land falls within a green belt area. My lords, would you find it at page number 124. I have placed the map on record to show that subject survey number falls within the green belt area. My lords, these are the important, my lords. Other things, my lords, I have placed on record, my lords, along with my objection, saying that, my lords, one is environment clearance is not taken. The land falls within the green belt area. My lords, then, my lords, recommendations should be supported as to why the particular piece of land should be acquired. So there is no such recommendation at all. Since it is in a compulsory acquisition, my lord, there is no such recommendation at all. Then another important aspect is that, my lords, whatever the judgment which is placed on record by the respondent with regard to the, that is first judgment, Gopal and another, does not speaks about the acquisition by consent. It is with regard to the compulsory acquisition.
Which one?
That is Gopal and another was the state of Karnataka, which is relied upon by the respondent.
That is acquisition. That is
It is not a case of acquisition by consent.
That is acquisition under the act.
But it is not the case of acquisition by consent. This is the case of acquisition by consent.
All right, we'll see, we'll consider.
Yes, sir. That is first point. Then, my lords, insofar as the second judgment, that is offshore holding private limited versus Bangalore Development Authority. That judgment speaks about that, my lords, even if it is scheme lapses, acquisition does not lapse. Now, in this case on hand, my lords.
He is not relying on that.
Yes.
He is relying particularly paragraph 36.
My lords, here, my lords, they have clearly incorporated the provisions of new act under the state enactment. Now, kindly see, my lords, section 36. My lords, those cases where there is no specific incorporation of the new act under the state enactment, my lord, this probably this judgment may apply. This is a case where, my lord, specifically they have incorporated the provisions of the Right to Fair Compensation Act under the state enactment.
We'll consider.
So therefore, my lords, on this count, my lords, the acquisition is bad in law, which is being vitiated for non-compliance with the statutory provisions.
Interim order ಇದೆಯಾ?
This interim order is there.
ಅಷ್ಟೇ. Yes. Heard, so and so reserved. Interim order subsisting would continue till the disposal of the petition.
But map is already on record, but it is, I am supplying the enlarged copy of the.
ಇದೆ sir.
Wait.
29.
ಇದು ನಮ್ದ? ಓಕೆ, ಅದಕ್ಕೆ ಫ್ಲಾಗ್ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ, ನಾ ಎಲ್ಲೆಲ್ಲ ಹಾಕಿದ್ದೀನಿ ಅದಷ್ಟೇನಾ? Next.
There is number 29.
29.
This arm court directed to
But in this regard, my lord, we have already filed the objection. It may be heard in the final, my lord. It is very urgent because the
Urgent?
urgency is because this, my lord, the stretch of 3.5 kilometers is left over. The rest of the entire thing was already done. Due to the stay in this matter, the bypass at Talguppe was stopped.
One second. ಇದೇನು ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೀರಾ?
No, my lord.
Objection itself is filed, my lord.
Counsel for the learned AGA submits that the objections are already filed
Already filed.
along with report ಏನಿದೆ?
This report is all.
Along with the report.
Yes, every report is.
Objection copy not been served.
The office objections, other office objections indicated stands overruled. The learned AGA pleads urgency in the matter. List
My lord,
list on Thursday in
Thursday, my lord.
preliminary
I saw it.
hearing.
One more connected matter is there, my lord.
Kudi.
Kindly tag that.
List
The
on
road
Thursday.
alignment, my lord, they are challenging the entire bypass design itself, my lord. So,
List
very
on
urgent.
Thursday in preliminary
That's
hearing, yes. Next.
30.
On amendment of cost title,
I have filed amended cast title and also amendment.
early hearing. We'll hear it.
Please.
Not now. Cost title amend ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀನಿ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಇದು ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಹಾಕಿದ್ದೀನಿ.
Learned counsel submits the office objection, so the needful has been done by filing an amended cost title. Application seeking early hearing of the matter stands rejected as the matter is not formally admitted. List the matter on 24th. Yes. 31. Yes, Rahul.
31. For the
File
petitioner,
an
my lord.
application to substitute.
I have seen that. Now, what is the suggestion of substitution? Yarna?
I've in fact also suggested the name Arun Gashu Giri.
Where is the order of posting of the?
Your Lordship, I've produced it along with the flag and
Yes,
a notification.
My lords, I only request that the SIT, that the application may be allowed, my lords, but insofar as my request is concerned, my lords, I only request that the SIT may be protected, my lords. If your lordships from being further transferred or deputed, if your
That
lordships
will-
may recall,
That will see.
And also I've also given a list of officers who are also assisting. The junior officers.
ಇವರೆಲ್ಲರನ್ನು ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ಬೇಕಾ ಈಗ?
ಹೌದು.
The state, this court had disposal. This court, in terms of its order dated 25/3/2025, had directed the constitution of 25/4/2025 had directed constitution of a special investigating team comprising of the following, page 33. The state has now moved an application seeking modification of the said members of the special investigating team on the score that one Shri Bhushan Gulab Rao Borase is now transferred and appointed as police commissioner Belgaum City. And therefore there is Belgaum City, and he has assumed charge of the post. Assumed charge of the post. The affidavit so filed by the third member of the special investigating team reads as follows. Quote it, page 2 and 3. While this court would not come in the way of the transfer and posting of officers, owing to certain administrative exigencies, the state is expected to, state is expected not to disturb the special investigating team and the officers who are assisting the investigating team. Now, the replacement is also suggested in the affidavit as to one yarad.
Sri Arun Gashugiri,
Yarad.
IPS.
Arun?
Arun Gashu.
Where do I find that name?
No, that's in the application itself I mentioned, Your Lordship. Replace the said
The,
officer with
the
one.
state has now come up with another name in place of the person who has now been transferred as Commissioner Belgaum City. The replacement is one Shri Arun Gashu Giri -IPS. Therefore, he would be the replaced member of the special investigating team. The team will now read as follows. ಈಗ ಅದನ್ನ ಫಸ್ಟ್ ಮೇಲ್ ಹಾಕಿದಿರಲ್ಲ, ಅದರಲ್ಲಿ ಗುಲಾಬ್ ರಾವ್ ಬೊರಾಸೆ ಅವ್ರು ತೆಗೆದುಬಿಟ್ಟು ಈ ಅರುಣ್ ಗಶುಗಿರಿ ಅವ್ರನ್ನ ಹಾಕ್ಬಿಟ್ಟು ಟೀಮ್ ವಿಲ್ ರೀಡ್ ಲೈಕ್ ದಿಸ್. ದಿ ಅಬ್ಸರ್ವೇಷನ್ಸ್ ಮೇಡ್ ಹಿಯರ್ ಇನ್ ಅಬವ್ may be borne in mind by the state.
So much of it.
Take the minutes.
Hearing on 32.
Impleading proposed 32 Sunil Rao.
We have not been served a copy of the impleading, Your Lordship. Nevertheless, Your Lordship, the other applications also are to be heard along with the main
What is all
matter.
this? FSL report produced in sealed cover. Ten years, sir. 2014 matter.
Please, Your Lordship, already first round of litigation, we had succeeded. Then the supposed allottees go in division bench and say we have not been heard. So the whole thing
No, I
comes
thought by
back
mistake
again next
ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ
round of
ಇಲ್ಲಿ.
hearing. And the allottees are so overeager in this matter that deflecting from the very main issue. Simple point, Your Lordship, this is a final.
You are for the allottees or
I'm for the
landowner?
original,
Original landowners.
landowner. 1991, 1997, 1999. 3 final notifications because 91 was set aside. They came up with 1997. In 1999 again, 2 final notifications they come up with. Your Lordship, this is covered by that Adikeshavalu's judgment. Prior to Adikeshavalu's judgment, Your Lordship, Justice Srinivas Reddy's single bench order did not quash it. There were several orders where it quashed, but it quashed only as against the petitioner. But in Justice Srinivas Reddy's order, it quashed the entire final notification, which came to be confirmed by the division bench of this honorable court, and which again came to be confirmed in SLP. What happens is that BDA suppresses most of these issues, and then individually each one of us is left to fight our own battle, despite the fact that they have attained finality long back. Again, second round, Adikeshavalu's judgment, Your Lordship, Justice Kumar's judgment, ultimately went to Supreme Court. They're all pending over there, Your Lordship. Therefore, now what BDA, through the guise of supposed allottees, is attempting right now is state that I am not the erstwhile landowner. I never had my rights, and they have tried to file complaints before Seshadripuram police station. Strangely, the police within a week come up with a report stating that the signatures, we don't know whether they match. Then they say, let us have an expert to give us a report. The AC conducts a report, which this honorable court says that it will not go into it. This honorable court last time said that let us find out whether we were part of the LAC proceedings or not, which we were part of. All of these are deflecting tactics, Your Lordship. Main question is, have all these, have the final notification, has it been quashed?
Now, what is your ground of challenge?
Your Lordship, my ground is several issues. First round, when we succeeded, was the fact that even Mahazar was not all right.
Where are those orders?
Please, Your Lordship.
You may have to file a convenience compilation with
I shall do
synopsis,
that,
because
please. It's voluminous.
old matter.
I understand, Your Lordship. I
All
shall
these
file a
old matters, if you assist by filing it, we will dispose it.
Please, Your Lordship, I shall
Otherwise,
file a
ಸುಮ್ನೆ
convenience
hear ಮಾಡಿ
compilation.
ಮುಂದೆ ಹಾಕೋದ್ರಲ್ಲಿ ಏನ್ ಅರ್ಥ
We
ಇಲ್ಲ.
shall do that.
All of you file your synopsis
Please.
or a convenience compilation, any one of them, of all the orders, whatever
shall
you
do.
want.
Please.
I'll give you
We
week's
shall
time.
combine it as with a convenience compilation along with the written
No.
arguments so that
Written
both
arguments, ಆಯ್ತು, ಏನ್ ಬೇಕು ಅದು ಹಾಕಿ.
both are covered. Please.
ಯಾವಾಗ?
Any day whichever, my lords, after 2
Okay,
weeks.
tomorrow?
Please,
ನಾನ್ ready
we
ಇದ್ದೀನಿ,
shall
ನಾನ್
have
ready
it
ಇದೆ.
ready.
Ready ಇದೆಯಾ?
ನಮ್ದು
ಆಯ್ತು. Next Tuesday then. Yes.
Please.
Tuesday, please.
17th.
Please, my lords.
Obliged.
And
All the applications shall be heard along with the main matter. Post the matter on Tuesday the next.
Obliged.
please, my lords.
33.
This case, my lord, petitioner died, my lord. LR's application has been filed. And
For the reasons indicated in the affidavit accompanying the application, the legal representatives of the deceased petitioner are permitted to come on record. The petitioner shall amend the cause title accordingly, ordered accordingly.
yes, date may
Interim order ಇದೆಯಾ?
next week.
Interim order ಇದೆಯಾ? 2016 ಬರುತ್ತೆ ಅಲ್ಲ next week.
Yes.
All old matters will post.
But
34.
Yes.
But I have 1 of 25 for production of documents.
What is it? Production of documents will be heard along with the main matter.
24th, my lords.
IA 1 of 2025, a production of documents would be heard along with the main matter. Next, what is there?
Matter could be posted on 24th, my lords. All other
All applications will be heard along with the main matter. List, even deferred for consideration. IA 1 of 19, what is that?
for that vacating the interim order.
All applications would be heard along with the main matter. List on 24th.
Please.
Made clear, no further adjournment would be granted. ಯಾರು ಕೇಳ್ತಾ ಇಲ್ಲ ನಮಗೋಸ್ಕರ ಅಷ್ಟೇ.
Please.
Yes. Next.
35.
IA 1 for early hearing stands rejected. List the matter in preliminary hearing, list the matter on 24th in preliminary hearing.
You have one submission, my lord.
Hmm.
My land has been without acquisition. They are utilized by BDA.
You don't, we'll hear.
It has been admitted by a commissioner report by this court.
Admit,
He has filed a written
Admitted,
statement. Admitted.
That's
The
tight.
written statement filed by them, my lord. And a commissioner report.
24, we'll dispose it on that day.
Please.
Old matters will not adjourn. Yes,
24th, my lord.
24th.
Very well.
Great.
ಸಚಿನ್ ಅವರೇ ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕೋಂಗಿದ್ರೆ ಹಾಕ್ಬಿಡಿ.
Actives.
By then ನೀವು ಅಷ್ಟೇ.
Yes,
36.
please. ma'am.
Early hearing, rejected 24th.
37.
A small issue.
Rule issue ಆಗಿಲ್ಲ, early hearing ಏನಾಗ್ತೀರಾ ಸರ್?
Small issue.
What is all this?
ಇಲ್ಲ, last occasion.
27th ಬೇಕಾ? ನೀವಿದ್ದೀರಾ ಇದರಲ್ಲಿ?
36.
Yes, ವಿವೇಕಾನಂದ್ 24.
24th.
Yes, up to 21, 22, 24, 26 will take and then move to the next. Yes,
37.
all early hearing applications rejected.
The matter was listed and adjourned. The coordinate bench suggested that we should move an application for early hearing, though it was not a matter in which the rule is.
The rule issue agada.
I understand, my lords. We just followed the instructions of the coordinate bench and we are before the
That's
lords.
all right. I'm not on you then. Yes. No, I'm not saying that I will not, I will post it after 8 weeks. Early hearing rejected, all 24, 26th.
Lords, a very short issue, my lords. 2010 preliminary notification, 2020 final notification, 23A order, Lord, section 28, 3 and 3A is not complied with. That's all the question.
All right, we'll post it on 24th.
Please, my lords.
All these will come in preliminary hearing
Very well.
according to seniority.
I'll file a very short synopsis.
The ಹಾಕ್ಬಿಟ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ.
Very well.
Synopsis and list of authorities.
Please.
Will not waste your time and the other way around I also want.
understand,
Yes.
my lords.
Yes.
But I understand the time of the court is more precious than
No,
ours.
true,
is
but
what we
these
can
are old
guess.
matters. Why should it languish?
I understand,
Close
my
it,
lords.
yes.
Before the preliminary. 38.
Additional grounds, sir. Application in IA 1 of 25 will be heard along with the main matter.
I have sought for a mandamus because they have not.
Mandamus ಅಷ್ಟೇ.
ಹೌದು, not paying the compulsory amount.
Why,
at all.
sir?
Well, there is some other proceedings also. They have sought for instructions on that. We taken up on
List the matter on 19th. As a last chance, the council appearing for the Ajay Kumar.
Please.
Council Ajay Kumar shall secure instructions and submit on the said date as a prayer that is sought in the case at hand is only for a direction by issuance of a writ in the nature of mandamus.
Please.
To consider the representations. Yes. Next.
No, for payment of money for the land acquired.
Representation ಏನ್ ಕೇಳಿದ್ದೀರಾ ಸರ್?
That's
ತಾನೇ ಕೇಳಿರೋದು. All right. Yes.
39 adjourned. 40.
For petitioners in this matter.
2024 early hearing will reject.
Please.
Post it on 1st July.
Achha.
Yes. No early hearing, we'll take up all the matters.
Please, Your Honor, on the last occasions, it was not reached. That is why we have.
Don't worry about all that.
Please,
We'll give a date. Yes, take up all these matters. Yes. Amendment. Any objection?
For petitioner amendment.
ಒಂದು ನಿಮಿಷ sir. Amendment ಗೆ objection ಇದೆ ಪ್ರದೀಪ್ ಕುಮಾರ್.
ಅದರಲ್ಲಿ ಏನಾಗಿದೆ my lord, recently my lord, I heard that my lord, they have filed my lord writ petition challenging my lord subsequent notification. They have obtained stay. ಅದನ್ನು verify ಮಾಡಿ ಹೇಳ್ತೀನಿ sir.
ಮತ್ತೆ ಇದು
ಉಳಿಯಲ್ಲ ಅದಕ್ಕೆ
infructuous ಆಗುತ್ತೆ.
ಅದಕ್ಕೆ
Yes sir.
pass over my lord, senior.
Pass over. Yes. Thursday. Passed over to Thursday. Yes. Next.
42.
I have for direction. What direction, sir?
Lakshmi, kindly,
For the respondent
in
to this.
pursuance of the consent award, my lord, may I request, my lord, page, that is the annexure A, page at 18, mil. That is the certain extent of land, 38,000, I am the land loser, my lord. 38,332 is the.
Yes, Murugesh.
They partly they.
Take a submission. Lord, I'm placing on material to show
Yes.
that, my lord, the proceedings have been initiated, saying that, my lord, there were no grant orders itself. And the grant orders which they claim are forced. My lord, the matter is.
ಆಯ್ತು ಹೇಳಿ ಸರಿ. ಏನಿದು early hearing?
Now, your Lakshmi kindly.
Direction ಏನು? No direction.
No, your Lakshmi kindly appreciate the consent award is acted upon partly. They executed the sale deed.
Where is the consent award?
Your Lakshmi, may I request, my lord, page at 18, 18. Your Lakshmi, annexure A is the consent award. In pursuance of the consent award, they executed 8 sale deeds. Your Lakshmi, totally 13 sale deeds are executed. Remaining also, they accepted the registration, they paid the fee, registration fee, draft sale deed, and everything. There is a complaint and also allotment letter. And now
They have not executed.
they
sale.
not executed the sale. Your Lakshmi, kindly appreciate. Now recently on January, and in pursuance of our representation, I given a memo. I also brought to the notice of my learned friend, and they persuaded, they agreed. So Lakshmi, kindly, they examine all these issues. Therefore, the authority may proceed to consider the prayer of the applicant in accordance with the law after collecting the necessary fee.
Yes, Murugesh.
When such being the case, my request may be kindly be complied. My prayer for the only 2 remaining sale deed to be executed. That's all my prayer before this court.
Lord, this BMTF, Lord, has seized this, Lord, may kindly take page 2, Lord. These files have been seized by the BMTF on the ground that there is a complaint against the persons who have been granted the land, and the grants which have been issued by the revenue authorities are fraudulent. And Lord, they are examining it. Under that circumstance.
Where is the report?
Lord,
report of the BMTF.
That is with respect to survey number 9, not with survey number 8, not with
Ashok, may
respect to
kindly-
survey number
Ashok.
93.
One ನಿಮಿಷ.
Let my learned friend to.
Lord, page 2 may be taken. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ
ಸರ್ವೆ ನಂಬರ್ 8, 93, 94,
94 and 95 ಅಲ್ಲಿ ಜಮೀನಿಗೆ
Which
ಸಂಬಂಧಿಸಿದ
is the survey number that?
93, Lord, they are
ಇವರು
referring-
93 ನೇ.
We are referring to 93. They have sought for an allotment what you have made. We have already, Lord, reported to the BMTF.
Come to the prayer.
Yes.
Survey number 105/2 ಯಾವುದು? They are claiming sale deeds to be executed in survey number 105/2.
No, what they are claiming is, Lord, 105/2 is the sites where they want an allotment, where the allotment letters are issued. Not
Their claim is survey number 93?
Yes, Lord.
Where do I get that?
Lord, may kindly take page 4, Lord, first paragraph. The land bearing survey number 93 measuring to an extent of 4 acres situated in Kannalli village, Hobli, was a land granted by the government to the late Hanumaya son of late Hanumaya.
Even the note that the learned senior council relies on.
Yes, Lord.
Is
by the
survey number 93.
Yes.
Yes.
And Lord, under those circumstances, Lord, then an FIR has been.
Where is the report of the BMTF?
Lord, that BMTF report has to be yet to come, Lord.
No FIR, your Lakshmi, kindly appreciate.
You will have to produce the BMTF report.
Yes.
Crime registered, if any, stage of the proceedings in the criminal case.
No. May I request my lord for a minute? Kindly
had
page,
happened
page 97, annexure F may be kindly be appreciated.
ಈಗ
My-
ಒಂದೇ ನಿಮಿಷ.
What,
How,
what,
one, you have executed a few sale deeds in the same survey number, correct?
yes,
How did you execute them?
Lord,
Their
this-
records were perfect?
no, Lord,
The
this is,
persons in
this-
whose favor you executed sale deeds, are those records perfect?
Lord, that is what all things have been seized by the
Then
BMTF.
how did you execute those sale deeds when BMTF had seized everything?
No, Lord, that was not, before the BMTF seized. All
That's
those
what I'm
persons-
asking, a simple question.
Yes.
Were records of all those persons whose sale deeds, 13 sale deeds you executed, were correct? So you filed your objections here?
No, I'll.
No,
I'll file.
your last kindly for a minute.
Ah.
Page 97, nobody. The BDA themselves filed an application before the special court, that is a land grabbing court, for so far this survey number is concerned. 93 is not the subject matter. 93, so far the survey number, there is no allegations as such. There is no. You may request, my lord, the order of the special court that has been annexure F, page 97. The order, just I'll read, your lordship, it is not in dispute that during the course of the investigation, original records and the survey number 93 Karnataka have been seized.
What happened? Come to page 101.
Yes. Lord, after
What
this-
happened to this order?
Lord, this order, Lord, I filed an application before this honorable court in a writ petition where the criminal proceedings filed against another person have been being adjudicated. Lord, Lordship may kindly take page 103, Lord. This is a writ petition filed by Srimati Narasamma, wife of Ventesh, Lord, challenging the proceedings before the BMTF, where there is a stay order. Lord, this, the petitioner was insisting upon releasing of a compensation. Lord, I filed an application before this honorable court to take the original documents pertaining to the allotment which has already been made to him.
Produce everything.
Please, I'll.
They heard the learned counsel, learned senior counsel DL Jagdish appearing for the petitioner. The claim of the petitioners,
One.
though in the first, dispose ಮಾಡ್ತಲ್ಲ direction ಕೊಡ್ತಾರೆ. Though in the first blush appears to be innocuous, a deeper delving would reveal certain aspects to be considered while considering issuance of a direction by issuance of a writ in the nature of mandamus. The claim of the petitioners is concerning survey number 93, where 13 sites are, where 13 site sale deeds are executed while the petitioners' sites are left over without executing the sale deed. The learned counsel Murgesh Charati, appearing for the respondent, would submit that these petitioners who are before the court did not have the valid documents, as their grant itself was forged and criminal cases are pending against them.
There is an allegation of.
Allegation of forgery and criminal cases are
There is nothing.
our submission and criminal cases of forgery, alleged forgery is initiated against the petitioners or the like, as the case would be. He would submit that the learned senior counsel at that juncture would place reliance upon a note in the note sheet maintained by the office of the BDA. The note reads as follows, Flagakiran. The note is indicative of the fact that the authority is directed to proceed to consider the prior of the applicant, i.e. registration of the sale deed, after collecting necessary fees and in accordance with law. Learned counsel Murgesh Charati would also place a memo which depicts that the entire files concerning survey number 93, including the claim of these petitioners, are seized by the BMTF, and the BMTF has instituted proceedings invoking the provision, the BMTF has set the criminal law into motion. Therefore, the respondent shall file its statement of objections, enclosing every document with regard to the claim of these petitioners and how it is untenable, failing which this court would be constrained to direct execution of a sale deed as is observed by the BDA in the note quoted supra. List the matter on 26th.
Obliged.
2025 early hearing ಏನು?
That's on the
Early hearing rejected. Rule issue ಆಗಿದೆಯಾ?
But on the
ಮತ್ತೆ?
last occasion, there is a direction by this honorable court that this honorable
Able
court
to
hear
serve
the
the council, my lords, I was not able to file it yesterday.
ಏನಾಯ್ತು?
Statement is.
ಕೊಡಿ ಕಾಪಿ.
That's on the last occasion, my lords, there is a direction of this court that this court will consider the interim prayer, my lords, for granting of stay.
In the event submissions are not made.
Lords, I am ready.
ನಂದೇ ಇದು order.
Correct. Lords, I am ready, my lords, because the committee, my lords, has now initiated proceedings, my lords.
What is initiated?
My lords, the committee, my lords, that's Justice Kevshanaran committee has initiated proceedings, my lord, by issuance of a notice to me.
Where is the notice?
My lords, notice is in the last page.
Who are you?
My lords, I am a person, my lords, in respect of whom the land was not acquired in the second final notification of 2014, my lords. My lords, can I just give a prelude of the entire matter, my lords, since.
We'll post it in preliminary hearing.
Lords, on
Day
the
after tomorrow.
Please.
Post, less the matter in preliminary hearing, day after tomorrow.
My statement.
IA for early hearing stands rejected. The statement of objections filed by the respondent Ajay Kumar is taken on record.
Please.
Give it.
Quote it. Please. Great.
44.
For the fifth respondent.
I appear notes for the petitioner. So this matter, my lords, is covered by the decision, this honorable court. I have placed, my lords.
But I
order.
sought time to verify.
Covered,
Actual, it's covered, no final notification is issued. Annexure
Heard
F,
the
my lord,
learned,
page
sorry, the petitioner is before this court seeking the following prayer. This court on 3/6/2025 on hearing Sri Subramanya R. counsel appearing for the petitioners had passed the following order. The learned counsel for the respondent had sought time to seek instructions or verify whether the issue stands covered by the judgment rendered by the coordinate bench in page 37 alide. The learned counsel for the respondent submits that the issue indeed stands covered and the submission of the learned counsel for the petitioner is correct. The coordinate bench has held as follows. The coordinate benches have held as follows in that light.
Not only annexure F, not the issue.
Only annexure F.
F1,
F1,
I am not a
F
party.
matra, yes. In the light of the submission in unison, I deem it appropriate to dispose the petition by on the very same reason rendered by the coordinate bench. The same order ಮಾಡ್ಬಿಡಿ ಆಮೇಲೆ. Para 8 na repeat ಮಾಡ್ಬಿಡಿ. For the aforesaid reasons, the following order ಅಲ್ಲಿ para 8 repeat ಮಾಡಿ.
Lords, only one submission, my lords, is that in the earlier orders, my lords, what is quashed, my lords, is the preliminary notification. My lords, here, my lords, I have also sought for quashing of, my lords, section 3(1) and 1(3), my lords, for the reason that it is declared as industrial area. I will not be in a position to, my lords, develop it.
My lord, what places an embargo is only the preliminary notification.
But
He can actually take advantage of that.
ಅದ್ ಮಾಡಾದ್ಮೇಲೆ ಫಸ್ಟ್ ಕ್ವಾಶ್ ಅದ್ ಮಾಡ್ಬಿಟ್ಟು ಸೆಕೆಂಡ್ ಪ್ರೇಯರ್ ಲೇನ್ ಕ್ವಾಶಿಂಗ್ ಕೇಳಿದ್ರೆ ಅದು ಮಾಡ್ಬಿಟ್ಟು ಮಿಕ್ಕಿ ಡೈರೆಕ್ಷನ್ಸ್ ಹಂಗೆ.
Otherwise, my lords, they will ask for.
Yes, sir.
Some NOC and other things, my lords.
Only one submission. I am for respondent number 5, beneficiary. My lord, I was impleaded subsequently, my lord, that order which your lordship now followed gives liberty to me to take appropriate action against.
Same order.
I want to just make sure the amendment is carried out, my lord, because
R5
I have not been served with a.
ಅಮೆಂಡೆಡ್ ಪೆಟಿಷನ್ ಹಾಕಿದೆ. ಫಾಸ್ಟ್ ರೈಟ್ ಅಮೆಂಡ್ ಮಾಡಿದೀರಾ ಇಲ್ವಾ?
First amendment
ಮಾಡಿದ್ರೆ ಬಸ್.
Amended.
R5 ಇದರ ನೋಡ್ಬಿಡಿ ನೋಡಿ ಮೇಡಮ್.
No, even in the court file, my lords, we have done it.
Let's see, yes. ಮಾಡಿಲ್ವಾ? R5
Petition
ಕಾಸ್ಟ್ ರೈಟ್ ಅಮೆಂಡ್ ಮಾಡಿದಾರ ನೋಡಿ. ಮಾಡಿದಾರ? ಹಾ ಸರಿ. You are there.
Yes, great.
My
lord, in 45 I have filed rejoinder statement. It has not been put up. May kindly be called tomorrow along with rejoinder statement.
Rejoinder ಹಾಕಿದ್ದೀರಾ?
On 25.
My lord, may make one submission. I'm the acquiring authority. I need to file objections. I have not filed, my lord. Recently, I filed wakalat, my lord. Last week, I need, my lord.
Urgency is for me, my lord. Your lordship may kindly appreciate in this matter.
Urgency is for who are you, sir?
Sir, I am the allottee by virtue of an allotment in 2007. I am in physical possession of the allotted by a housing board.
All right.
2007 to till today, I am in physical possession. Now, after lapse of 24 years, now they question the acquisition and that this has been attained finality before division being before this honorable court. I produced them along with my objection statement. And also it is a settled position
ಈಗ
of.
ನಿಮ್ ಪೊಸಿಷನ್ ಯಾರು ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ?
Now they are surprisingly taking advantage of a third party comes in and a subsequent purchaser enters into a property and try to put up a construction. Your life may kindly.
ಅಂದ್ರೆ ಏನಿಲ್ಲ ಅಲ್ಲಿ.
It is a settled position of.
ಅಲ್ಲ ವೇಕೆಂಟ್ ಲ್ಯಾಂಡ್.
Right. It is a settled position of law that the subsequent purchaser has no legal right. So far as the position of law is concerned. And then I place a judgment, they are divided.
That I am aware, sir.
That's why my submission will not be kindly vacate, they suppress all these facts. The vendor of the present contesting petitioner filed a writ petition before this court, that has been dismissed.
You are the purchaser.
Yes.
I am the purchaser.
Lord,
My lord, I have produced certain documents along with rege and
Lord, what
statement.
1993, my lord, was the final notification.
My lord, my submission is let
one
my
nimsha,
document be taken on record.
We'll take it.
Tomorrow I will argue the matter.
We'll take it, yes.
Lord, 1993 was the final notification. Lord, after my lord form, my lord, acquisition of the land by my lord, the housing board, we have formed layout, my lord, my lord, the sites have been allotted, my lord, in favor of the private respondent hearing. This my lord site, my lord, said to have purchased by my lord the petitioner hearing before my lord the acquisition proceedings.
Before the acquisition.
Before acquisition proceedings came before this court, my lord, after lapse of 23 years. ಅವ್ರಿಗೆ ತೊಂದ್ರೆ is genuine alati, is genuine alati ಅವ್ರಿಗೆ ತೊಂದ್ರೆ.
ಅವ್ರೇನ್ ರಿಜೈಂಡರ್ ಹಾಕಿದಾರಂತ.
ಹಾಕಿದ್ದಾರೆ.
Let them all already filed.
Already filed. Tomorrow it may be called. My lord.
List the matter on 17th. In
20th, but any other day except 17th.
19th.
ಅಲ್ಲ ಸ್ಟೇಟಸ್ ಕೋ ಮಾಡಿ ಅದರಲ್ಲಿ
ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಈಗ ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಟ್ಬಿಟ್ಟಿದಾರಲ್ಲ ಸರ್. ಬಟ್ ಅದನ್ನ ಮಾಡಿಫೈ ಮಾಡಿ. ಇಫ್ ಯು ಆರ್ ಇನ್ ಪೊಸಿಷನ್
ಅಲ್ಲ
ಸ್ಟೇಟಸ್ ಕೋ
ಹಂಗಾರೆ ಇರಿ, ನೀವು ಪೊಸಿಷನ್ ಇದ್ದೀರಾ?
ನಾವಿದ್ದೀವಿ.
ಒಂದ್ ನಿಮಿಷ ಪೂರ್ತಿ ಕೇಳ್ಬಿಡಿ. ನೀವು ಪೊಸಿಷನ್ ಇದ್ದೀರಾ? ನೀವು ಪೊಸಿಷನ್ ಇದ್ದೀರಾ? ಪಾರ್ಟೀಸ್ ಟು ಮೇಂಟೈನ್ ಸ್ಟೇಟಸ್ ಕೋ ಟಿಲ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. This is in addition to the order that is already passed. Yes.
19th.
19th.
ಇನ್ನು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ
ಆಯ್ತು, ಹೆಂಗೂ ಆಗಿದೆಯಲ್ಲ. List on 26th. Objections if any by the housing board by then.
ಪ್ಲೀಸ್.
ನೀವು ಅಷ್ಟ್ರಲ್ಲಿ ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಪಾಸ್ ಆರ್ಡರ್ಸ್ then.
P group 46.
2012.
Yes.
Yes, sir. Early petitioners.
Challenge the notification. Like last occasion also did not come. 2 days time may be granted to file my statement of objection. It's ready, madam.
Statement of objections. 13 ವರ್ಷ ಆದ್ಮೇಲೆ.
List of.
List of.
ಮತ್ತೆ ಲಿಸ್ಟ್
No, sir.
ಬಹಳ ವರ್ಷದ ನಂತರ ಲಿಸ್ಟ್ ಆಗಿದೆ.
Will impose exemplary costs and then permit. This is not correct. 13 ವರ್ಷ ಬೇಕು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಕ್ಕೆ. ಯಾರಿದು ಹುಡಾನ?
ಇಲ್ಲ, ಹೌಸಿಂಗ್
ಹೌಸಿಂಗ್ ಬೋರ್ಡ್. ಇವ್ರು ಬೇರೆ ಬರೋದೇ ಇಲ್ವಲ್ಲ.
2013 ಲಾಸ್ಟ್ ಟೈಮ್ ಲಿಸ್ಟ್ ಆಗಿದೆ ಮಾತ್ರ.
ಆಮೇಲೆ ಆಗೇ ಇಲ್ವಾ?
ಇಲ್ಲ ಸರ್.
Seriously? Await the outcome of a writ appeal procedure. ಏನದು?
ಆ ಸ್ಕೀಮ್ ಒಂದು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು. ನಾವು ದ ಸ್ಕೀಮ್ ಇಸ್ ಬಿನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಸ್ ಗಿವನ್ ಸ್ಕೀಮ್ ಇಸ್
ಅಲ್ಲ, ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು ಅಂತ ನೆನಪೇ ಬರಲ್ವಾ?
ಅಪಾಲಜಿ, ಐ ಶಲ್ ಡು ಇಟ್.
The subject petition was for the first time listed on 5/2/2013. At that point in time, an identical question was before the division bench in writ appeal 5697 of 2012. Dispose agilva?
Dispose agilva.
2012. The writ appeal, the respondent shall secure instructions as to what has become of the writ appeal so mentioned on 5/2/2013, 12 years ago. The learned counsel for the board, housing board, submits that after the said date, the matter had appeared only on 3/6/2025, and therefore the objections are ready and would be filed in the next 2 days.
Yes.
In the next 2 days. Since the matter is of 2012, 2 days time in the peculiar facts is granted to the respondent housing board to file statement of objections. List the matter next Tuesday, 17th. There is no representation on behalf of the petitioner In the event there would be no representation on behalf of the petitioner, the petition would be dismissed for its non-prosecution. Yes, next.
47.
Appeal for petition.
Respondent.
That's on 20th February 2013.
47.
This honorable court had granted stay and directed to list this matter after writ appeal 5697. of
Same
2000.
same order. ಏನಾಗಿದೆ writ appeal?
It is dismissed.
ಕೊಡಿ.
Be fair.
ಅದರಲ್ಲಿ ಮೇಡಮ್ ಹಿಂದೆ ಇದರಲ್ಲಿ the writ appeal is said to have been dismissed in terms of the order of the division bench. ಈಗ 12th December 2024.
Please.
12th December 2024, along with all connected writ appeals.
My lords, in the said order, my lords, the special leave petition number is wrongly typed and I have
SLP
written.
pending ಇದೆಯಾ?
SLP is covered by.
SLP is also dismissed. The ಇದನ್ನ ನೀವು ನೋಡ್ಕೋಬೇಕು.
ಅದರಲ್ಲಿ SLP ನಂಬರ್ ತಪ್ಪಾಗಿದೆ ಸ್ವಾಮಿ. You have filed correction.
ಆಯ್ತು, anyway, Supreme Court has dismissed it. The council appearing.
Supreme Court has allowed my lord the appeal filed by my lord the housing board.
And sent it back, is it?
No. It is, my lord, the issue involved was.
Where is the order of the apex court? The parties to the list to place on record the order passed by the apex court, since the matter is of the year 2012, list the matter day after tomorrow. Yes. ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಏನಿದೆ ಎಲ್ಲ. Next. 48.
48.
Yes, Vachan.
Nadaprabhu Kempegowda layout. Acquisition has been upheld.
Yes, ma'am. Acquisition has been
Covered.
upheld, but there's some directions has been issued in that.
The representation ಕೊಡಕ್ಕೆ.
Representation. That may be, same may be.
It is only for site only.
ಇವರೇನು?
No, I have got 11 guntas of land.
I will submit a representation.
Same, I will
consider
submit the
it.
representation.
Page number 304, may I have seen.
Same representation has been permitted.
Orally,
With regard to landowners excluding site owners.
Including site owners, if my lord, they were to claim, my lords, that they are part of nursery lands situated within green belt, totally built up area, religious and charitable institutions. Similarly, adjoining lands have been denotified. If that is there. Here, my lords, no such grounds have been urged.
I have 11 guntas of land.
Any of his grievance, if he wants to represent, let him represent.
I will represent.
You consider it in accordance with law and close it.
Another facet, my lord, in this case may kindly be considered. The CDP road, my lord, which is running to the said lands. I produced it along with my objections. I filed it in the morning. So the CDP road, my lords, anyhow will have to be formed. My lords, that will have to be taken into consideration, my lords. This they might.
You
simply not square it.
reject it, sir.
Please.
Yes. The petitioner is before this court.
I filed my objections in the morning in the office.
Before this court seeking the following prayer. The learned counsel B. Vachan appearing for the BDA files a statement of objection, same as taken on record. The learned counsel for the petitioner submits that the acquisition for Nadaprabhu Kempegowda layout has been affirmed with certain directions. The directions so issued are found at page 3052. Madam, 3052, 310 idರಲ್ಲಿ. The directions are as follows. The learned counsel for the petitioner submits that the petition be disposed with liberty to submit a representation as is reserved by the division bench in the aforesaid judgment. In the event he would stand covered by the directions so issued. Counsel B. Vachan would seek to submit that the petitioner cannot be declared to be beneficiary of even submission of a representation, as he is the site owner. He is not a site owner. And what lands are his?
11 guntas of land is there.
Yes.
11 guntas of land.
Is not a site owner, be that as it may. I deem it appropriate to dispose the petition in the light of the acquisition being upheld by the division bench in so and so, reserving liberty to the petitioner to submit a representation venting out his grievance, if any. If a representation is submitted, it is needless to observe that the BDA would consider the same in accordance with law and pass necessary orders and communicate the orders so passed to the petitioner. With the aforesaid observations, the petition stands disposed.
49.
Same, the petition, same, my lord, the
Same,
covered by
huh?
judgment, yes, this is the covered by judgment, and is the revenue side holder. The land was.
Same order.
Yes.
ಅದೇ ಕೋಟ್ ಮಾಡಿ ಸೇಮ್ ಆರ್ಡರ್. ಯಾರು ಇದರಲ್ಲಿ ರವೀಂದ್ರ HT?
AD Vijayas, he was in, not in
ಅಲ್ಲ
panel.
ರವೀಂದ್ರ ಅಲ್ಲ, ಯಾರದು? ಸಾರಿ,
AD
AD ವಿಜಯ ಅವ್ರಿಲ್ವಾ?
ಅವ್ರಿಲ್ಲ.
ನೀವೇ ತಗೊಂಡ್ಬಿಡಿ ನೋಟಿಸ್. Counsel for the petitioner submits AD Vijaya, who was directed to accept notice for R2 and R3 is not in the panel. Therefore, B Vachan is directed to accept notice for respondent 2 and 3 BDA. So same order matter. Covered ಅಂತ ಅವರೇ ಹೇಳ್ತಿದ್ದಾರೆ.
She was a revenue side holder.
Copy
Same
ಕೊಡಿ.
was acquisition, I will challenge the.
ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ
House of Nalapur. ಇಲ್ಲ.
ನೋಡಿ ಬೇಕಾದ್ರೆ ಏನಾರು ಇದ್ರೆ ನಂಗೆ ರೀಕಾಲ್ ಮಾಡಕ್ ಹೇಳಿ. ಜಸ್ಟ್ ಲುಕ್ ಪೇಪರ್ಸ್ ಕೊಡಿ ಒಂದು ಈಗಲೇ ಕೊಡಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್
50.
Last occasion, when the matter was heard, the housing board advocate submitted that they have formed the layout and they have produced the plan and things.
ಏನ್ ಹೇಳಿ?
This is.
We have filed the memo is filed along with certain documents showing that in the acquired lands, the lands have been utilized.
Who are the petitioners?
Landowners.
Landowners.
Whose lands have been acquired.
By the housing board.
Housing.
Yes, sir. What do you want then?
Your Lordship will kindly see, the preliminary notification was issued for acquisition of 1,103 acres and 37 guntas. When the final notification, it comes only 350 acres.
What happened to the remaining?
The remaining, they have not notified in the final notification.
Yes, sir.
And when we have filed, they have pick and choose our objections. They have left the.
In fact, my lord, on 4.
Your lands come within those 650 acres left out?
This comes, my lands comes within 350 acres.
Within
That
350
belongs
acres
to
that is now
Chunchukubere.
notified.
Yes.
The reason for, my lord, reducing the extent in the final notification is that we had in fact not formed the scheme in this 1,100 acres. The government approved, my lord, the scheme only in respect of 400 acres. That is how, my lord, the final notification has been issued. And in fact, my lord, this honorable court directed us to file an affidavit explaining what are the circumstances under which the extent of the land was reduced to 350 acres. And my lord, on 29 January 29th January 2024, my lord, we have filed an affidavit explaining, my lord, the circumstances.
Where is the direction of the court? On 4/1/24?
4/1/2024, my lords. 4/1/2024.
Implementation begins.
ಇದೇ ಹೊತ್ತಾಗಿದ್ದು.
All right, what is your grievance now?
Your Lordship will kindly see, when I have filed the objections for preliminary notification.
They have not considered it.
They have not considered, but the very same objections was raised by the other persons, they have accepted. That I have produced under annexure C1, C2, C3.
Objections B1, is it?
C1, C2, C3. Yeah. Our petitioner's objections were overruled, but similar objections was raised by the other landowners has been accepted and their proceedings were dropped.
Yes, sir. That's the allegation.
Yes.
My lord, Lordship may kindly see, my lord, those, my lord, lands, my lord, came within the parameters fixed by, my lord, the board for acquisition, and that is how they were, my lord, in fact excluded from acquisition. But in the case of petitioner, only in respect of one land, there is a conversion order.
Where is the consideration of his objections?
Objections ಇಲ್ಲ. ನಮ್ಮ
Inquiry.
ಇಲ್ಲಿದೆ.
2014 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ. ಎಸ್ ಸರ್.
ಎಲ್ಲಿ ಬರುತ್ತೆ? It is part of Lord writ petition. I may be permitted to refer to this 5A report.
Where is the consideration of the objection?
Consideration 5A report is.
They have not considered my
Page
objection.
49.
Page
49. 49 ಅಲ್ಲ 50 ಇಂದ ಇದೆ. 50 ಅಲ್ಲಿ
consideration.
Annexure C, my lord. It is annexure C. Serial number is
ಎಲ್ಲಿದೆ ಇಷ್ಟೇನಾ?
part of the 5A report is filed.
No, no. You see the objections. Where is the consideration of the objections?
Yes.
Survey number 24, 25B, 5B, 25, 5B ಇದು. ಆಮೇಲೆ 20.
ಎಲ್ಲಿ ಬರ್ತದೆ?
ಎಲ್ಲ 10 ವರ್ಷ ಆದ್ರೆ ಹಿಂಗೆ ನೀವು ಎಲ್ಲೋ ಇಟ್ಟಿರ್ತೀರ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಇದೆ ಆಕ್ಷೇಪಣೆದಾರರು ಸಲ್ಲಿಸಿರುವ ಆಕ್ಷೇಪಣೆ ವಿವರ ಅಂತ ಇದೆ ಸ್ವಾಮಿ. ಸೀರಿಯಲ್ ನಂಬರ್ ಬಂದು consideration is like this now.
C1, C2, C3 have dropped considering those landowners.
Yes, yes.
He has contended that he is similarly placed. ನನಗೆ objection ಇಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲ in fact my lord,
There are detailed objections filed.
it is considered my lord.
Where sir?
And
Not in this fashion. Where is it considered?
consideration is here my lord.
ಅದೇ ಇಲ್ಲಿರೋದು page 50 ಇಂದ.
ಅದೇ 15 ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್
ಅದ್ರಲ್ಲಿ ಫುಲ್ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ ಅವ್ರಿಗೆ ಸಂಬಂಧ.
ಎಲ್ಲಿದೆ ಫುಲ್ ಕೊಡಿ.
ಇಲ್ಲಿ
ತೊಳೆದ್ ಮಾಡಿ. Objections ಹಾಕಿಲ್ವಾ?
Objections
ಜೊತೆ ಹಾಕಿಲ್ವಾ ಇದು?
objections ಜೊತೆಗೆ ಹಾಕಿಲ್ಲ.
Objections.
The same thing.
Survey numbers my lord 25/5B, 24,
25/5B.
5B, 24.
That is the petitioner.
25/2. Lords, then 25/4A.
ಆಕ್ಷೇಪಣೆಗಳ ಬಗ್ಗೆ ಭೂಸ್ವಾಧೀನ ಕೇಳುವ ಅಧಿಕಾರಿಗಳ ಶರ. ಭೂಸ್ವಾಧೀನ ಅಧಿಕಾರಿಯು ಮಾಡಿರುವ ಶಿಫಾರಸ್.
ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ ಸರ್, ಡಿಟೇಲ್ ಆಗಿನೇ ಬರೆದಿದ್ದಾರೆ.
ಅವ್ರದ್ದು ಯಾಕೆ ಬಿಟ್ರಿ? C1, C2, C3.
Yes, my lord, we have explained. By filing my lord the statement of consideration of the objections filed in respect of lands that were excluded, it is my lord part of my lord our affidavit at annexure R4. Page number 15 of the affidavit paper.
What is the present position?
Present position, my lords may kindly see this memo that we have filed on 11th March, my lords. Pursuant to the honorable court's direction dated 21/2/2025.
Again compensation ಕೊಟ್ಟಿದ್ದೀರಾ?
Compensation ಇದು award ಮಾಡಿದೀವಿ, deposit ಮಾಡಿದೀವಿ.
What memo is this?
Memo, my lord, in fact, on 21/2/2025, the honorable court directed us to
Correct.
place the records.
11/3/2025 you have filed a memo.
Yes, yes.
What is that?
That is not the award part.
Award approval.
Award copy of the letter.
Depositing the award list of allottees.
List of allottees and notification dated 3/2/2025.
No, what have you done in this sites form ಮಾಡಿದ್ದೀರಾ?
ಇದರಲ್ಲಿ
ಇಲ್ಲ ಸೈಟ್ಸ್ ಇನ್ನೂ ಆಗಿಲ್ಲ.
ಏನು interim order ಇದ್ದಾಗಿದೆ.
ಇಲ್ಲ
ಏನು ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ. I have filed the writ petition and obtained an order of interim order. It is even today it is in force.
11 ವರ್ಷದಿಂದ interim order.
Honorable court wanted to know whether the scheme is implemented in the acquired lands. And Lord, in In response to the direction, Lord, we have filed this affidavit, not showing that the scheme has been not only implemented, allotments have also been made. Lord, in respect of these lands, the litigation is.
ಎಷ್ಟು ಲ್ಯಾಂಡ್ ನಿಮ್ದು?
ನಮ್ದು ಇಲ್ಲಿ ಫಸ್ಟ್ ಪೆಟಿಷನರ್ ಸರ್ವೆ ನಂಬರ್ 25/5B ನಲ್ಲಿ 15ವರೆಗೆ ಉಂಟು.
15ವರೆಗೆ ಉಂಟು.
ಹೌದು. ನೆಕ್ಸ್ಟ್ ಸರ್ವೆ ನಂಬರ್ 24 ನಲ್ಲಿ 2 acres 32 ಗುಂಟಾಸ್.
ಅಲ್ಲ ಫಸ್ಟ್ ಪೆಟಿಷನರ್ ಎಷ್ಟು?
ಫಸ್ಟ್ ಪೆಟಿಷನರ್ 15ವರೆಗೆ ಉಂಟು. ಅದೇ ಸೀರಿಯಲ್ ನಲ್ಲಿ ಐ ಹ್ಯಾವ್ ಮೇಡ್ ಎ ನೋಟ್ಸ್. ಪ್ಲೀಸ್
ಎಲ್ಲಿದೆ?
ಇಲ್ಲೇ ನಾನು
ನಿಮ್ ಕೈಲಿ
ನನ್ನ ಕಡೆ ಇದೆ. ಸಾರಿ, ಐ ವಿಲ್ ಸಬ್ಮಿಟ್.
ಒಂದು ಪೂರ್ತಿ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿ.
ಹಾಕ್ತೀನಿ.
ಆಲ್ ದಿ ಯಾರ್ಯಾರ್ದು ಏನೇನಾಗಿದೆ
ಪ್ಲೀಸ್
ಪ್ಲಸ್
ಹಾಕ್ತೀನಿ.
ದಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಂಡ್ ಯು ಆಲ್ಸೋ ವಾಟ್ ಹಸ್ ಹ್ಯಾಪನ್. ಪ್ರದೀಪ್ ವಿಲ್ ಗ್ರಾಂಟ್ ಯು ಟೈಮ್ ಟಿಲ್ 24th. ಲಿಸ್ಟ್ ಆನ್ 24th. ಅಷ್ಟರಲ್ಲಿ ಹಾಕಬೇಕು. ದಟ್ ಐ ವಿಲ್ ಡಿಸ್ಪೋಸ್ ಇಟ್.
ಪ್ಲೀಸ್.
ಎಸ್ heard so and so list on 24th. Entry mode absolute ಇದೆಯಾ?
Absolute ಇತ್ತು.
ಅಲ್ಲ ಐತೆ.
ಹೌದು ಇದೆ.
Absolute, yes, fine. Next.
51.
I appeal for the petitioner, as the matter may be taken up day after.
Sorry?
The matter may be taken up day after.
2014.
We'll address our arguments without fail. We'll address our arguments without fail.
Mic, take the mic.
We'll address our arguments without fail.
You will address the arguments. Yes. You will not grant time.
Please.
Now. Yes. Any matter? Nadit Baker. Let's day after tomorrow.
For petitioners, this matter pertains to Akkavati layout. What
Acquisition is upheld.
Please, my lord, say here the issue is, my lord, an extent of 25 guntas has been dropped. Lord, the dispute rises, my lord, whose land has been dropped. The private respondents and the petitioner both have been given an endorsement saying that, my lord, 25 guntas has been dropped. Lord, the private respondents herein, my lord, sir.
Yes, sir.
My lord, there are the 25 guntas of lands are deleted, my lord. Now the
Yaar, you are the respondent.
that is the dispute, my lord.
Who will resolve the dispute? Court? You want court to resolve?
Now, subsequent, I filed the affidavit, my lord.
Whose land is dropped on the affidavit?
In that, my lord, it is said that respondent's land was this.
Why they did not come and see you?
No, my lord, we have produced the
In the
sketch.
sense BDA.
Sketch also produced in the along with the affidavit, my lord, at page 13.
ಯಾರ್ದು ಅಂತ ಗೊತ್ತಿಲ್ಲದೆ ಆಂಬಿಗ್ಯೂಸ್ ಆಗಿ ಇಡೋದು, ಆಮೇಲೆ ಇವೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಮಾಡಿ.
ಅಲ್ಲ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಯುವರ್ ಲ್ಯಾಂಡ್ ಎಕ್ವೈರ್ ಆಗಿದೆ.
ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ಯಾರ್ ಲ್ಯಾಂಡ್ ಡ್ರಾಪ್ ಆಗಿದೆ ಅಂತ. ಏನ್ ಡ್ರಾಪ್ ಮಾಡಿದ್ರಿ?
My lord, he is subsequent purchase from the notified khatedars.
When was the purchase?
My lord, he purchased, my lord, the
in the 2005, after, my lord, they issued a
preliminary notification.
After, my lord, in the 2004 final notification, my vendor's name was not available.
And you have no right.
No, my lord,
acquisition is upheld.
No, my lord,
Drop ಮಾಡಿದ್ರೆ ಮಾತ್ರ problem arises.
Lord, sir, I am not challenging the accusations.
One more submission, my lord. Even the deleted land, as per the judgment of this honorable court, my lord, they referred to the committee where this honorable court directed even the deleted land has to be scrutinized by the committee, whether that deleted land comes under the.
Lord, sir, committee, my lord, now we approach the honorable committee.
Go before the committee.
No, my lord, we approach the honorable committee, my lord. Honorable committee considered and said, my lord, because of this writ petition,
we will dispose the petition. We will not clear the impediment.
No, my lord, there is a issue, my lord. Lordship, it is not an aspect of, my lord, the accusation. I am not challenging the accusation. Lord, sir, these facts are but little.
Bench single judge.
Single judge.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಹೇಳಿ?
My lord, kindly the
The committee shall also, ಇದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಆಗಿಲ್ವಾ ಇದು?
It was also confirmed.
Single runner single judge constituted committee, my lord. Page, my lord, 741, my lord. My lord,
you have not gone before the committee?
I am before the committee, my lord.
ಎಲ್ಲಿ ಇದು deleted lands ಎಲ್ಲಿದೆ?
My lord,
observation.
Page 741. ಅದರಲ್ಲಿ Roman number 14, my lord. All the deleted or denotification recommended by the BDA or made by the BDA or by the government is subject to the certification or approval by the committee to the effect that such deletion of land is in accordance with the law laid down by the division bench of this and decision or clarification
issued by the apex court in Bondu Ramaswamy's case. And my lord, in the page 743, my lord, the Roman number, the E, my lord,
E. How E?
my lord,
All E, my lord.
page 748, my lord, sorry. E, my lord, the committee shall examine as to whether deletion of the lands from acquisition made by the BDA is within the parameter fixed by the division bench of, and Bandaramaswamy case by examining every such deletion made on case-to-case basis, and particularly with the reference to the deletion made.
Now what has happened before the pending ide anta madilva?
ಇಲ್ಲ my lord, these facts are little different, my lord.
What facts are different?
I may be permitted, my 2 minutes, not.
What facts are different?
Facts, my lord, is my lord's,
First thing is you are a subsequent purchaser, no doubt about it.
No, my lord, that's I will clarify, my lord. What is
not?
No, my lord, I am the subsequent purchaser. My lord, the preliminary notification, my lord, kindly take my lord, second writ petition 7038. My lord, the preliminary notification, my lord, say, my lord, we alleged a fraud on the BDA and the private respondent.
Fraud on the BDA?
Please, my lord, lordship may kindly appreciate. Annexure A, my lord, is the preliminary notification. My lord's page 19, my lord, is the relevant portion. Page 19, my lord. Serial number 47.
What is this order, Justice Krishna Kumar?
Please, my lord.
What is this order in D. Raman Kumar?
Please, my lord. So, my lord, my petition was disposed with the batch of petition what lordship has read now. My lord, I filed a review petition because my case stands different from the what is disposed. The review petition was allowed and this petition was restored. My lord.
Oh, this petition itself.
Please, my lord, this petition was restored. My lord, it's a case wherein, my lord, my lord, we alleged a fraud. My lordship will also try to demonstrate. Annexure A, my lord, is a preliminary notification. Page 1717, my lord. The survey number is 33.
File your synopsis.
Please, my lord.
Synopsis, list of authorities, everything.
Please,
yes. The petitioner shall file a detailed synopsis of his submissions, dates and events, and also the list of authorities by the next date.
Please.
List on 24th.
Please.
ಅವತ್ತು ಇಲ್ಲಿ ತಂದು ಕೊಡಬೇಡಿ, ಮುಂಚೆನೆ ಹಾಕಿ. Yes.
53.
Respondents in this matter.
Sanction of scheme challenge. Sanction of scheme challenge.
No representation. We have the petitioner list on as a last chance list on 1st July.
Along with that.
In covered.
Along with that previous serial number is ಅದೇ ತರನೇ
ಬಂದೇ ಇಲ್ವಾ?
Hebar 47 Thursday.
ನಿಮಿಷ.
The grounds
it's different. Different. This is
no representation. We have the petitioners. No representation. The counsel for the petition. There is no representation. We have the petitioners. A perusal at the order sheet would indicate that the counsel for the petitioner has been continuously absent. Therefore, as a last chance, list the matter on 24th. In the event of no representation, the petition would be dismissed for its non-prosecution.
One more submission, my lords. In serial number 46, my name may be shown, my lords. My senior's name will be shown. 46, S.A. Sudhindra.
Vasant Kumar Tagivar.
Alla, Ashwath.
Registry to delete the name of S.N. Ashwath Narayan.
Been designated.
And print the name of
Sudhindra S.A.
Sudhindra
S.A.
S.V. S.A. All right, yes. Next.
Obliged.
54 until 55.
Pass over.
Please, Mr.
Passed over to day after tomorrow.
My lords,
Urgency.
just hear it, my lords. It's short matter only. If you can have it.
Pass over. Next.
66.
That's day after tomorrow.
Pass over. Yes. Yes, Basuraj.
56.
1st July. No representation. We have the petition.
57.
So everyone will try.
56, lords. I have day after tomorrow. Covered.
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 List on 20 next Thursday. 57.
Lord, in this case,
12th Thursday. Yes, Aruna Batra.
7.
My lord, in this case, the matter pertains to, my lord, challenging endorsements. 3 endorsements, my lord, by which my request for allotment of incentive site, my lord, has been rejected.
Incentive.
Yes, my lord.
My lord, this is the equation, my lord, the year 77, 78. Incentive site rules came into force in the year 1989, my lord. And the incentives are not in the scheme of the is 77.
Retrospective application idea.
Lord, in fact,
Scheme.
even that issue is also not considered by, under the respondent, I mean, endorsements. My lord, this honorable court, my lord, in an identical circumstance, my lord, can I just pass on? Lord, please be kind enough to see, my lord, this paragraph 4.
Incentive scheme has been rejected.
Paragraph 4 onwards. My lord.
ಈಗ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದಾರಲ್ಲ ಅದನ್ನ.
My lord, they have not said so. Lord, please have a look at the endorsement.
Want me to remit the matter back? We'll remit.
Very well.
Same order will pass. Yes, Krishna.
My lord, page 83, my lord. That is one of the endorsement they have.
83.
Sorry, and that is the, my lord, the badal innovation is not permissible. And
We'll send it back.
My lord, one more thing, my lord. Is the person, from the person to whom the petitioner purchased the land, my lord. Sorry, the petitioner claims under the one Pratap Singh, my lord. The land tribunal said that Pratap Singh is the brother son of the original landowner. And the land tribunal granted the occupancy right to some other person.
ಅದೆಲ್ಲ ಇದರಲ್ಲಿ ಇಲ್ಲ. Whatever you want to say, you say.
I have filed in the statement of objection.
Petitioner is before this court seeking the following prayer heard so and so. Facts in brief, Germain, are as follows. The petitioner claims to be the purchaser of the subject property in the year 1967.
My lord, that is the grandfather of the petitioner. He purchased initially.
The grandfather of the father of the petitioner is said to have purchased the subject property on 23/8/1967. The
Lord, can I just pass on the synopsis?
No, could better. Good. Heard so. The petitioner claims to be the daughter of one late Pratap Singh, son of late Ram Singh and late Lakshmi Bai. It transpires that late Ram Singh had purchased 1 acre 7 guntas of land.
My lord, here one submission.
On facts,
facts, Ram Singh, there are the two names are similar. One the petitioner.
I am not deciding anything on merits, sir. Late Ram Singh purchased 1 acre 7 gunta, is said to have purchased 1 acre 7 guntas of land in survey number 25/5 of so and synopsis number 2 only the madam. Ram Singh passes away, leaving behind the wife and 2 sons. All the 3 then pass away. The subject land is said to have become the subject matter of acquisition by issuance of preliminary notification on 3/1/1977, after which on 2/8/1978 a final notification comes to be issued and the award is passed on 12/9/1986. The BDA is said to have taken possession of the land on 6/10/1986. The claim of the petitioner is that the BDA had resolved to give one alternate site per acre of those landowners who come forward to hand over the land without any hurdles at the time of acquisition. This resolution of the BDA resulted in formulation of a scheme in the year 1989. The representation is submitted by the petitioner claiming that he was entitled to entitled to an alternate site under the incentive scheme. The said representation has resulted in endorsements which are challenged in the subject petition. The learned counsel, Sri Subramanya Bhatt, appearing for the petitioner, would seek to place reliance upon the judgment rendered by the coordinate bench interpreting the scheme, i.e. the scheme interpreting, madam, judgmentally, interpreting the so-and-so scheme. The learned judge has held as follows. Quote the entire para 2 in the para 5. The case was, according to the learned counsel for the petitioner, the issue in the list stands on the same footing as is considered by the learned single judge in the aforesaid writ petition. The learned counsel appearing for the BDA K. Krishna would, however, dispute the position contending that the endorsements are issued also considering the fact whether the scheme would be applicable with retrospective effect for the lands that have been voluntarily surrendered prior to the coming into force of the scheme. The perusal at the endorsement would not indicate any such consideration at the hands of the BDA. In the light of the order passed by the by the learned single judge quoted supra, the matter, the representation of the petitioner would require a fresh consideration at the hands of the BDA, bearing in mind the order passed by the coordinate bench by the learned single judge quoted supra. In that light, I deem it appropriate to dispose the petition with a direction to the respondent BDA to consider the representation in terms of what is held by the coordinate bench in quoted supra and pass necessary orders in accordance with law. It is made clear that this court has not pronounced or considered the case of the petitioner on its merit for entitlement of an incentive scheme. Ordered accordingly.
Great.
The representation shall merit consideration within 12 weeks from the date of receipt of the copy of this order, and the decision taken on such representation be communicated to the petitioner.
Great.
Ordered accordingly.
58.
This is pertaining to the Nadaprabhu Kempegowda layout. Similarly,
So what is the present status? If the matter.
Present status ಎಲ್ಲ ಹೋಗಿದೆ.
We don't know. Milords.
Supreme Court confirm
I
ಮಾಡಾಗಿದೆ.
understand, Milords, it's confirmed, but present status of the property there, I don't know what they have done.
Now your lordship passed the order, where the landowner is concerned, my lord.
ಅದೇ representation ಇದೆ.
Representation.
ಎಲ್ಲದರಲ್ಲೂ ಅದೇ ಮಾಡ್ತಾರೆ. Heard the learned counsel appearing for the petitioner. Heard the learned senior counsel, Sri D.R. Ravi Shankar, appearing for the petitioner. The subject acquisition that is called in question pertains to Nadaprabhu Kempegowda layout. The division bench, while considering the challenge to the said acquisition, has upheld the acquisition while issuing certain directions. The directions so issued by the division bench is as follows. In the light of the directions, the petitioners are also reserved liberty to submit representations to the BDA, and the BDA shall consider the same as is directed by the division bench within the time frame fixed by the division bench, which would run from the date of receipt of a copy of this order. Ordered accordingly.
Please.
Yes.
59.
ಇದು ಇಟ್ಕೊಂಡಿರಿ.
Petition this case, they are challenging the order of the Commissioner BDA in Annexure P, wherein the request of the petitioner seeking for alternative site in utilization of 3 sites by the BDA is rejected by stating that the reconveyance scheme ali kodak baralla anta. We are
Objections ಹಾಕಿದ್ದೀರಾ?
please, madam, they have filed objections.
ಹಾಕಿದ್ದೀರಿ. Yes.
Next times.
Why?
Seniors
ಯಾರು ನಿಮ್ಮ senior?
engage ಆಗಿದ್ದಾರೆ.
ಪ್ರದೀಪ್ ಕುಮಾರ.
My lord, the Krishna.
Unnikrishnan.
Respondent.
59.
59, yes. At the request of the council appearing for the respondent as a last chance, list the matter on 19th. Yes.
Okay.
On the same stage.
60.
Number 16, my lords. We have given an NOC wakalat in the first week of May, my lords. For the
First week of
petitioner.
May.
Please, my lords.
I object for any adjournment. my lord.
Object, madam.
Since from 2012, this matter is going on, my lord.
Lords, this matter, my lords, I have filed my wakalat this morning for the petitioner, my lords. Lords, I
Lords,
seek
I'm
for a
appearing
short-
for.
One moment.
I'm appearing for BDA, my lords. I pray for a week's time to file my objections, my lord.
You are appealing for the BDA.
Me, my lord. I'm sorry.
Lords, I am
One moment, one moment.
Disposed of. These are taken.
What happened to the suits
Suits have been dismissed, my lord.
filed by the petitioner?
Yes, my lord.
Yes. The learned counsel appearing for the petitioner submits that he has entered appearance only today. As a last chance, list the matter on 17th. In the event no submissions would be made, the petition would be dismissed for its non-prosecution. Yes.
The interim order sustaining may be extended.
Interim order subsisting will continue subject to the aforesaid condition. Madam Sak will continue it to that. Please, madam. Anybody wanting time, madam? Anybody wanting time except in further hearing could.
ಲಿಸ್ಟ್ ನಂಬರ್ 230 ಕರೀತೀರಾ 230ಗಾ
Madam, serial number 75, list 1, madam.
It's not taken up, ma'am.
Yes, I mean, time, if I want time.
Madam, ನಾನಿದ್ದೇನೆ. I'm for petitioner.
Which
75.
adjournment?
75. ಅವರು ಇಲ್ಲ ನಂಗೆ adjournment ಬೇಡ. I'm objecting.
ಬೇಡ.
Objecting.
Madam, second list to first.
I
Madam,
yes, I need time in, I mean, serial number 75.
it's still not called.
Okay, okay, fine, fine.
Hello, court officer.
My lords, the court is on mute, my lords.
List number 3, pronouncement of order. Seal number 1.
Finding no merit in the petition stands rejected. Since the issue is of the year 2018, the concerned court shall conclude the trial within 3 months from the date of receipt of the copy of the order.
Seal number 2.
Great, ma'am.
Criminal petition is allowed. Proceedings in so and so stand squashed. Cat named Daisy has driven everyone crazy. Yes. Howda? Yes. Avaga. 23. Yes. We'll release it today itself.
Seal number 3.
3. The writ petition is dismissed with cost of rupees 50,000 to be paid by the petitioner to the respondent plaintiff. The impugned order of the concerned court dated 12/9/2024 stands upheld. In the light of the suit being of the year 2006 and the fact that it is languishing in its 19th year, I deem it appropriate to infuse finality. The concerned court shall conclude OS 9897 of 2006 with an outer limit of 2 months from the date of receipt of the copy of the order.
4.
Writ petition is allowed in part. The crime in crime number 58 of 2024, insofar as it concerns the petitioners 2 and 3, mother-in-law and father-in-law of the complainant, stands quashed. Crime in crime number 58 of 2024, insofar as it concerns the husband of the complainant, stands sustained. Investigation shall continue against the first petitioner, the husband.
5.
Dismissed.
Submission, my lord. The matter before the learned commercial court is on 5th July, my lord.
Forward.
My lord, may I request
Copy
for-
tomorrow you will get. 5th July.
Yes, my lord. Now they will advance the matter and there is a divergence of opinion, my lord, before
No,
it high
your
courts.
divergence is a figment of your imagination.
But ma'am,
All the law you have not brought to the notice of the court. Only the 3 judgments you gave which were in your favor.
yes. But none
Against you, division benches, SLP has been dismissed against all those.
But none of these judgments have considered section 32, my lord, which was vital. Therefore, my lord, a petitioner, my lord, intends to file an SLP.
Please
may,
do so.
May I request
You want- It will be uploaded tomorrow. Sir.
my lord, since there is a vacation before the Honorable Supreme Court.
Vacation bench is there.
Till then, my lord, may I request for the continuation of the present interim arrangement.
No.
Because since 1st April, there's an interim arrangement, my lord.
No.
They have been taking time in the execution.
When I passed an order, it's not correct for me to state.
But just at least 3 weeks, my lord. We
No,
will
sir.
move the vacation bench.
That's not correct. Yes.
But this honorable court has the power.
I'll have it uploaded tomorrow. Whatever you want, you can take.
But this honorable court has the power, my lord, to
Power is
extend.
the exercise discretion. Yes.
Because since 1st April, my
No,
lord,
no,
there's
sir.
an interim
I
order.
will
operating.
never stay my own order. Yes. That would mean that I have no confidence in passing that. No, sir.
Grateful for the opportunity.
Yes, we'll have it uploaded tomorrow.
Please.
6.
For the petitioner, my lords.
Dismissed.
Respondent, please.
Madam, the ಎರಡನ್ನ $230 ಏನಿದೆ ಮೇಡಮ್ Yes.
Continue.
Let's continue 61.
And for the petitions in this case, I'm challenging the notice issued by the respondent for Annex G, page 31. my lord. This is my lord, second note of litigation. my lord. The petitioner was a army ex-serviceman. He was allotted a site in the year 2004. He was joined the service in the year 2003. So he has in the out of station, out of state, in the very
Out of?
state, because he's the Indian Army. He has served in the
All right.
because after the allotment, he did not receive any allotment intimation letter for which he could not pay the settle amount. Only after retirement, he came to state. He came to know that site was allotted and it has been cancelled for non-payment. Immediately he approached the disseminal court for challenging the cancellation order. So after hearing both the parties, this lordship has set aside the cancellation order and directed the BDA to allot this site as
Got the site.
Yes, my lord. Annex the may kindly be seen. The operative portion. Just a minute. Page 29. Operative portion order may kindly be seen.
Yes, sir. I've seen page 29.
29.
Yes, sir.
Thereafter, my lord, he failed to execute the sale deed, and there was a direction to the petitioner to pay the entire balance settle amount along with the interest at the rate of 21%. So, my lord, I have paid the entire settle amount. There is a delay of 3 months because.
How did they reject it?
Because, my lord, another 3 months, there is a delay of 3 months because there is an entire state has been locked out due to pandemic COVID-19. I was not permitted to go inside to pay the entire.
COVID irrilla, sir.
Ittu sir.
22 al COVID itta.
Yes. 20 ನಲ್ಲಿ ನಮಗೆ ಡೈರೆಕ್ಷನ್ಸ್ ಇದ್ದಿದ್ದು
20 ಲಿತ್ತು ಗೊತ್ತು.
ಎಸ್ ಆವಾಗಲೇ ನಾವು ಕಟ್ಟಕ್ಕೆ ಆಗಲಿಲ್ಲ 3 ತಿಂಗಳಲ್ಲಿ ಇವ್ರು ಕೈಂಡ್ಲಿ ಐ ಫೈಲ್ ದಿ
24/11/20.
yes madam
Thick of COVID.
yes madam so I filed the contempt petitions madam.
Contempt ಹಾಕಿದ್ಮೇಲೆ ಬರದೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್
yes
ರಿಜೆಕ್ಟ್ ಆಗಿ.
to avoid the threat of contempt the false endorsement came to be issued.
So obvious contempt ಹಾಕಿದೀನಿ ಅಂತ
how
ಅಂದ್ರೆ
the contempt court has
another
made,
writ
given the findings may kindly appreciate para 7 of the contempt court order may kindly be seen madam.
ಈಗ
3 ತಿಂಗಳು
ಆಯ್ತಲ್ಲ
ಪ್ಲೀಸ್
ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
Two aspects.
Not two aspect, only one aspect. ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಅಷ್ಟೇ. ಸ್ಟೇ ಇದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
Stay ಇಲ್ಲ.
ಮತ್ತೆ
ಇನ್ನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
Yes.
Well, it's the order which has been passed, which my lords looked at, page 29 ನಲ್ಲಿ. There was this other orders which were passed.
Maybe.
One where direction was given to collect balance cycle value of with interest of 21%. The said aspects was challenged before division bench in a
What
batch
happened
of
to those orders?
Well, that the division bench had affirmed the order, but the Supreme Court has set aside the order,
And then set
and
aside
I
the
said
order and
that such
directed
an
what?
order can't be passed directing to collect 21% interest beyond the period of time and to allot the site.
Where is the order there?
I have not got the order, so I'll have it Monday or Tuesday.
Which is no consent to this process, please.
Where are the orders? Which order of the apex court?
Recently the order has come,
How recently?
It's about 2-3 weeks back, it has come. I'll produce that order copy also. Tuesday, may have it, I'll produce
Now
it.
the apex court has set aside those directions.
Please, but as I said, that 20.
It's 20 years, my lord, I struggled to get this site. I was allowed in the 2004 itself.
Just one moment.
Please.
Please, the order, is.
What is the order?
It's the 14th of May, the order has been passed.
All right, what is the order? Read it.
Please, Please. I'll just read that order.
Please, sir.
Please. At the same time, the Learned Counsel for BDA relied upon order dated 11/4/2022 passed by a coordinate bench of this court in civil appeal number -2022, wherein in identical circumstances, this court has held as follows. Rule 13(1) of the rules mandates the allottee to deposit settled value deducting the initial deposit. The appellant could extend the time for payment for a further period of not exceeding 60 days as a final chance along with additional interest. Since the writ petitioner failed to deposit the amount within the stipulated period, therefore, there is no corresponding obligation on the appellant to allot an alternative site to the writ petitioner. If the writ petitioner was being transferred from place to place, it was his duty to keep the appellant informed about his change of address on which he could be communicated. The appellant had no duty to find out the address of the writ petitioner. The sole duty to communicate the address, his place of posting, etc. was on the writ petitioner alone. In the absence of any proof of change of address, the writ
No,
petitioner
it
has
is
lost.
ಈ ಮೋಹನ್ ಕುಮಾರ್ ವರ್ಸಸ್ ಬಿಡಿ ಅದೆಲ್ಲ ರಿವರ್ಸ್ ಆಗಿದೆಯಾ? ಹೌದು, ಯಾವ ಚಾಲೆಂಜ್ ಆಗಿದ್ದು ಯಾವುದು? Which come to page 28, sir. Come to page 28 of the petition.
Please.
The petition is allowed in terms of the decisions of this
That batch,
court.
my lords. It was taken in a batch.
Correct.
Writ
All
appeals.
these orders are now reversed.
Have been reversed. my lords. They have been reversed. I'll produce that copy. my lords.
Produce it, yes. We'll take it on Tuesday. List the
Please.
matter on Tuesday in preliminary hearing.
Please. Great.
Yes. Adjourn.
Fast or man?
Serial number?
Number 4.
4 yav. Housing board.
Lord, there is some Lord dispute, my Lord, with regard to the entitlement of compensation.
Only
Lord.
consider the representation.
Lord,
Annexure AAG and
Lord, the
AA.
petitioners filed a suit.
AG, additional advocate. All right.
Lord, there are so many cases where, my Lord, the other another, my Lord, landowner, my Lord, who has title, sale deeds, my Lord, other things, my Lord, has got, my Lord, ownership, my Lord, say, ownership. Well, he's in petition is
Sections ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ,
ಹಾಕಿ.
ಹಾಕ್ಬಿಡಿ.
2025 ಅಲ್ವಾ ಇದು?
ಹೌದು.
ಹಾಕಿ objections. Counsel Pradeep Kumar submits that statement of objections would become imperative in the light of the claim of the petitioner. Therefore, objections, if any.
Petitioner ಅವ್ರನ್ನು ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ಒಳ್ಳೇದು.
ಯಾರನ್ನ ಪಾರ್ಟಿ?
ಅಂದ್ರೆ ಅವರು
To consider representation.
Civil claimants are there.
ಆಮೇಲೆ ಹಿಯರ್ ಮಾಡಿ will pass that order. Objections ಹಾಕೋಂಗಿದ್ರೆ ಹಾಕಿ. List the matter on 1st July. Objections, if any, by then. Next.
55.
No, I'll require, sir.
Scanning, ability to scan.
Will
like
require,
a-
sir, yes.
Lord, I am the owner of 33 guntas of land. State government issued a notification for acquisition of initially about 11 guntas. Final notification is dated 23/3/1989. Though the award was passed, my Lord, compensation has not been taken, possession not taken. Petitioner continues in possession. During the year 2005, BD issued a notification, my Lord, for acquisition of 10 guntas of land out of 33 guntas. Again, my Lord, one more notification. It issued another notification for acquisition of 20 guntas, my Lord, in 2009. Page 62 and 66, my Lord, are the two notifications. BDM, my Lord, took possession, though, my Lord, these are preliminary notifications. It took possession of 30 guntas of land. No compensation was paid. Petitioner filed, my Lord, several writ petitions. Ultimately, my Lord, in one of the writ petitions, when it came up, my Lord, they said, we are paying for 4 crores rupees. This was received by the petitioner under protest. Amount, my Lord, was paid only after the contempt petition was filed by the petitioner in CC number 2 of 2008.
Yes.
Contempt petition was closed, my Lord, because they paid this amount. But while closing, this honorable court, my Lord, contempt court, my Lord, specifically permitted petitioner to challenge the endorsement dated 2/2 issued by the BDA, while agreeing to grant, my Lord, the sum of rupees 4 crores. I have filed, my Lord, the present writ petition. Endorsement, my Lord, is at challenging the endorsement dated 2/2. BDA has, my Lord, paid the compensation of 4 crores. According to the endorsement, my Lord, BDA has stated, my Lord, it has utilized only 16.770 guntas of land.
Out of 33 guntas.
Yes.
Yes.
And, my Lord, they say 2.28 guntas is, my Lord, utilized by the BBMP. Their notification.
Compensation is not paid.
Howdukku illa. Further, petitioner has sought for quashing endorsement, my Lord, dated 11/2, wherein the BDA has stated that they have utilized 16.7 guntas. Petitioner has paid, my Lord, for compensation in respect of 27.72. There is a joint inspection, my Lord, this is more important, serial number 8. Joint inspection, my Lord, indicates they have utilized, my Lord, 27.72 guntas of land. BBMP, my Lord, 2.28 guntas. They've issued, my lord, notification for 30 guntas, my lord, they found that they can't contend that 2.28 is taken over by the BBMP. Utilization is admitted, therefore, my lord, they'll have to pay the market value.
Compensation.
Before the division bench told to pay market values.
In fact, division bench order, my lord, if your lords look at, my lord, page 145, division bench specifically held that, my lord, they'll have to pay the market value as on 18/4/2016. Please come to, my lord, page 143.
143.
Yes, my lord, at 145.
Connected matter.
Notification.
WP 303 of
Connected matter.
2018 matter 30381.
Which one are you referring to?
This. Two are-
30381.
Yes,
140.
my lord, the order.
145.
Yes.
Yes.
Specifically, my lord, at page 145. In accounts are payable as on April 18th, 2016. This is a division bench order. That has become final.
To assess compensation concerning the same parties?
Yes, my lord.
Same land.
Same land, my lord. Nehalal.
This has become final.
Yes.
Compensation is not paid.
4 crores ಕೊಟ್ಟಿದ್ದಾರೆ ಬಾಕಿದು ಯಾವುದು ಕೊಟ್ಟಿಲ್ಲ. So, my lord, we have.
ಎಷ್ಟು ಬರಬೇಕು?
According to us, my lord,
More than 21 crores.
21 ಕೋಟಿ ಆಗುತ್ತೆ. Little more. Market value as on 2016. It's in the prime land.
No, not market value, guideline value.
I'm told, my lord, sorry.
Now
Guideline value
value-
itself is
20 it will come up to 21 CR.
21 CR ಅಂದ್ರೆ
21
crores.
crores.
CR ಅಲ್ಲ ಇದು.
Yes.
CR.
Yes.
Always. ನಾವು ಕೋರ್ಟಿಗೆ ಹೇಳ್ಬೇಕಾದ್ರೆ full
ಅದಕ್ಕೆ
correct ಆಗಿ
CR ಗೊತ್ತು ಬಟ್ ಆದ್ರೂ ಕೇಳೋದು ಕರೆಕ್ಟ್.
ಅದಲ್ಲ
My apologies.
ನಾವು ನೆಗಾಡ್ಕೊಂಡು ಕೇಳ್ತೀರಿ ಕೆಲವರು ಏನ್ರಿ ಇದು ವಾಟ್ ಯು ಮೀನ್ ಬೈ ದಟ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಹಾಗಾಗಿ ನಾವು
ಇಲ್ಲ not that I don't know but court ಅಲ್ಲಿ it should not be.
My apologies.
No problem. Yes. Yes, Sachin.
Sir, we have issued an endorsement. We have paid the compensation. 4 crores 94 lakhs 94,106.
That is before the division bench order or after the division bench?
After the division bench order.
How did you determine that amount?
Come to that. That is one aspect, and we have also paid the compensation of 22 lakhs 17,294.
4 crore 22 lakhs.
4 crore 23 lakhs 11,310 is the. My lords, the division bench has said that as on
18th April 2016.
Correct.
Correct.
Lord, the assessment arrived at is placed on record along with my statement of objection. My lords would get it at page number.
guideline value.
That is page number 62 of my statement of objection.
On page number 178.
Please. So we had made a request to the sub-registrar to, because originally with regard to this village is concerned, we are not having any material. So for other adjacent village ಗೆ ಸಂಬಂಧಪಟ್ಟ rate ಕೊಡಿ ಅಂತ ಹೇಳಿ we made a letter.
Adjacent village?
ಹೌದು.
ಅದು ಎಲ್ಲಿತ್ತು?
That is.
ಯಾವ village adjacent ಯಾವ village?
My lords, that is, my lords would get it at page number.
It is a circle, sir.
We have drawn the proceedings. That is page number 74.
74.
74 of my statement of objection, my lords.
All right, I'm there.
Yes.
74.
Yes, sir.
Please.
340?
Page
Note 340 is it?
Yes, sir. 337 ಅಂತ.
37 ಇಂದ 40.
ಹೌದು ಸರ್. ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಯಶವಂತಪುರ.
ಆಯ್ತು, ಏನ್ ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ ತಗೊಂಡಿದ್ದೀರಿ?
ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ವಿ. ಇಲ್ಲಿ ಟೋಟಲ್ ಒಂದು ಹೇರೋಹಳ್ಳಿ ವಿಲೇಜ್ ಒಂದು.
ಹೇರೋಹಳ್ಳಿ ಗ್ರಾಮದ
ಪೇಜ್ ನಂಬರ್ 75 we have made a box. ಹೇರೋಹಳ್ಳಿ ವಿಲೇಜ್ ಗೆ
No, you have taken that as an exemplar here to determine this compensation.
ಹೌದು. We have arrived at the compensation amount of rupees 2,202 per square feet. ಒಂದು ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಗೆ 2,202 ರೂಪಾಯಿ.
ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ ಎಷ್ಟಿತ್ತು ಅವತ್ತು?
ಅದಕ್ಕೆ to arrive that conclusion, my lords would get it at page number.
No, your conclusion, guidance value ಎಷ್ಟಿತ್ತು ಸರ್ ಅವತ್ತು?
ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ ಹಾಕಿದ್ದೇನೆ.
ಎಲ್ಲಿದೆ?
ಇಲ್ಲಿದೆ. My lords, kindly see page number 81.
What the judge is saying, where is the guideline value?
Page 81. ಇದು ಸಬ್ ರಿಜಿಸ್ಟರ್ ವ್ಯಾಲ್ಯೂಷನ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 83 ರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 157 ಸಿಕ್ಕಿತು. 157 ಪೇಜ್ 83
ಶ್ರೀಗಂಧದ ಕಾವಲು.
ಹೌದು, ಇದೇ ವಿಲೇಜ್ ಇವ್ರದ್ದು. ಪರ್ ಸ್ಕ್ವೇರ್ ನೋಡಿ, ಸ್ಥಳೀಯ ವ್ಯಾಪ್ತಿಗೆ ಬರುವ ವಸತಿ ನಿವೇಶನಗಳು 23,700 ಸ್ಕ್ವೇರ್ ಮೀಟರ್. ಇದನ್ನ ಕನ್ವರ್ಟ್ ಮಾಡಿದ್ರೆ 2,202 per square feet ಬರ್ತದೆ. This is also on.
So you have determined and paid 4 crores according
Correct.
to that.
4 crores. Then for building also we have assisted.
Right.
So if you calculate with
4,23 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದೀರಾ.
4,23,00,000 11,310 ರೂಪಾಯಿ ಬರ್ತದೆ ಟೋಟಲ್.
ಆಮೇಲೆ ಚೇಂಜ್ ಏನಿಲ್ವಾ? All right.
We have issued an endorsement that is also part of record. My lords would find it at page number 146.
Right, 1 minute. Sir, what is the contra calculation according to you?
This is what it is, we have produced for BDA owns at that Kamakshi Pale Magri Road Police Station Circle near the.
My lord, we are in the circle. Please come.
Circle?
In the Kamakshi Palya circle.
Sumanahalli.
Sorry.
ಅದು ಎಲ್ಲಿ ಬರುತ್ತೆ?
Sumanahalli circle.
Item number?
This is page number 178 of.
My lords, one submission. Subject to. If there is.
ನೀವು ಸರ್ಕಲ್ ಅಲ್ಲಿ ಇಲ್ವಾ? Wait sir.
Circle ಇದು.
Yes.
Please come to my lord page 170 of the writ petition.
178?
Of the writ petition. This is our circle. So this our property itself is circle. They made that on the other side.
Kamakshi Palya, Magadi Main Road, Kamakshi Palya Police Station to Sumanahalli circle.
ಸುಮ್ಮನಹಳ್ಳಿ ಸರ್ಕಲ್.
ನಮ್ದು ಸುಮನಹಳ್ಳಿ ಸರ್ಕಲ್ ಅಲ್ಲೇ ಇದೆ. ಸರ್ಕಲ್ ಮಾಡೋದಕ್ಕೆ ತಗೊಂಡಿರೋದು.
ಆಯ್ತು.
ಅದಕ್ಕೆ my lords get that my lord at
71,000 per
2804.47 square feet and 27,720 per square feet. Is that right?
Yes, sir, yes.
ಅಲ್ಲ ಮೇಲ್ ಬರ್ದಿದೆ ನೋಡಿ ಅವ್ರದ್ದೇ.
ಕೈಯಲ್ಲಿ ಬರ್ಕೊಂಡು ಕಾಲಲ್ಲಿ ಬರ್ಕೊಂಡು
ವರ್ಷದ ಯಾವುದು ಗೊತ್ತಿಲ್ಲ.
No, if there is erroneous determination, you may have to redetermine it. Because the division bench clearly, as on 18th April 2016.
Lords, can I make a submission? Whatever the sub-register valuation we have adopted, if there is any grievances.
No, the learned senior counsel is saying the area that you have deployed itself is different than what the acquisition.
That's the reason, one submission. Lords, for this evidence has to be let. What is the market value? For that, let him approach the civil court. Now we have arrived this conclusion based on the document which is available on record. If there is any, if he wants an enhancement of compensation, let civil court determine it, because let him lead an evidence for that. Because it amounts to disputed question of fact.
Correct.
That's the reason.
Yes. What you may say, or what you are saying may be correct. We'll see. Yes. ಅದೇ ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ ತೋರಿಸ್ಬಿಟ್ರೆ ಐ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್. As on 16th April 2016, ನೀವು ಸರ್ಕಲ್ ಆಗ್ಲಿ ಅಥವಾ ಬೇರೆದಕ್ಕಾಗ್ಲಿ ಯಾವ್ದು ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ ಇತ್ತು ಅವತ್ತು. ಇಲ್ದರೆ ಐ ಮೇ ಹ್ಯಾವ್ ಟು send it to relegate you to the civil court.
ನಮ್ದು ಪ್ರಕಾರ ಅದೇ ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ 1/4/2017.
1/4/2017.
ಅದೇ ನಾನು ತಮಗೆ ಅದನ್ನ ಹಾಕಿದ್ದೇನೆ.
If there is something else, then tell me, otherwise I'll take it day after tomorrow, not a problem. I'll take it day after tomorrow. You drop a chart of calculation. I'm telling Farah, it's nothing else. You drop a chart of calculation and the guidance value. You should assist senior then. Yes. Day after tomorrow. List day after tomorrow.
Great.
Yes.
Let's continue. 63.
63.
Yes, sir. 63.
62 adjournment ತಗೊಂಡಿದ್ದಾರೆ ಮಧ್ಯಾಹ್ನ. ಗೊತ್ತಿಲ್ಲ 19th.
19th.
Here there.
No, he appears to be unwell. ಇನ್ನೇನು ಟೈಮ್ ತಗೊಂತಾ ಇದ್ದಾರೆ. List the matter on ಇದು 19th ಹಾಕಿರ್ತೀನಿ by then. Yes, list on 19th.
64.
In 64, my lord, I have to file the objection, kindly grant.
File ಮಾಡಬೇಕಾ?
Madbek.
Learned Counsel K. Krishna appearing for the BDA seeks 2 weeks time to file statement of objections. List the matter on 1st July.
65.
This my lord, I will file objection, my lord. We are not utilizing more land. We are not utilizing the land of the petitioner herein. We are only utilizing the land which was already been allotted as a road, my lord. Their contention was that we are widening the road.
I will record that, let him file his objections.
Yes.
The learned AGN instructions would submit
No,
that.
I will file objection.
No, submit that they are not utilizing the property belonging to the petitioner for the purpose of widening of the road and would like to file statement of objections. No, those things won't happen. I'm going to fix dates. List the matter on 1st July, objections, if any, by then. In the event no objections would come about, the petition would be answered hearing the counsel for the petitioner.
Next
Yes.
Tuesday, it may be taken.
Huh?
I have, if the objection is ready, I will file.
Okay, so 1st July, yes.
66.
Involved in?
Education institution.
Ah.
They are in one of the two survey numbers. Survey number 144, 145. Notification was issued by respondent number 2.
Then objections.
My lords, they have not challenged the award, my lords. They have challenging the award notice.
Interim order there?
My lords, interim order is that, my lords, not to precipitate, my lords, BD has already formed the for the property.
File your objections. Allah. File your objections.
Yes, my lord,
Anyway, you are
file.
restrained from interfering with his possession.
Now, what they are doing is, since the survey number 145, you belong to the entrance of the institution. So now the
What institution?
providing the education institution.
Providing education institution. Ah, there.
But I'll just take 5 minutes. Initially, they had issued a notification intimating my lord petitioner that they acquired 15 kuntas in one survey number. And thereafter, my lord, 2 acres, 10 kuntas in one survey number. Thereafter, lot of my credit this case, my lord, annexure D in page 33. My lord. During the formation, my lord, they have realized, saying that they need additional 16 kuntas in survey number 144. And my lord, they found that they have acquired extension of 18 kuntas in survey number 145. So therefore, my lord, the then commissioner issued a letter to the state government saying that in one survey number we want to acquire more, and in one more survey number.
Then there should be uniform acquisition, and how can you pass? No. Yes.
This is their own sketch, my lord. In page 33.
Rectification of award. Prayer is for rectification of the award.
The additional, whatever the kuntas they acquired, there is no award passed. And thereafter, my lord, there are 18 kuntas additional.
So without compensation, they have utilized the land?
Yes, sir.
Yes, sir.
Kindly see the sketch.
No, let him file his objections. It's 2023, anyway, and you're protected. The learned counsel appearing for the respondent, BDA, na? BDA seeks 2 weeks time to file statement of objections. List the matter on 3rd July. Objections, if any, by then interim order subsisting will continue to the next date. Next.
67 urgent, 68.
No representation. ಅದೇ ನಾನು ಕೊಡ್ತಾ ಇದ್ದೆ, ಯಾರು ಇಲ್ಲ ಅಂತ. List the matter on 3rd July. No, 3rd July, yes. Yes, next. Banshankari further extension.
6th stage further extension.
ಅದೇ Banshankari further extension. ಕುಡಿಯೋದು.
Not admittedly, my lord, land was converted in 1985. Not the preliminary notification is issued in 2002. Final notification, my lord, in 2003. But the issuance of final notification was challenged earlier in the of litigation. Lord, if the Lord may kindly turn to my lord, page 240, the order passed by the single judge. Page 240, the 11th portion. The judgment starts at page 93. Page 93. Portion, my lord, at 240. The court, my lord, upholds the acquisition, but however, my lord, gives liberty to the BDA, saying that, my lord, the land was under the resolution passed by the BDA, page 240. Clause B, my lord, page, clause B.
Clause B, yeah.
Clause B.
238.
240.
240. The one list on subclause. 240. 241.
241. Clause B. All the petitioners who are landowners, converted site owners, duly converted for non-agricultural use in accordance with law, who are seeking dropping of acquisition proceeding insofar as their respective land sites are concerned, on the ground that their lands are situated in the greenbelt area, converted for non-agricultural purpose, so that might be important. Converted for non-agricultural use, so and so, make an appropriate application to the authorities seeking such exclusion and exemption and producing the documents to substantiate their contention with 3 months from the date of this order. My lord, next, my lord, clause, next page, clause 3. In the event the authority comes to the conclusion that these persons are similarly placed and are covered by resolution number so and so, denotify these lands, sites, built up portion and exclude from the acquisition. Now, my lord, as per this order, the PDA, my lord, challenging this, my lord, we had filed a writ appeal. When the writ appeal was pending, my lord, the PDA, my lord, issues us an endorsement. Page, my lord, page 245, my lord, may kindly see. They say, my lord, this land is not required, and they have sent it to the government. Page 245.
That is 25/6/2007. ಕೈ ಬಿಟ್ಟು ಸರ್ಕಾರಕ್ಕೆ ಈ ಬಗ್ಗೆ ಪ್ರಸ್ತಾವನೆ ಕಳುಹಿಸಿದೆ. ಪ್ರಸ್ತಾವನೆ ರೆಕಮೆಂಡೆಡ್.
Honorable court had directed the PDA, my lord, to drop the proceedings where, my lord, the land is converted.
All right.
So they come to a conclusion, yes, the land has been converted.
So dropped it.
So drop it. That is the stand of the PDA answers.
Now what's the problem?
Now, my lord, the resolution which was passed by the PDA, which was sent to the PDA, to the government, the government, my lord, without even looking into the order passed by the learned single judge, says that since possession is now already been taken, the lord may kindly turn to the order, my lord, at page 287. Page 287.
Now government rejects it.
Government rejects it, saying that, my lord, since possession has already been taken, the question of denotification will not arise. That is the only.
Yes, sir.
I have filed objections, my lords, but
page 289. The note sheets of the BDA
recommends dropping.
My lord, there, my lord, they clearly say possession has not been taken also.
Where page?
My lord, page 289, annexure S, serial number 30, in the note sheet, serial number 30.
13. That is at page 292. 10 ಗುಂಟೆ ಜಮೀನನ್ನು ಕೈ ಬಿಡುವ ಆದೇಶಕ್ಕಾಗಿ ಸಲ್ಲಿಸಿದೆ.
ಸ್ವಾಧೀನವನ್ನು ಪಡೆದಿರುವುದಿಲ್ಲ.
ಇದು ಡಾಕ್ಟರ್ಗಿಂತ ಇದಾಗಿದೆ. ಎಸ್, ಅರ್ಥ ಆಗಲ್ಲ. ಸ್ವಾಧೀನ ಪಡೆದಿರುವುದಿಲ್ಲ. ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. ತಡೆಯಾಜ್ಞೆ ಇದ್ದಿದ್ದರಿಂದ ಸ್ವಾಧೀನಕ್ಕೆ ಪಡೆದಿರುವುದಿಲ್ಲ.
My lord, there is a Mazar which says, Mazar, my lord, which is a cyclostyle copy of the cyclostyle copy, where nothing is there, my lord, as far as the witnesses are concerned. But however, my lord, this court has held, my lord, this is not a case where, my lord, we are seeking for denotification. We are, my lord, relying on the judgment of this court, where they have held that, my lord, converted land should not happen.
Yes, sir.
I have filed objections, my lords. We would still.
You have not filed your objection.
I have filed, my lords. I have filed, but here, madam, lords, the state would have to defend.
VDA is in fact supporting us, because that is their resolution, my lord, which they say it is not required.
State government would have to file its objections, my lords, but.
What will file your objections? BDA says it is not, possession is not taken. And how did you say possession is taken and rejected the claim? On the face of it, this has to be allowed. How much? The petitioner will grant you it. The petitioner is before this court calling in question an order passed by the state government declining to accept the dropping of the land of the petitioner measuring how many guntas? 10 guntas from the acquisition on the score that possession has already been taken by the BDA.
In fact, I have produced the Mahazar copy.
Not taken.
Possession has been taken. What has happened in this case is this. There was an interim
No,
order.
even otherwise, that would become immaterial in the light of the judgment of the single judge, which has been accepted, affirmed. Whether you have taken it or not, that is not the issue. The petitioner relies upon a judgment rendered by the coordinate bench, with particular reference to clause B of the directions. Clause B of the direction reads as follows. The direction is that all the petitioners, landowners who have converted their site for non-agricultural use of land in accordance with law and who are seeking dropping of their lands from acquisition shall be dropped ಅಂತ ಮಾಡಿದ್ರ? Shall be dropped from acquisition. The finding so rendered has become final. After the order passed by the learned single judge as quoted supra, the BDA also recommends for dropping of 10 guntas from acquisition in the light of the judgment of the division, judgment of the learned single judge. This recommendation is considered and an order is passed rejecting the recommendation on the ground that BDA has already taken possession of the land. The learned counsel for the petitioner has placed the note sheet of the BDA, which would to buttress his submission that possession has not been taken in the light of the interim order subsisting in identical cases, which is disputed by the counsel representing the BDA, referring to a Mahazar. Be that as it may, in the light of the order passed by the learned single judge, the rejection of or the order of rejection by the state government is on the face of it erroneous unless the state would justify the same by appropriate objections. 2 weeks' time is finally granted to file statement of objections to the state government. Lest the matter on 1st July, in the event no objections are filed, the petition would be answered on the aforenoted contentions. Yes.
70.
Respondent. It is the nature of endomus. Since the subject matter of the land of the petitioner has been acquired in the year 1978 by the final notification also came to issue in the year 1985. However, no award has been passed, neither paid the compensation nor alternative land.
TDR certificate ಬೇಕಾ?
But I filed my statement of objections. This is not a case for awarding TDR. When acquisition proceedings are initiated,
Compensation ಕೊಟ್ಟಿಲ್ವಾ?
land is fully built up.
Compensation ಕೊಟ್ಟಿದ್ದಾರೆ.
The award has not been passed.
Why?
Barring an extent of 5 guntas of land in survey number 48.
Acquisition ಯಾವಾಗಿಂದು?
78.
1978.
78.
ಇಲ್ಲಿವರೆಗೂ ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡಿಲ್ಲ.
DJ Helli, that fully built up area. I have produced the Google map also. The remedy is to file a writ petition and get it quashed, not for issuance of a TDR.
TDR ಇಲ್ಲ ಬೇರೆ, but compensation ಇಲ್ಲ to pay. ಇಲ್ಲಾಂದ್ರೆ as I said, file a petition, seek quashment of the notification insofar as the property is concerned.
Or he may approach the BDA for issuance of NOC. After final notification of them, certain persons might have constructed the building. Even BDA has also issued notice to them. That also I have placed before this court.
You have given representations to that effect. ಅದನ್ನೇ consideration ಕೇಳ್ತಿರೋದು.
Issuance of
TDR ದಲ್ಲ, prior 4.
Yes.
Not, I will not pronounce upon TDRs.
Please.
Consider the representation.
78 notification concept of TDR has come only in 2004. Till then ಏನು ಇರಲಿಲ್ಲ. Yes.
In the representation, series of representations they have given, they have requested for TDR only.
Will not on that.
Compensation as well as.
He will restrict it to compensation.
Lords,
He will restrict his claim to compensation only.
but even then, Lords,
ಅದು ಇಲ್ವಾ?
built up area ಇದೆ. We will not, I have filed an objection to the effect that layout cannot be formed there. Therefore, my lords, he may seek, get it quashed, or he may seek for issuance of an NOC from the BDA.
Amend this and seek quashment of the notifications. You're not challenging the acquisition process?
My lord, he has sold it, my lords. The difficulty would be, my lords, he filed this writ petition only because, my lord, the LRs of one Munimarappa has already sold the land to several other, because my file clearly discloses that at the time of filing of objections to the PN, they have all requested for dropping of the proceedings. They are not in possession of the land in question.
We'll look into it and then pass out. List the matter on 3rd July. Next. ಮುಗಿದೈತೆ ಇದು. ಒಂದು ನಿಮಿಷ ಎಷ್ಟಿದೆ ಇನ್ನು? 83 ಇದೆ. 4 ಮ್ಯಾಟರ್. 80 ಅಲ್ಲ. Yes.
72.
Where is Sidrap?
Thank you.
List the matter on 8th July. Interim order subsisting will continue till the next date of hearing. ನಿಮ್ಗೆ urgency ಉಂಟಾ? Wait, yes. Next.
73.
First ಹಳೆದೆಲ್ಲ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗೋಣ.
Lord, this matter is covered by His Lordship's judgment, my Lord. Sir.
Page 76.
No.
Yes, sir.
Lord, need to file objections.
You covered ಅಲ್ವಾ? ನೋಡಿದ್ದೀರಾ ಇದು?
ನೋಡಿದ್ದೀವಿ.
Covered?
It's covered.
Vehemently argued. ಅಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು. ಒಂದು ವಾರ ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀನಿ. Material instructions ಬರುತ್ತೆ.
Award has been passed. 1623.
We want to file objection, let him file.
Same village, survey number, this is in so far as survey number 62 is concerned. Minus 61.
ಏನ್ ಲ್ಯಾಪ್ಸ್ ಆಗಿದೆ ಅಂತನಾ?
Please, my lord.
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
1990.
1990.
1994. 94.
1994. ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಬೇಕಾಗಿಲ್ಲ. Yes.
Covered.
Pass the same order. Vehemently argued. The petitioner is before this court seeking the following prayer, heard so and so. The learned counsel H. Shanti Bhushan, representing the petitioner, would contend that the coordinate bench concerning the same acquisition of the adjacent land has allowed the petition, quashed the acquisition, quashed the notifications of acquisition on the score that the scheme has lapsed.
Scheme has lapsed.
In terms of the mandate of section 27 of the BDA Act. The coordinate bench has held as follows from para 12 to, para 14 to end. The learned counsel for the respondent, though, would put up vehement opposition on the ground that award has already been passed. He is not in a position to dispute the fact that the notification was of the year 1994 and nothing has happened in the subject land. Therefore, the scheme has stood lapsed. and does not meet the rigors of section 27 of the BDA Act, as is held by the coordinate bench. In the light of the issue standing answered, as also the fact the standing answered, qua the same acquisition, I deem it appropriate to follow suit and grant the same relief to the present petitioner as well. Same order, yes.
74.
Very short question. Petitioner was not a party to the compromise. Though he was not physically present, nor his signature was taken on the order sheet, the execution case, my lord, came to be closed.
I'll file my objection, my lord, for this.
Learned Counsel Prashant BR seeks 2 weeks time to file 2 weeks time to file statement of objections. 3rd July, objections if any by them. Yes.
Please.
Next.
75.
Milord, Milord, I appear for the respondent and I request for Milord 2 weeks time for Milord filing of statement of
Simple
objection.
matter where, Milord.
Objection ಹಾಕ್ಬಾರ್ದಾ?
ಅಲ್ಲ ಮಾಡ್ಬೋದು, but Milord, point is, Milord, they fixed the market value at Milord 4,110. Milord paid them 15.
Place the
But
matter on
while-
8th July, objections if any by the National Highway Authority of India by then.
Milord, kindly.
Oblige, Milord.
Made clear further adjournment for filing of objections would not be granted.
Payment
Yes.
ಮಾಡುವಾಗ
Please,
25
Milord.
slab ಪ್ರಕಾರ ಕೊಟ್ಟಿದ್ದಾರೆ.
Objection act
Preliminary, Milord.
2025, sir.
Preliminary.
No.
But
Yes.
payment of compensation.
Well, yes, everything will reach.
76.
Please.
Please, my lords. Sought for mandamus, my lords, to restore my name.
Disclose your, restore your.
To restore my name in the RTC, my lords.
Yes, sir.
I'm the owner of the land.
It is to be done by the
Government ಯಾರು?
government ಮಾಡ್ಬೇಕು. So it's a- it is-
Government
No, KDB
has-
lots had proposed.
Who
to-
should restore, sir?
Government.
ಎಲ್ಲಿ ಸರ್ಕಾರ?
76.
ನೋಡೇ ಇಲ್ವಾ ಫೈಲ್? Day after tomorrow. Yes.
Pursuant to the order passed by this honorable court.
Day
my
after
lords, the day after.
77.
Petitioner, my lord.
Objections?
Today he has issued the endorsement to me, copy
Endorsement
of
has
the
been
endorsement. It is a very vague, there is nothing
Challenge
in the
that.
endorsement.
Challenge ಮಾಡಿ.
I need to challenge that endorsement.
Learned Counsel, the Learned Counsel H.L. Pradeep Kumar submits that pursuant to, in terms of the prayer seeking consideration of the representation, an endorsement is issued.
That is a legal notice.
Served upon the petitioner. The endorsement is dated 9/6/2025, which rejects the claim of the petitioner. The Learned Counsel for the petitioner seeks leave of this court to draw the petition and raise a challenge to the endorsement so issued on 9/6/2025, reserving such liberty to the petitioner to raise a challenge. If he is so aggrieved, the petition stands disposed. Next.
78.
Petitioner sought for a writ of mandamus, my lord.
Who has to consider?
It cannot be considered.
BDA.
Consider ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಬರಲ್ಲ,
There is a
objection ಆಗ್ತದೆ.
rival claimant ಇದೆ.
ಏನು ಕೇಳಿದ್ರೆ ಕಾಂಪೆನ್ಸೇಷನ್?
No,
ಇಲ್ಲ,
my lords, the
site
site,
allotment
my lords, was allotted in favor of the elder brother, my lords.
Rival claimant ಹೆಂಗೆ?
The elder brother, the site was allotted, my lords, in favor of the brother of.
So what are you filing? Objections?
Memo.
Memo for what?
ನಾಗರಾಜ್ ಅನ್ನೋನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ನಂಗೆ ಸೈಟ್ ಕೊಡಿ ಅಂತ ಕೇಳ.
Who is Nagaraj?
The petitioner, my lords, is the brother, my lords, of the deceased Bhimappa, who was allotted, my lords, the site.
Next Tuesday.
Please.
Yes.
79.
Paper for the petitioner covered by decision annexure E of the petition.
Covered.
Please. Annexure E.
Wait, sir.
They have to file objections, my lord.
Learned Counsel appearing for the respondent seeks time to file statement of objections. 3rd July, objections if any by then. Counsel for the petitioner submits that the issue stands covered by the judgment rendered with the coordinate bench, page 39. In the event no objections are filed, this court would follow the order of the coordinate bench and dispose the petition. Yes, next.
Date may be.
P, my lords, has sought for remanding the matter, my lords. Kindly see annexure P for a moment.
Appearing for respondent number 1 and 2, my lord. Earlier, learned counsel Shobhit Shetty was directed to take notice for respondent
MS
number Vasan Copper. MV Kenyan companies.
You know?
MV Kenyan company.
MV Kinian Company.
Company has been instructed
Registry to delete the name of Shobhit Shetty as appearing for 1 and 2 and print the name of MV Kini and Company as appearing for respondents 1 and 2.
Page 17 may kindly be seen for a moment. Page 17. But so on one day in the year 2022, somebody files wakalat. And straight away, no opportunity, no hearing, nothing.
My lord, the present petition is as against an arbitral award.
No,
An
I'm
alternative
not
Natural justice violation.
under 34, my lord.
No,
And it is
Adukku
all
34 kalas, I will never
after
send.
the lapse of.
I will never send, sir.
I may be
You
permitted
violate
to-
everything and say a limitation barli anta allige hogli anta ಹೇಳ್ತಿರದಾ?
My lord, limitation
Yes.
has been barred, my lord. I'll file my,
That
I'll place my,
itself is anyway debatable.
I'll place my objections on record, my lord. My
List on Tuesday in preliminary hearing.
Please.
Yes.
81,
For the petitioner, my lords.
ಈ ಮೊನ್ನೆಯಿಂದ 2-3 ಕೇಸಿಗೆ ಬರೋದೇ ಇಲ್ಲ ಸರ್.
Lords, I was not well, my colleague was there. But
Nobody was there, sir.
I am sorry, my lords.
ಇದೇನು?
My lords, the petitioner's land.
ಯಾಕೆ ಇದರಲ್ಲಿ ಸ್ಟೇಕ್ಸ್ ಹೈ ಇದೆಯಾ?
Without initiating any acquisition proceedings, my lords, the land belonging to the petitioner has been.
Then highwayನಾ?
Please.
Who appears respondent?
Silpa Shah is.
Milord, my name is shown. I have not, I mean, copy was served upon us and I have sent it to Milord NHI, not received instruction yet. Milord, at least a week's time may be granted, Milord.
Then 3rd July, finally, yes. List on 3rd July at the request of the council, Srimati Shilpa Shah.
Obliged, obliged.
ಯಾವ್ದು ಮೇಡಮ್ ಇದು?
final disposal 82,
23/10/2000 ಎಲ್ಲೇ KLR.
Hearing for respondent number 1, my lord. I seek for a.
ಶರತ್ ಗೌಡ್ರು ಏನಿದೆ?
Lords, this
ಯಾಕೆ
one,
KLR ಕನೆಕ್ಟ್ ಆಗಿದೆ?
Lords, National Highway Authority hack. The land, KLR is a connected petition, my lords, because the subject matter is same, land is same.
14 and 16, 1 week time I will grant. Get ready in the matter.
Please, sir.
Yes. Next Thursday, list on 19th.
The question is, we are on Moolageni, my lords. This land is now subject matter of
We'll see on
acquisition.
that day, 19th.
Obliged.
Yes.
final hearing 83,
For direction to consider the representation to allot the
ಇದು
land in the.
My lord, here they are claiming, my lord, in survey number 137, they are claiming that VD has used a portion of the land for the formation of road. My lord, I have filed the memo along with the documents, my lord. A statement of objection also filed subsequent.
Which SLP is pending?
My lord, that is pertaining to where the.
Last time SLP is pending ಅಂತ ಅಡ್ಜನ್ ಆಗಿದೆ.
That is pertaining to the lands where the BD has utilized the land without acquiring the land. There is a resolution for payment.
What has happened to this SLP?
That, my lord, that SLP is pending, but that, my
That
lord.
has nothing to do with this?
Nothing to do, because, my lord, here we have not utilized the land and we have not formed the layout also. My lord, kindly see. I have
List on next Tuesday in preliminary hearing.
Allotted for without.
Preliminary hearing next Tuesday, yes. We'll close it.
Yes.
Next. ಯಾವ್ದು madam? 2:30 further hearing. Huh? Oh, this NCLT.
Yes, my lord, this is that.
Yes, sir.
My lord, I appear for the respondent who is appointed as the resolution professional. The main answering respondent is the State Bank of India, my lord.
Yes, Krishnamurthy sir ಇದ್ದಾರೆ.
So.
Yes, sir.
In this connection, your lordship was pleased to author a judgment last month.
Author a judgment, which one, sir?
In another matter. Now that matter covers some of the most important issues that we are raising here.
What is that?
Yes, I have a judgment. Yes. Take copies for everybody. Court copy will give.
On 3/4, lordship kindly on 3/4/2025.
judgment ನಂದ
Yes, so that's a judgment where, yes, we are giving. Where your lordship recognizes, based on established law, that the DRT would not be in a position to decide on forgery and fabrication.
Correct.
In that view of the matter, that was a case where the debtor had gone before the DRT and made an application stating that, kindly see, I have a civil court proceeding in which I am seeking a declaration that these documents are all forged. So please stay your proceedings. That was a request he made. Now the DRT felt that under the law, they are not really bound to take note of such proceedings, so they summarily dismissed it. And that comes before your lordship. And then your lordship looks into the state of the law and then finally determines that because a DRT, that was a surface proceeding, would not have the authority to decide on forgery, and then that is a matter for the civil court, which proceeding is pending. That will have to be looked into by the DRT, and so DRT is directed to
criminal cases were pending, charge sheet is filed for forgery.
Yes. So now, this is a case, in our case, we have a positive order from a civil court directing SBI not to use the board resolution dated 1st September 2009, which is of course the foundation of their matter before the NCLT. Now, that is the reason why the NCLT is saying, now page 477 and 480 in volume 3 may kindly be looked into, your lordship. 477 and 480. I'll come to page 480 first.
Yes.
So this is the defendants are the SBI and then various other persons connected with prosecuting SBI's claims before the NCLT. Mr. Dayananda is the first petitioner in this writ petition. The prayer that he seeks, page 480, if I may, to declare that the forged and fabricated board resolution dated 1st-9/2009 is void ab initio. And then prayer B in substance is a permanent injunction against using it, SBI and other persons using it in any forum whatsoever. And there is accordingly an order passed last year, almost 1 year, 2 months ago. Now that order
of the NCLT.
NCLT is proceeding. NCLT has already directed liquidation, and then the liquidation processes are underway and it's proceeding. Now this order is an order that the NCLT would want guidance on how to deal with.
Where is it? Where is the NCLT so crying?
Orally.
Orally?
Your lordship, this order directs SBI not to use it. And then the NCLT recognizes that SBI is going on doing it. So in a situation like this.
Now, liquidation process is over already?
Liquidation process is on.
Liquidated. Company has already been ordered to be liquidated.
Liquidation order has been passed, but at the end of the day, after a company is directed to be liquidated, there is so much that happens. And then that is informed to the NCLT, and the NCLT says, now I direct the company to be struck off the register of companies. Now that is a fag end, which is in fact has not happened. Now my only concern here is NCLT can't decide on forgery and fabrication. Now civil court alone can. Now a civil court has in fact been
indirectly. I have stayed the proceedings before the NCLT, which I will not.
No, that is not what the order is. Your lordship did not say NCLT proceedings will be stayed.
Come to page 42, your prayer.
Yes, no, but then the prayer granted by this honorable court.
That's all right. What is your prayer? Now
I will read down the prayer.
If I am to consider it finally, this I can't grant.
No, that is why in my written argument, we have said we are requesting a reading down of the prayer. A reading down of the prayer to the extent that the NCLT proceedings be directed to be adjourned for a period of 3 months.
No, you take it that the prayer is read down. Even on the read down prayer, the effect would be that I am stalling liquidation process or the liquidation going to its logical conclusion.
Okay, if that is problematic, as your lordship sees it, NCLT should be
not problematic. You see, 2 of the orders of mine, where the apex court has said that I should not interfere in NCLT proceedings.
Yes,
repeatedly I'm interfering despite the orders of the apex court. What is observed by the apex court?
My respectful submission would be that it certainly would not be a fact like this.
No. The effect.
The lordship, the Honorable Supreme Court is not going to say the civil court will be made light of by the SBI, and then the IBC court allows the SBI to make light of the civil court proceedings. Your lordship, with greatest of respect. Honorable Supreme Court would, I mean, those were facts, certainly it would rest on facts, but I don't think it's an absolute principle of law because
Where are the judgments?
if that is the case, then your lordship may kindly
Farooq Ali
see,
Khan give it.
if it flows from the statute, then I
And
will.
one more where Justice Narasimha Ramal on should not
Mohammed
interfere.
Enterprises
Allah,
Tanzania.
if that is the
Mohammed
case, then
Enterprises.
IBC provisions, unfortunately, I will have to seek unconstitutionality of IBC provisions only.
Whatever.
Allah, because if a debtor's defense.
Before the apex court, sir.
Allah, if debtor's defense must be excluded, if IBC is read in a way that your lordship is excluding the debtor's defense.
The effect of entertainment of this petition is stalling the proceedings before the NCLT, which I will not.
Okay, let us not stall it. If it is directed to take note of the proceeding and to act accordingly, which in fact has been the order.
Sir, everything is over now. Liquidation process is on or to be taken to its logical conclusion.
Your lordship,
Where am I putting the clock back?
Allah, we have had an order. I can produce it. 21 years after the order of winding up, this honorable court recalls the order of winding up. No, in a case like this.
No, I can tell you, Northeast is a beautiful place. Yes.
My respectful
You didn't
submission.
get my point.
My respectful. No, absolutely not. Well, yeah, certainly.
Yes, yes.
Your lordship may kindly note that the judgments that were just cited out, I certainly would be in a position to distinguish.
No, sir.
Your lordship, certainly they would not deal with facts of this nature.
Period. I will not interfere in matters pertaining to NCLT.
Now,
and your prayer, whether it is read down or even enlarged, will ultimately lead to the fact that NCLT proceedings are stayed.
Well, in that event, now is that because the statute requires it? Because if that is the case,
that's because the apex court time and again says that this court under Article 226 should not interfere with the proceedings. Where is the next order?
Allah, and I will show the apex court judgments only that say.
You should show it to the apex.
Allah, no, basically to make sense of those judgments. Your lordship, we get 880 judgments from the Supreme Court every year, and then 2 judgments exclusively read in a way to keep out facts.
You may say from that side, I cannot say here. Next order, Nandish, where is it?
DRT, your lordship may kindly see, DRT was struck down by the Delhi High Court because it would not take off debtors' defenses.
That is what impressed me in granting an interim protection to you. The apex court later says, no, I shouldn't have. In identical cases, may not be in this case.
Allah, I'm not aware of that, how identical it is. If I may be given the opportunity to
How identical, Allah? It is NCLT proceedings of any kind. Under Article 226, this court should not interfere.
The order which I just gave, that has not gone to the Supreme Court.
That doesn't.
Allah, the order which I did give, we do our research, it has not gone to the Supreme Court. No.
I will not.
Then your lordship kindly note.
It's plain and simple.
Allah,
whatever skills of convincing you may demonstrate, but I will not.
Allah, but then this resolute, I mean, with great respect.
Supreme Court, sir.
Allah, but your judgment is not everything. The jurisprudence is not just.
No, that is DRT. On those facts I have rendered. It's a different thing, but I'm not. NCLT proceedings I will not stall at all.
NCLT does not have the jurisdiction. Now their hands.
You should take clarification from the apex court.
Then they would certainly blame us for not doing enough before the High Court.
So don't worry. That's,
No.
Then I am there to be blamed.
No, yes. We will be asked that we didn't argue enough. We did not try to persuade the court.
No.
There are 3 judgments of the Supreme Court which we have cited in.
Maybe, sir, this is reversing my order. Reversing my order. There is another. They have not got it. I have it. Reversing my order, saying I should not entertain petitions which question anything about the NCLT.
And with great respect, I'll have to say it's prima facie, it would be very wrong to say something like that. And I must have the authority to say so much. You'll also may kindly see in the language policy case.
No, you may say.
Allah, kindly see what happened in the language policy case. This honorable court said the honorable Supreme Court's comments actually were not required in that matter and went against it. And this was approved by the honorable Supreme Court of High Judge Bench. A 1994 decision was cited by the government to come out with its language policy. Now, this honorable court said that, doctrine of precedent requires us to read the judgment in a certain way, and we don't think it is binding. I'm not saying we need to go that far in this case. All I'm saying is, let's have the opportunity to look at these judgments and then to distinguish it.
We'll take it tomorrow.
We'll distinguish it.
No, I am not, whatever, you may try to distinguish, but since it is passed on, an order passed by me entertaining identical petition with regard to, that was in violation of natural justice, violation of the statutory provisions, I had said everything. That was a about 100-page judgment. Now it is, it's reversed here.
Yes, we'll come back tomorrow, but our proposal would be,
No, sir,
if your lordship would in fact refer
No,
to
I'm
this
not-
judgment and say interim order can't continue, we will take the matter to the Supreme Court.
Please do that.
Allah, only not by keeping the matter alive.
No,
but-
no.
Allah, but then it certainly would not help us. If your lordship were to say,
No.
not today, but tomorrow.
You can't take a live litigation, taking a stray order and going to the Supreme Court and bringing an order again. He has entertained the petition again. No, sir.
Allah, we want to inform the Supreme Court that the law is this and that the Honorable
No problem. We will pass a final order.
Illa vera.
You can take it, and Supreme Court, if it is, if it clarifies, then we will take it.
We could have the matter day after tomorrow, then I'll look into this judgment.
Oh, that's all it. What, day after tomorrow, finally, no more adjournments on this issue.
Illa, we never
I'm
saw
not-
adjournment
And
until now.
prima facie, I can tell you it is period that I'm not going to entertain.
We are grateful for the guidance that's coming.
Correct, whatever it is. But
Notwithstanding that, my lord, prayer your lordship may kindly see the prayer.
that's what I'm telling you, prayer. The effect is that.
We have read it down.
No, Dhananjay sir, generally I would just,
We'll have
now
it
I
after.
don't get into the adventurism.
Absolutely not. Absolutely not. Day after tomorrow.
No, because when Supreme Court has clearly said that I should not entertain, I will not.
We'll do our research.
It's a burnt child.
We'll
Treating
do our
with fire.
research.
Yes,
Day after tomorrow.
yes, day after tomorrow in preliminary hearing.
Grateful.
Yes. Interim order subsisting will continue to the next date.
Further reading 85.
Nandish, get the next order. Yes.
This is that Santosh Hospital, my lord.
Santosh?
Santosh
Ah,
Hospital.
ಎಲ್ಲಿ ಇವರು ಜಗದೀಶ್ ಸ್ಫೂರ್ತಿ ನೀವೇ ಮಾಡ್ತೀರಾ ಅಲ್ಲ ಮೋರ್ ದೆನ್ ದಟ್ ಮಯೂರ್ದು ಇದೆ ಇವತ್ತು ವೇರ್ ಇಸ್ ದಟ್ is not there that CBI investigation. Okay, I will take that. Yes, let me see, we'll continue.
86.
ಇದಿರ್ಲಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ.
Allah, because I have not that.
You don't worry, tomorrow day after we'll take it.
Interim order may kindly be issued.
That will, don't worry about that. Yes. Ready, Naila?
Yes, sir. Mr. Chowta was heard already in this matter, my lord.
So I've forgotten.
Lordship,
If they want to make submissions, I'll be doing the same day if they require time. Otherwise, we can already.
Yavat ಬೇಕು.
Synopsis in the matter.
File.
File.
Already filed. So I should look into it and pass orders.
The LOC matter is very simple, my lord, that's.
No, that is an offshoot of this. If this goes, LOC goes.
And there are
ಇದಿರ್ಲಿ
other-
ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಯಾವಾಗ ಮಾಡಿ, where is Shota sir?
He's on his legs in another.
Tomorrow. It will be in the list. Yes, but
Lordship,
continue.
Could you day after tomorrow? on this?
ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕು ಅವಾಗ ಮಾಡಿ.
It comes if I don't appear.
ಆ ಥರ
That's it, kind
Don't
of-
worry about that. I will not record that nobody has appeared
No, no.
until well. Yes. Yes, next.
87.
Krishnan sir is not there, is it? Yes.
My lords, appearing for respondent, my lords, for the connected matter.
Yes,
So matter, my lords,
Mahesh.
where what we have challenged, my lords, see, it's based on an offshoot of a criminal complaint filed.
What happened to that?
That has been tagged along.
This is the criminal complaint, is
That's
it?
correct.
This is stayed here.
That has stayed here.
Anyway, if we answer this, this
That,
goes.
that goes, my lords.
Connected
That's
matter.
the- The stay was granted on a ground that, my lords, Priyanka Shrivastava was not followed.
But that is in fact followed.
No, it's not.
Then fine.
Then, my lords, it has to go.
Yes, Jagdish sir has
Irrespective
come.
of the other merits of the case.
There is another matter, my lords, regarding to the same, quashing of same PCR and FIR, my lords, filed by the petitioners in this case.
No, I'm not going to tag any other matter.
No, my lords, the same question regarding the same, my lords.
What is
are
it?
the connected matters? My lords, the criminal petition 4870 of 2025. The
I am
petitioner
not
are
going to
different.
tag that, sir. This you answer, it will be fine. ಇನ್ನೊಂದು ಯಾವ್ದು ಹಾಕಿದ್ದೀರಾ?
ನಂಗೆ ಗೊತ್ತಿದೆ.
Yes.
ನಾನು ಹಾಕಿದೆ.
Let it be in the list. When do you want to submit?
My lords, small adjournment, my lords. And even I need a petition copy from petitioners, my lord, because
No, you are not the petitioner.
I am not the
He is
petitioner.
talking about the connected matters.
connected matter.
Connected matter, I don't have the copy.
Correct, the petitioner is not here.
Yes.
That's what. The 87.1 al ಬರ್ಕೊಳ್ಳಿ ಜೀವ. The petitioner shall serve set of papers upon the counsel representing the respondent forthwith. ಅದು next week ಬರುತ್ತೆ. It will be in the list.
88.
Jagdish sir, ಅಲ್ಲಿ ಮುಗಿತಾ? You have to go back? You have to go back ಅಂದ್ರೆ ಹೋಗಿ. This cell number 85 ಅಲ್ಲಿ,
Yes.
it's Santosh Hospital. Oh, it will have a bearing on, ಬರ್ಲಿ. Yes, next.
88.
This matter,
Ah,
I may be permitted to file a written submission.
ಸಾಕಾದು? Yes. The 88 ಅಲ್ಲಿ ಜೀವ. The matter was heard on it being posted for further hearing on the request of the counsel B.S. Prasad. As a reply to those submissions, the counsel for the petitioner files written submissions. The same is taken on record, re-reserved. Yes. ಅಷ್ಟೇ. ಮತ್ತೆ ಮೂವ್ ಮಾಡಬೇಡಿ.
ಇಲ್ಲ,
ಇನ್ನೂ
ಮತ್ತೆ
ಎರಡು
move
ಪಾಯಿಂಟ್ ಬಿಟ್ಬಿಟ್ಟಿದ್ದೆ.
ಇಲ್ಲ, ನಾವು ಮತ್ತೆ ಮೂವ್ ಮಾಡೋದು ಬಿಕಾಸ್ ಅರ್ಲಿಯರ್ my lord, I moved the
ಯಾವಾಗ
matter.
3 ತಿಂಗಳಾದ್ಮೇಲೆ ಮೂವ್ ಮಾಡ್ತೀರಾ? ಪಾಯಿಂಟ್ ಬಿಟ್ಬಿಟ್ಟಿದ್ದೆ ಅಂತ.
ಟ್ರಿಪ್ ಶೀಟ್ ಅಲ್ಲಿ ನಂಬರ್ ಇರುತ್ತೆ, ಇದರಲ್ಲಿ ನಂಬರ್ ಇರುತ್ತೆ, ಬರೀ ಇನ್ವಾಯ್ಸ್ ಮೇಲೆ ಮಾತ್ರ ಅವ್ರು ಇದ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಟ್ರಿಪ್ ಶೀಟ್ ನಂಬರ್ ಮತ್ತೆ
We'll see. Yes,
ಲೈಸೆನ್ಸ್
89.
ನಂಬರ್.
89.
89, I appear for the petitioner.
ಬನ್ನಿ.
Your Lordship has heard this matter.
I have heard extensive. Yes, sir. Anything else?
Yes, my lord, there is a submission.
I have heard you also at length all over. ಇನ್ನು ನಾನು ಗುಲ್ಬರ್ಗಾಗೆ ಹೋದ್ರೆ ಅಲ್ಲಿ ಕೇಳ್ಬೇಕು ಅಷ್ಟೇ, ಅದೊಂದೇ ಬಾಕಿ ಇರೋದು.
Not at
ಎರಡು
length.
ಸರಿ ಧಾರವಾಡದಲ್ಲಿ ಕೇಳಿದ್ದೀನಿ.
Not
ಫಸ್ಟ್ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಕೊಟ್ಟಿದ್ದು 23 ಅಲ್ಲಿ ಧಾರವಾಡದಲ್ಲಿ, 25 ಅಲ್ಲಿ ಮತ್ತೆ ಅಲ್ಲೇ ಕೇಳಿದ್ದೀನಿ. ಈಗ ಮತ್ತೆ ಇಲ್ಲಿ ಕೇಳ್ತೀನಿ. ಎಷ್ಟು ಕಡೆ ಅಂತ ಕೇಳಲಿ ಇದನ್ನ?
ನಮ್ ಸೈಡ್ ಕೇಳಿಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ ಸೈಡ್ ಕೇಳಿ.
ನಿಮ್ ಸೈಡೇ ಕೇಳಿರೋದು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರು ನಾನು ಬಂದಾಗ ಒಂದು
ಸರಿ,
2
ಸರಿ.
ನಿಮಿಷ ಅಷ್ಟೇ.
ಎಲ್ಲ ನಿಮ್ದು ಅವ್ರ ಸೈಡ್ ಕೇಳೋ ಅವಶ್ಯಕತೆನೇ ಇರ್ಲಿಲ್ಲ. ನಾನು ಎಂಟ್ರಿ ಮಾಡಲ್ಲ, ಎಲ್ಲ ಕವರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೆ. ನಿಮ್ನೆ ಕೇಳ್ಬೇಕಾಗಿತ್ತು. ಅದನ್ನೇ ಕೇಳಿದ್ದೀನಿ. ನೀವು ಅದು ಕೊಡ್ತೀನಿ ಇದು ಕೊಡ್ತೀನಿ ಅಂತ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಆಗ್ತಾನೆ ಇದೆ.
ಇಲ್ಲ.
ಈಗ ಏನಿದೆ ಹೇಳ್ಬಿಡಿ.
Adjournment umpteen number of times.
Your Honor,
ಹೇಳಿ.
This is a case of trespass. Already my position is protected by this honorable court in civil case. And that has been upheld by the honorable Supreme Court. In the meantime, the petitioner have tried to trespass and demolish the compound wall of the respondent, for which the respondent has lodged the complaint before the police station. Police have registered a case. Your Honor, in respect of civil case is pending, we are not claiming under the civil case nothing before this honorable court. Only it is
atrocities,
trespass
and trespass.
Trespass. That is the only. Unless whether the trespass has been done or not, that is only to be
Matter of trial.
It is a matter of investigation and trial. Here, investigation has not been completed, started at all.
ಹೌದು, ಅದು
Started
ಮುಂಚೆ
at
ಸ್ಟೇ
all.
ಆಗಿದೆ.
Very third day, is honorable court has granted.
Third day ಅಲ್ಲ, 13 days.
Sorry. Now, your lordship has asked me to produce some document in respect of payment.
That may not be required.
That is not at all required, because it is a matter of civil case. Civil case is pending before the honorable city civil court. Now, my submission is the matter to be investigated by police, whether the trespass has not are done or not, because it is appeared in the entire media for 3 days. What the atrocities have done by the petitioner. There are records. Let the investigation be.
Media records.
Mediaದಲ್ಲಿ ಬಂದಿದೆ. How they have bulldozed my the compound wall. How they around 40 to 50 members Gundas have entered the. They created a nuisance there, for which the respondent has lodged the complaint. Let the investigation be continue. That is my submission.
ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವ್ದಾದ್ರು ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ಕೊಟ್ಬಿಡಿ. ನೀವು ಯಾವ್ದಾರು ಕೊಡ್ಬೇಕು ಅಂತ.
Please.
Yeah. At the civil case and criminal case.
You are there in this, sir?
No, next matter ನಂದಿತ್ತು, ಅಲ್ಲಿ ಬೇರೆ matter ಕರೀತಾ
Paral,
ಇದ್ದಾರೆ.
It will be in the list. Not
Very good, because I've got another matter.
Yes,
to
yes. Hitesh Verma.
I've given that unit.
You are. Why is he giving Hitesh Verma? ಪುನೀತ್ ಬೇರಿವಾಲ ಅದು ನೀವೇ ಕೊಟ್ರದ್ದು?
ಇಲ್ಲ ಇಲ್ಲ
ನೀವು ಕೊಟ್ಟು. ತಾಳಿ ಒಂದ್ ನಿಮಿಷ. ಹಾ, ಆರೋಪಿ ಬರ್ದಿದ್ದಾರೆ ಅಷ್ಟೇನಾ? ಜಗದೀಶ್ ಸರ್, leave it to the court. Yes.
Your
Heard
Lordship,
reserved.
Please, please.
Interim order subsisting will continue till the disposal of the petition.
Obliged.
ಏನು ಹೇಳೋದಿಲ್ಲ ಎಲ್ಲ ಹೇಳಿ ಆಗಿದೆ.
Next.
He's made up his mind.
90 ನೀವಿದ್ದೀರಾ?
ಏನಾಗಿದೆ, yesterday I have filed an additional objection.
Yesterday?
I have filed an additional objections.
Who?
I
Additional objection ಹಾಕ್ಬೇಕಾ?
ಹಾಕಿದ್ದೀನಿ.
ಹಾ.
ಪುಟ್ ಅಪ್ ಆಗಿಲ್ಲ ಅಂತ.
ಇಲ್ಲ, put up ಆಗಿದೆ.
ಆಗಿದೆ ಸರ್.
Yes.
Kindly pass on. Mandigi is just.
Senior counsel
Senior
Mandigi.
senior advocate Mandigi. I'm sorry.
ಎಲ್ಲ ಮರ್ತು ಬಿಟ್ಟಿದ್ದೀರಾ?
Sorry.
Yes.
Kindly pass on. You've just come.
Ready na sir? We'll see. Time permits, we'll take it.
Otherwise your lordship will fix a date so that.
ಇಲ್ಲ, this will be in the list. They will be till disposal, they will be repeating.
My only thing is.
ನಿಮ್ಗೆ ಯಾವತ್ತಾಗುತ್ತೆ ಅವತ್ತು ಮಾಡಿ. I am force
Tuesday
ಮಾಡಿ.
also we.
Whenever both of you are ready to argue, I will hear it.
I am ready to argue even tomorrow day after also, no problem.
But it will be tomorrow or day after, we'll take it. Once I finish the regular list, I am taking this list.
Yes, yes.
Yes, next.
92, sorry, 91.
I beg to appeal for the petition. 14(3), there was an order to, for investigation after to file the charge sheet of within 3 weeks, my lord. Already 3 months got over.
Filed,
Charge sheet has been filed. It is the scrutiny stage.
Scrutiny stage.
Filed and scrutiny stage. Scrutiny ಆಗಿ ಫೈಲ್ ಆಗದಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ನಾವು ಫೈಲ್ ಮಾಡ್ತೀವಿ.
ನೀವು ಫೈಲ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಕೋರ್ಟ್ ಮುಂದೆ ಹಾಕಿಲ್ಲ ಇನ್ನು.
ಅಲ್ಲ, ಕೋರ್ಟ್ ಮುಂದೆನೆ.
I have not received copy, my lord.
Scrutinize that.
You are the accused.
Yeah, please, my lord, please.
2017 ಇಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ?
ಅಲ್ಲ, ಅದೇ this is the matter, my lord, initially with.
Affidavit ಹಾಕ್ಸಿದ್ದೆ ಇದೆ.
ಹೌದು.
That's the investigating officer.
Yes, present investigation.
The learned counsel, learned additional SPP C. Jagadish, on instructions from the investigating officer who is present before the court, would submit that the charge sheet is filed before the. Sorry, sir. We inject. Mistake again. Yes. So, on instruction, submit that the charge sheet is is filed and is being scrutinized before the concerned court and would be numbered any moment.
They seems to have raised some objections.
And would be numbered once the objections so raised are clear. The submission is ಇನ್ನೇನು ಉಳಿತಿಲ್ಲ? ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ. Submission is placed.
Time frame ಮಾಡಿ.
Submission is placed on record. The petition, in the light, the subject petition was entertained only on the score of divulgence of reason as to why the charge sheet was not filed despite passage of 6 years.
7 years.
6 years, 6 or 7 years. The learned additional SPP had filed an affidavit of the investigating officer as to why why it could not be filed. The reason was found plausible, and therefore, in the light of the aforesaid circumstance of the charge sheet being presented before the concerned court, I deem it appropriate to dispose the petition, reserving liberty to the petitioner to avail of such remedy as is available in law once the charge sheet is filed before the concerned court. Ordered accordingly. ಯಾರು ಇವರು? ಅಪೂರ್ವ SK ಅಂದ್ರೆ ಇವರೇನಾ? Yes. ಅಲ್ಲಿ ಮೇಲೊಂದ್ ಕಡೆ ಬರ್ಕೊಳ್ಳಿ. ಅಪೂರ್ವ SK, the investigating officer is present before the court, presence is noticed. Yes. ಇದೇನು ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗಿದೆ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್?
ಇಲ್ಲ, ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗಿಲ್ಲ.
ಮತ್ತೆ
pursuant to the direction passed by the Samala.
ನೀವು ಒಬ್ರು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಗೊತ್ತು, ಅಲ್ಲಿ ಪಾರ್ಟೀಸ್ ಇನ್ ಪರ್ಸನ್ ಯಾರ್ಯಾರು? ಯಾರಿಲ್ಲ
Sorry.
ತಾನೆ? ಹಾ, ಸರಿ.
Pursuant to the
ಕಾರು
direction,
ಬ್ಯಾಂಡ್ ಹಾಕಿಲ್ಲ. ಹಾ. Yes.
pursuant to the direction issued by the Samal Court. At
ಅಲ್ಲ,
local,
ಈಗ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದಾರಂತ.
the Tahsildar has filed a complaint against me. Based on the complaint,
ಅದನ್ನ ಸ್ಟೇ ಮಾಡಿದೀನಲ್ಲ ನಾನು.
ಅದ್ರಲ್ಲಿ stay ಆಗಿದೆ.
ಹಾ.
That it is.
Wash ಮಾಡ್ಬೇಕು.
Wash ಮಾಡಿ.
My submission,
I have
my lord.
submitted the
Respondent, I appear for on behalf of respondent number 2 complaint.
ತಹಶೀಲ್ದಾರ? ವೆರಿ ಗುಡ್. ಎಸ್, 10 ಲಕ್ಷ ಕೇಳಲಿಲ್ವಾ?
I have never demanded.
ಆಡಿಯೋ ರೆಕಾರ್ಡಿಂಗ್ ಇದೆ ಸರ್.
Is not with somebody's.
ಇವ್ರು ಕೇಳಲಿಲ್ಲ ಬಿಟ್ಬಿಡಿ. ಯಾರಿಗೂ 10 ಲಕ್ಷ ಯಾಕೆ ಕೇಳಿದ್ರಿ?
Who is none other than his advocate. He's appeared.
ಅಡ್ವೊಕೇಟ್ 10 lakhs ಕೇಳಿದ್ರ?
ಅಲ್ಲ, ಅವರೇ ರೆಪ್ರೆಸೆಂಟ್ KT ನಲ್ಲಿ ಮ್ಯಾಟರ್ಗಳು ಆಗ್ತಾ ಇದ್ರು. ಅವ್ರದ್ದು
ಅದಕ್ಕೆ
ಅಡ್ವೊಕೇಟ್.
ಏನಕ್ಕೆ ಕೇಳಿದ್ರಿ?
ಈ ಮ್ಯಾಟರ್ ಸಂಬಂಧ
ಯಾವ ಮ್ಯಾಟರ್ಗಾರ? ತಹಶೀಲ್ದಾರ್ 10 ಲಕ್ಷ ತಂದ್ಕೊಡಿ ಅಂತ ಫೋನಲ್ಲಿ ಯಾಕೆ ಕೇಳ್ಬೇಕು? Why should a Tahsildar, a public servant,
not in
ask any person to give 10 lakhs?
not in respect of
ಏನ್ TDS ಕಟ್ ಮಾಡಿ ಚೆಕ್ ಅಲ್ಲಿ ಕೊಡಕ್ ಕೇಳಿದ್ರ?
ಅಲ್ಲ,
ಇಲ್ಲ, ಕ್ಯಾಶ್ ಕೊಡಕ್ ಕೇಳಿದಿರ?
not in respect of this subject matter.
Maybe with respect of any subject, sir. Why did a Tahsildar ask 10 lakhs to be given?
Lord,
And how has he gone on scot free till now?
Lord, one Umesh, he is the advocate of second respondent. He is filed applications before the KT and the transferring matter. He was retired, already retired, my lord.
ಸರಿ.
Lord,
Sir,
29/7.
ಯಾವುದಕ್ಕೆ ಈಗ ಈ ಕೇಸಲ್ಲಿ ಕೇಳಿಲ್ಲ. ಆಡಿಯೋ ರೆಕಾರ್ಡಿಂಗ್ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್ that 10 lakhs you have demanded. May not be from him. ಯಾರಿಂದ ಡಿಮಾಂಡ್ ಮಾಡಿರೋದು?
ಇಲ್ಲ, ಅವ್ರ ಹತ್ರನೂ ಮಾಡಿ.
The Tahsildar has to the Umesh.
ಉಮೇಶ್ ಯಾರು?
Umesh is advocate, own advocate.
ಓನ್ ಅಡ್ವೊಕೇಟ್.
ಅಂದ್ರೆ
ಓನ್ ಅಡ್ವೊಕೇಟ್.
second respondent
He is an advocate. He was appearing for Tahsildar in the service matter, KT.
ಆಲ್ ರೈಟ್.
So therefore.
ಅಲ್ಲ, ಅಡ್ವೊಕೇಟ್ ತಹಶೀಲ್ದಾರ್ ಇಂದ 10 ಲಕ್ಷ ಫೀಸ್ ಕೇಳಿದ್ರೆ ಅರ್ಥ ಇದೆ. ತಹಶೀಲ್ದಾರ್ ಅಡ್ವೊಕೇಟ್ ಇಂದ 10 ಲಕ್ಷ ಯಾಕೆ ಕೇಳ್ತಾರೆ?
ನಾಟ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಸಬ್ಜೆಕ್ಟ್. ಅದು ಏನಕ್ಕೆ ಅಂತ ಅವ್ರು
ಏನಕ್ಕೆ ಅಂತ ಅದೇ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಬೇಕು.
ಲೆಟ್ ದಮ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ವಾಟ್ ಹ್ಯಾಪನ್.
ನೀವು ಹೇಳ್ತಿರೋದು ಯುವರ್ ಓನ್ ಅಡ್ವೊಕೇಟ್ ಅಂತ. ಯುವರ್ ಓನ್ ಅಡ್ವೊಕೇಟ್ ಆಸ್ಕಿಂಗ್ ಫೀಸ್ ಆಫ್ 10 lakhs. Whether Tahsildar ಕೊಡ್ತಾರೋ ಬಿಡ್ತಾರೋ ಬೇರೆ ಮಾತು. Advocate is entitled to ask.
Is not a phone, any phone call to him. My lord,
ಉಮೇಶ್ ಅಂತ ಮಾಡಿದಾರ?
ಅವ್ರ ಕ್ಲೈಂಟ್ ಮಾಡಿದಾರ. ಅವ್ರು ಉಮೇಶ್ is called to.
ಹೌದು ಸರ್, ಅದನ್ನೇ ಕೇಳ್ತಾರೆ. 10 ಲಕ್ಷ ಯಾಕೆ ಕೇಳಿದ್ರಿ?
ಏನು ಮೇ ಬಿ ಫೀಸ್ ಅದು ನಾಟ್ ಇನ್
ಫೀಸ್. ತಹಶೀಲ್ದಾರ್ ಯಾವಾಗಿಂದ ಫೀಸ್ ತಗೊಳಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರು?
Not in respect of this subject, my lord.
Whatever it is, when did Tahsildar begin taking fees from clients?
After disposal of the appeal, he filed a complaint on 19th.
ಹೋಗ್ಲಿ ಬಿಡಿ, ತಹಶೀಲ್ದಾರ್ ಯಾಕೆ ಕೇಳಿದ್ರು ಅದ್ ಕೇಳ್ತಿರೋದಷ್ಟೇ.
ಅಲ್ಲಿ ಇವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿಲ್ಲ, ಅದ್ ಹೆಂಗ್ ರೆಕಾರ್ಡ್?
ಯಾರಿಗೋ ಮಾಡಿದೀರಾ? ಮಾಡಿ 10 ಲಕ್ಷ ಕೇಳಿದ್ರೆ ಇಲ್ಲಿ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
ಮತ್ತೆ ಇವರು ಏನೋ ಮಾತಾಡಿದಾರೆ. ಐ ವಿಲ್ ನಾಟ್ ಪ್ಲೇಸ್ ದಟ್ CD. ಇವರು ತುಂಬಾ ಮಾತಾಡಿದ್ದಾರೆ. ಅದನ್ನ ತುಂಬಾ ಎಂಬ್ರಾಸ್ಮೆಂಟ್ ಆಗುತ್ತೆ ಕೋರ್ಟ್ಗೆ. ಅದಕ್ಕೆ ನಾನು.
ಹೌದಾ? ಇದು ಕೊಡಿ.
ಅದೇನೇನೋ ಮಾತಾಡಿದ್ದಾರೆ. ಐ ವಿಲ್ ನಾಟ್ ಪ್ಲೇಸ್ ಇಟ್.
ಏನೇನ್ ಮಾತಾಡಿದ್ದಾರೆ? ನಥಿಂಗ್.
ಎಂತ ಅಲ್ಲ, with respect to the transfer of Kata, that Umesh is my relative.
ಬೇರೆ ತರ ಏನೇ ಇದೆ, ಅದಕ್ಕೆ ಐ ವಿಲ್ ನಾಟ್ ಪ್ಲೇಸ್ ಇಟ್. ದಟ್ ಒನ್ ಹರ್ಡ್ ಅಬೌಟ್.
ಬೇರೆ ಏನೇನು ಕೋರ್ಟ್ ಬಗ್ಗೆ ಎಲ್ಲ ಹೇಳಿದಾರ?
ಕೋರ್ಟ್ ಬಗ್ಗೆ ಎಲ್ಲ ಏನೇನೋ ಮಾತಾಡಿದ್ದಾರೆ. ಐ ವಿಲ್ ನಾಟ್ ಪ್ಲೇಸ್ ಇಟ್.
ಮಾತಾಡಿ, ತೊಂದರೆ ಇಲ್ಲ. ಬಟ್ ಈ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದಾರಲ್ಲ,
ಇನ್ವೆಸ್ಟಿಗೇಷನ್
ಕೋಆಪರೇಟ್ ಮಾಡಿ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್
ವಿಲ್ ಕೋಆಪರೇಟ್.
ಅದ್ರ ಪಾಡ್ಗೆ ಅದಾಗುತ್ತೆ.
So far as his case is,
I will quash this.
that is only I objecting.
ಏನ್ ಹೇಳಿ?
Lord, 29/7/2024, one Nanjundappa sons is filed application for a transfer of revenue records. One Prasanna, as per annexure R2, my lord, Prasanna is filed statement of objections to objecting for transfer of Kata. My lord, then Tahsildar initiated the proceedings, RRT proceedings. Then that proceedings, the advocate is petitioner is appeared. He asked for genealogical tree and other documents. He is objected for producing that. My lord, then my lord, 15/10/2024 order sheet speaks. He passed the orders saying that entire the property Kata was not rejected. Passed order in favor of the applicant, saying that property Kata to be registered. The family members of the he's objecting is that my lord, he want to register in one name, against which that order, my lord, he filed appeal also before the assistant commissioner. Then my lord, after disposal, my lord, 18/10/2024, he want to advance the application. That only some
altercations have happened.
Then the Tahsildar has filed a complaint.
ಅಷ್ಟೇನಾ sir?
Yes.
When he has not received the complaint, he lodged the complaint before the Lokayukta saying that he demanding 10 lakhs.
ಕರೆಕ್ಟ್ ಆಗಿ ಇದೆಯಲ್ಲ ಅದು ಆಡಿಯೋ
After disposal.
ಆಡಿಯೋ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಇದೆ.
After disposal of the appeal.
ಪ್ರೀಪೇಡ್ ಪೋಸ್ಟ್ ಪೇಡ್ ಒಟ್ನಲ್ಲಿ ಕೇಳಿದ್ದು ಹೌದು.
No date, time, nothing, my lord. Let them investigate the matter, my lord.
ನಿಮ್ದು ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ಲೇಬೇಕು.
ನಮ್ದು ಮಾಡ್ಲಿ,
ಅವ್ರದ್ದು ಯಾಕೆ ಮಾಡ್ಬೇಕು? 353 is the allegation. ಏನ್ ಬೈದ್ ಬಿಟ್ರ ಇವ್ರು ನಿಮ್ಗೆ?
ಗಲಾಟೆ ಮಾಡಿದ್ದಾರೆ ಅವತ್ತು ರಜೆ ದಿನ.
ನೀವು 10 ಲಕ್ಷ ಕೇಳಿದ್ದು ಗಲಾಟೆ ಮಾಡ್ಲೇಬೇಕು.
ಅವ್ರು ಕೇಳೇ ಇಲ್ಲ, ಅವರು
Anything else? Yes, the petitioner, a practicing advocate appearing in person is before the doors of this court, calling in question a registration of a crime in crime number 223 of 2024 registered for offences punishable under section 132 of the BNS, which is 353 of the earlier regime, the IPC. Facts in brief, germane, are as follows. The second respondent is the complainant. The petitioner, the second respondent, the Tahsildar, Yava Ajjampura police, Ajjampura Taluk, is the complainant in the case at hand. The petitioner appears before the Tahsildar seeking mutation of kata in favor of the legal representatives of his client. It transpires at that point in time there are certain altercations between the petitioner and the Tahsildar. The Tahsildar passes an order against which the petitioner is said to have preferred an appeal. Appeal is in your favor?
Appeal is said that Tahsildar order is set aside and remanded back to
the appellate authority, the assistant commissioner, sets aside the order of the Tahsildar and remits the matter back to the hands of the Tahsildar for consideration of fresh of the claim of the petitioner's clients, petitioner's clients. After the said remand, the petitioner registers a complaint before the Karnataka Lokayukta with certain evidence of conversation recorded in a compact disc to the Lokayukta, recorded in a compact disc, alleging that the second respondent Tahsildar had demanded rupees 10 lakhs as alleged bribe, not from the petitioner but from one Umesh. The recording was not taken to its logical conclusion, nor a crime was registered against the Tahsildar. In turn, the crime was registered against the petitioner for alleging that the petitioner has raised his voice or has abused the Tahsildar who was performing his public duty at the point in time. And therefore, therefore the complaint becomes a crime in crime number 223 of 2024 for offence punishable under section 132 of the BNS 2023. It is at that juncture the petitioner is at the doors of this court calling in question the registration of a crime in crime number 223 of 2024. The petitioner in person would contend that the Tahsildar has registered the subject complaint as a counterblast to the complaint so registered by the petitioner before the Lokayukta, which had not yet resulted in registration of a crime. He would submit that none of the ingredients as is necessary in law as laid down by the apex court in several judgments is met in the case at hand insofar as it concerns the offence under section 132 of the BNS bracketally 353 of the IPC. Per contra, the counsel appearing for the second respondent complainant, the Tahsildar, would submit that the petitioner has in fact hurled abuse upon the Tahsildar at the time when he had visited him for preponement of the case after the remand from the appellate authority.
After disposal.
After the disposal, the Tahsildar dispose ಮಾಡ್ಬಿಟ್ಟಿದ್ರು.
Our dispose ಆದ್ಮೇಲೆ he filed a complaint.
After the disposal of the proceedings before the Tahsildar, he would submit that it's a matter of investigation, and the investigation, the court should not, in exercise of its jurisdiction under 482 of the CRPC, interfere at this stage of the proceedings. The learned additional SPP should be in Jagdish would also submit that the matter is still at the stage of investigation and therefore this court should not interfere with the said proceeding. I have given my anxious consideration to the submissions so and so. The afore narrated facts, link in the chain of events and the dates are all a matter of record. What drives the petitioner to the Lokayukta is the complaint so registered by him. Tell the complaint.
Annexure C page.
Complaint registered by him, Annexure C, page 18. The complaint in the narration in the complaint is that the Tahsildar has hurled abuses and has demanded money. The Lokayukta does not take any action. In turn, the Tahsildar registers a complaint on 19/10/2024 against the petitioner for alleging that the petitioner has spoken in loud voice and abused in the chamber of the Tahsildar. In the chamber of the Tahsildar. So, Tahsildar, therefore, it becomes a crime in crime number 223 of 2024. The issue now would be whether the complaint so registered, quote madidina? The complaint so registered by the Tahsildar, the complaint reads as follows, 19/10/24 reads as follows, page 12. The complaint so registered by the Tahsildar would meet the ingredients of section 353 of the IPC/132 of the BNS. Section 353 of the IPC directs or punishes a person who would stop a public servant from performance of his duties by use of criminal force. Criminal force or assault as the case would be. Section 329, 349 to 351 define what is assault and what is criminal force. If the ingredients as is found in section 349 and 351 are noticed, none of those are present in the complaint so registered against the petitioner. Therefore, it would not become an offense under section 353 of the IPC or 132 of the BNS. Permitting further proceedings against the petitioner would be permitting a complaint that is registered as a counterblast to what the petitioner had registered against the Tahsildar before the Lokayukta. The apex court in the case of Bhajan Lal was said Haryana was Bhajan Lal 1990 para 102 extract has laid down 7 postulates of entertainment of a petition at the stage of crime in excise of jurisdiction under section 482/528 of the BNS. In the light of the law so laid down by the apex court in Bhajan Lal as the apex court considering what would be the purport of section 349, 351 and 353 of the IPC has in SLP 5905 of 2022 disposed on 21/10/2024 in the case of KV Dhananjay versus State of Karnataka has held as follows, paragraphs held in the light of the law laid down by the apex court in the case of KV Dhananjay versus State of Karnataka, which applies to the facts of the case at hand on all its force, FOURS, on all its force. Permitting further proceedings would become an abuse of the process of the law. It would become apposite, APPO, apposite to refer to the judgment of the apex court in the case of State of Haryana versus Bhajan Lal. So in para 102 clause 157 highlight madi. In the light of the aforesaid judgments, the apex court, I deem it appropriate to excise jurisdiction under 408 of the CRPC and obliterate the crime against the petitioner for the aforesaid reasons allowed quashed. Yes.
93.
I appear for respondent number 3 in this matter. FSSA.
Yes, sir.
Lord,
2012, no adjournment. Yes. No adjournment. Whatever face you make, no adjournment. Don't cut a sorry figure. Yes. How long are you here?
I'm sure
Till the Supreme Court is on vacation.
Yes.
Yes.
My Lord, I've prepared a note with regard to the food standards, my Lord, Act.
One moment. Sorry. One day, ಏನ್ sir? ಅದು the same order will be passed. Yes, same. ಅದರಲ್ಲಿ ಅಲ್ಲಿ ಸ್ಫೂರ್ತಿ ಹೆಗಡೆ, ಹರ್ಡ್ ಸ್ಫೂರ್ತಿ ಹೆಗಡೆ ಅಂತ ಹಾಕ್ಬಿಡಿ.
Acceptable, sufficient.
ಯಾವ್ದ್ರಲ್ಲಿ?
Page number 92, 330 matter.
ಈಗ ತಗೊಂಡಿರೋದೇ 330 matter sir.
Page number 92, family matter.
14%. 92. ಬೇರೆ ಕೋರ್ಟ್ದಲ್ಲಿ. ಈ ಕೋರ್ಟ್ದ ಬೇರೆ ಕೋರ್ಟ್ದ?
96.
ಇದೇ ಕೋರ್ಟ್. ವೇಟ್, ಎಸ್. ಫುಡ್ ಸೇಫ್ಟಿ ಇದಲ್ಲ ಸರ್? ಎಸ್ ಮೇಡಮ್ ತಗೊಳ್ಳಿದು ಸರ್.
Please look at the regulations, my lord. Sorry. We are challenging, my lord, the regulations. If your lordships, my lord, look at, my lord, the regulations which are challenged at the bottom, my lords have got in the first page. Indian cuisine, my lord, has hundreds of this thing. Now please come to the next page. Food operator shall ensure that the registering or licensing authority always has up-to-date information on their food business establishment. My lord, food business establishment, these are all, my lord, all restaurants. Even a one-man, my lord, one-man restaurant or one-man, my lord, food joint, they are bound by this. Therefore, my lord, please look at, my lord, page 2.
Chefs are running food joints now, no problem. They are bound, yes. Yes, sir.
Chefs, my lord, are running. What happens is one man, my lord, like our canteen here, one man, or my lord, there's smaller canteen.
Yes.
Therefore, my lord, please look at, my lord, what is it that
Yes, sir. Page
I am
2.
required? Page 2, my lord.
Sir.
Page 2.
Yes.
Regulation 2.1.9.
Yes, sir.
What does it say? Food business operator shall ensure that the registering or licensing authority always has up-to-date information on their food business establishment, shall inform the relevant authority of any modification or additions or charges in product category, layout, expansion, closure, any other material information based on which the license was granted. In fact, my lord, what has happened is, there is a codex, my lord, in America, there is what is known as codex. They virtually copied it in this. Now, please come to, my lord, what is it that we have said? On, my lord, the right hand side, my lord, regulation. As stated above, Indian cuisines, my lord, there are a number of dishes which are not produced on a daily basis. Special occasions, my lord, we do that. My lord, if I have to, my lord, keep on giving, my lord, information, it's virtually impossible. This is one. Anyway, my lord, that may not be the major this thing. Now, please come to the third page. Every licensee shall.
Yes, sir.
Page, my lord, regulation 2.1.13.1. Every licensee shall on or before the 31st of May every year submit a written, electronic or physical form as may be prescribed by the concerned Food Safety Commissioner in Form D1, provided in Schedule 2 of these regulations of licensing authority in respect of each class of food items handled by him during the previous year. Hotels, my lord, handle, my lord, number of raw materials, food items in a day. Difficult to maintain, my lord, in respect of everything. Somebody comes, my lord, says that I want upma. Somebody comes and says, adhik ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇದು ಹಾಕಿ ಇವತ್ತು ಇನ್ನೊಂದೇನೋ ಮಾಡಿ. This is one. That also may not be major, but please come to the next one. This is more important. All raw materials.
Indian food ಮಾತ್ರನಾ?
ಹೌದು.
What about Burmese, Chinese, Japanese?
ಅಲ್ಲ, all restaurants, all restaurants. All restaurants. Please come to, my lord, next page 33 ನಲ್ಲಿ last.
Yes.
All raw material, food additives, ingredients, wherever applicable, shall conform to the regulations and standards. Standards fixed by, my lord, in the regulations very high, and some of them are impossible of compliance. I'll point out because ತಾವು ಮುಂದಕ್ಕೆ ಬಂದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
Yes.
Next, food raw materials, regulation 5.1.3. Additives and ingredients as well as the sources of procurement shall be.
ಅಂದ್ರೆ everything is regulated.
ಹೌದು. ಅದು ಮಾತ್ರ ಅಲ್ಲ, ಮಿಲ್ಕ್ ಗೆ ಇಷ್ಟು ಫ್ಯಾಟ್ ಇರಬೇಕು. ಅದು ಹಸು ಅಥವಾ ಎಮ್ಮೆ ಅದು ಏನ್ ತಿನ್ನುತ್ತೋ ಅದೇ ನಾನು ತೋರಿಸ್ತೀನಿ ನಿನ್ನ ಮುಂದೆ.
ಇಲ್ಲ, ಅದು ಆಮೇಲೆ ನೀರಿಗೆ ಹಾಲಿಗೆ ನೀರೋ ಗೊತ್ತಾಗಲ್ವಲ್ಲ, ಅದಕ್ಕೆ ಫ್ಯಾಟೇ ಇರಲ್ಲ ಅದ್ರ. Every milk has today become skimmed milk.
Of course.
Yes.
That skim milk ಅದೆಲ್ಲ ಇರುತ್ತೆ.
Yes.
Records of all raw material, food additives, ingredients as well as sources of procurement shall be maintained in register.
Yes, sir.
There has to be a register. Then next page 5. A well-equipped laboratory for testing of food material, food physical, microbiological.
It should be at the restaurant.
Yes. He must have. Otherwise, my lord, he'll have to send. ಅದಕ್ಕೆ ಇದು ಹೇಗೆ ಅಂತಂದ್ರೆ ಬೆಳಿಗ್ಗೆ ಚಟ್ನಿ ಮಾಡಿ idli ಮಾಡಿ I'll have to, my lord, I don't have a small joint, I don't have a laboratory, so I'll have to send, my lord, chutney for testing. By the time, my lord, I'll have to give idli, my lord, without chutney, and by the time, my lord, that laboratory tests it and brings it back, it will have gone.
Chutney
it
would
was
have
spoiled.
gone.
Anyway,
Yes.
now, my lord, on the right side, what is it that I have said? Regulation relating to food testing facility, equipment, laboratory within the space of business cannot be made applicable to hotels for reasons that the establishment of laboratories also for testing food material would cost around 1 crore rupees. My lord, microbiological, physical, chemical analysis, everything. And
So this is irrespective of the size of the restaurant.
Yes, yes, yes.
Food cart gain ಮಾಡ್ತೀರಾ? A lot of food carts today. How have you regulated that? No food safety. Allah, food trucks. So many food trucks everywhere. Of course, they're better than restaurants sometimes. But how have you regulated them?
But it needs to be answered.
Idu again, it has to be tweaked to a large extent where you have to bring in the latest, this 2012 regulations. You may have to.
ಅದು ಮಾತ್ರ ಅಲ್ಲ, ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ, my lord, my lord, Indian scenario must be borne in mind, my lord, when we frame a regulation. I can't, my lord, codex ಇದು ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಹಾಕೋಕ್ಕಾಗಲ್ಲ. Now next page ತಗೊಳ್ಳಿ, ಹೇಳ್ತೀನಿ. ಇನ್ನು
No, it is be Indian, think global.
Of course, I agree.
Yes.
And people, my lord, today, my lord, one of our astronauts is wanting to go, my lord.
Yes, yes, that is why, sir. Yeah.
I know.
All over the globe.
Correct. Lord, insofar as the regulations are concerned, my lord, it is for him, my brother to answer it. That
But if what senior counsel says, you really laboratory ಇಟ್ಕೋಬೇಕು restaurant ಅಲ್ಲಿ.
My lord, I read it, my lord, it.
Insofar as regulation is concerned, we'll have to say that how to be substantial. So far as section 50 to 60,
Did you want to say your no? Objection.
Inconvenience today, kindly 2 days time may be granted.
Then next page, page 6 ಅಲ್ಲಿ, regulation 7.3.
No restaurant can comply with this.
7.3, page 6. If there is no in-house laboratory facility, then regular testing shall be done through an accredited lab notified by FSSA. In case of complaint received and if so required, the company shall voluntarily do the testing either in the in-house laboratory or an accredited lab. ಇನ್ನೂ ಇದೆ, ಸುಮಾರಿದೆ, ತೋರಿಸ್ತೀನಿ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಮನೆಯಲ್ಲಿ ನಾವು ವಿ ವಿಲ್ ಪ್ರಿಪೇರ್ ಮಲಾಟ್ ದ ಫುಡ್, ಅದನ್ನ ಮಧ್ಯಾಹ್ನ ತಗೋತೀವಿ, ಬೆಳಿಗ್ಗೆ ಇಲ್ಲದೆ ಇದ್ರೆ ಮಧ್ಯಾಹ್ನ ತಗೋತೀವಿ. ಇದೆಲ್ಲ ರೀಹೀಟ್ ಮಾಡೋದು ಇಲ್ಲ, ಅದೆಲ್ಲ ತೋರಿಸ್ತೀನಿ.
ಮೈಕ್ರೋವೇವ್ ಇನ್ನೇನು
ಸರಿ, ಅದು ಮಾಡಂಗಿಲ್ಲ.
ನೋ ರೀಹೀಟಿಂಗ್ ಫುಡ್.
ನೋ ರೀಹೀಟ್.
ಎಸ್ ಸರ್.
Then page 6, regulation 8, appropriate records of food processing, preparation, product production, cooking, storage, distribution, service, food quality, laboratory accessories, cleaning.
How do you regulate this also? Refrigerator should be kept at 5 degrees Celsius. ಯಾರು ನೋಡ್ತಾರೆ ಅದನ್ನ?
Practically not possible.
What is this? You should bring in some regulation where there can be some vigil and vigil can regulate it. ಏನಿಲ್ಲ, 5 ಡಿಗ್ರಿ ಇಟ್ಟಿದಾರೋ ಇಲ್ವಂತ ಏನ್ ರೆಗ್ಯುಲೇಟ್ ಮಾಡ್ತೀರಾ? Someday you will inspect, it shows 7 degrees. Issue a show cause notice. This is what you will do. Regulator needs to be regulated first. Amel regulations. Yes, sir.
Salads, page 8 ಅಲ್ಲಿ, of course, ತಾವು ಸ್ವಲ್ಪ ಮುಂದೆ
Chilled food intended for consumption should be cold enough. What do you mean should be cold enough? ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು ಕೋಲ್ಡ್ ಇರ್ಬೇಕದು? ಅಲ್ಲ, you have said chilled food intended for consumption should be cold enough. What sort of regulation?
Vague.
What vague? Cold according to you or according to the consumer?
Has to be according to me, which.
ಫುಡ್ ತಗೊಂಡು ಹೋಗೋದು ಪ್ಯಾರ 9 page 9 ತೊಡೆದ್ರೆ ಆ ವ್ಯಾನ್ ಬೇರೆ ಯಾವುದಕ್ಕೂ ಉಪಯೋಗಿಸಂಗಿಲ್ಲ.
Vehicle, van transportation, processed food should be clean. ಅಲ್ಲ,
clean ಆಯ್ತು.
Laudable object in everything.
No difficulty. Next, dedicated for this purpose should not carry anything else.
The, because my lord,
ಅದೇ ಹೇಳಿದ್ದು ಕೋಡೆಕ್ಸ್.
Sir, we need not ape the West. We should re-Indianize Indian things. It's enough of aping the West. We'll pass orders. ಮತ್ತೆ ಯಾಕೆ? Why are you cutting a sorry figure again? I know your regulations are bad, but what to do? Huh? You want to defend that? Objection ಹಾಕಿದಿರಲ್ವಾ? ಮತ್ತೇನು accommodation? What Doreraj? You are not ready ಅಂದ್ರೆ it is impossible to accept. Doreraj should not seek time.
ಅಲ್ಲ ಇದು ಮಾತ್ರ ಅಲ್ಲ, ಇನ್ನೊಂದು ನೋಡಿ, ಇದೊಂದು ಲಿಸ್ಟ್ ನೋಡಿ.
ಅದೇನು ಸರ್?
ಇದೆ ಸೇಮ್ ಅದರಲ್ಲೇನೆ ರೆಗ್ಯುಲೇಷನ್ ಅಲ್ಲಿ. I'll give them also.
You want to submit? Wait.
ಹೌದ್ರಿ, ಇದು ಹಿಂದೆ ಮುಂದೆ ಎಲ್ಲ ಮಾಡಕ್ಕೆ. ಒಂದು ನಿಮಿಷ.
ಇದರಲ್ಲಿ ಯಾವ ರೆಗ್ಯುಲೇಷನ್ಸ್?
My lord, my lords are having, my lord, that analysis of the act and, sorry.
ದೊರೆರಾಜ್, ನೀವ ಮಾಡಿರೋದು ಇದು? ಅಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಮ FKCCI.
ಹೌದು.
ಮೈದಾ should be 14% moisture, 2% ash. Ash soluble in dilute hydrochloric acid, HCl. Gluten 6%. Alcoholic acidity 0.8%. Expressed in ಏನಿದು H2SO4. Hydrochloric sulfuric acid. ಯಾಕೆ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡ್ತೀರಾ? ನಿಮ್ದು ಯು ಅಕಾರ್ಡಿಂಗ್ ಟು ದಿ ಇಂಡಿಯನ್ ಇದು ಯು ಶುಡ್ ಡೂ ಸಮ್ ರೆಗ್ಯುಲೇಷನ್. ಎಲ್ಲ ಅಮೆರಿಕನ್ ರೆಗ್ಯುಲೇಷನ್ ತೆಗೆದು ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡಿದ್ರು. ಯುರೋಪ ಅಮೆರಿಕದ? ಅಮೆರಿಕನ್. ಮತ್ತೆ ಪ್ರೆಸೆಂಟ್ ಅಮೆರಿಕನ್ಸ್ ಹ್ಯಾವ್ ಗಿವನ್ ಅಪ್ ಆಲ್ ದಿಸ್.
ಫ್ಯಾಟ್ ಇಷ್ಟು, ಇದು ಇಷ್ಟು,
ಅದೇ ಎಲ್ಲ ಇದೆ. ಅದು ಎಕ್ಸ್ಪ್ರೆಸ್ಡ್ ಆಸ್ H2SO4. ಆಯ್ತು. ಆಮೇಲೆ ಸೆಮೋಲಿನ ಶಾವಿಗೆ ಅದೇ ಎಲ್ಲ 6% ಆಲ್ಕೋಹಾಲಿಕ್ ಎಸಿಡಿಟಿ. ಅಮೆರಿಕಲ್ಲಿ ಎಲ್ಲಿದೆ ಶಾವಿಗೆ? ಅವ್ರು ಕೇಳಿದ್ರೆ ಥಿನ್ ಪಾಸ್ತಾ ಅಂತಾರೆ. wheat, jawar and bajra, rice shall confirm damaged grains, weevil grains, uric acid content in rice.
ಅಲ್ಲ ಇಷ್ಟಿರ್ಬೇಕು ಅಂತ ಅಲ್ಲಿ ಎಲ್ಲಿಂದ ಇದು? ಇನ್ಫ್ಯಾಕ್ಟ್ ನಮ್ಮಲ್ಲಿ one of the acts specifies that, my lord, in water you can have, my lord, X% of pesticide. ಅದು ಇದೆ.
ಅದೇ ಇದೆ.
What I am submitting before your lordship says,
but in coke it is more.
Of course,
you are entitled
that, of course,
yes.
adide. Now what I am saying is, this kind of, my lord, regulation is impossible of compliance. Oh no, everybody has shut shop, my lord, and
ಇದ್ರಲ್ಲಿ ಯಾವ ರೆಸ್ಟೋರೆಂಟ್ ಓಪನ್ ಆಗುತ್ತೆ? either you can't regulate, or if you want to regulate, nobody will open a restaurant.
Impossible of compliance.
Impossibility of compliance regulation should never be bought in. You can never regulate it. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು regulator should be regulated now. ಆಯ್ತು ಅಷ್ಟೇ. vehemently argued.
ಆಮೇಲೆ
you vehemently argued.
acts ಅನ್ನು ಇದನ್ನ ಅನಾಲಿಸಿಸ್ ಮಾಡಿರೋದು.
ಕೊಡಿಸಿ. ಶುಗರ್ ಮಾತ್ರ ಏನ್ ರೆಗ್ಯುಲೇಷನ್ ಇಲ್ಲ, ಎಷ್ಟು ಬೇಕಾದ್ರೆ ತಗೋಬಹುದು, ಏನ್ ಬೇಕಾದ್ರೆ ಇರ್ಬೋದು. ದಿ ಸಿಂಗಲ್ ಮೋಸ್ಟ್ ಡೇಂಜರಸ್ ಥಿಂಗ್ ಟು ಹ್ಯೂಮನ್ ಬಾಡಿ ಇಸ್ ಶುಗರ್. ಅದಕ್ಕೆ ರೆಗ್ಯುಲೇಷನ್ ಇಲ್ಲ. ಎಸ್,
ಇನ್ಫ್ಯಾಕ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ ಇದು ಹಿಂದೆ 4-4 ಸತಿ ಆರ್ಗ್ಯುಮೆಂಟ್
ಇಲ್ಲ
ಆಯಿತು.
ಇದೇನೆ
Judgment
now it
ಎಲ್ಲ
won't buck stops here.
I know that. Only thing is, my lord, ಅದರಲ್ಲಿ ಒಂದು ಕಂಪೈಲೇಷನ್ ಇದೆಯೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ, ನನ್ನ ಹತ್ರ ಇರ್ಲಿಲ್ಲ. ಅದಕ್ಕೊಂದು ಇನ್ನೊಂದಷ್ಟು ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ ಮಾಡಿದ್ದೇನೆ.
ಕೊಡಿ.
2 other compilations are already there. ಅಂದ್ರೆ almost similar.
I'll hear you, 2
provisions.
minutes, wait.
Idu subsequent ones, but if your lordships take, my lord, idu reasonableness ಬಗ್ಗೆ, please take, my lord, that larger volumes that I have given to your lordships.
Illides,
ಹೌದು,
it's here.
ಅದರಲ್ಲಿ ನೋಡಿ, first list ತಗೊಂಡ್ರೆ first aim list.
List of authorities then are list ಇದೆಯಾ sir? List of authorities ಕೊಟ್ಟಿರೋದು list ಇದೆಯಾ?
ಅಲ್ಲ ಮೇಲ್ಗಡೆ first.
Yeah, ಈಗ ಕೊಟ್ಟಿದ್ದು, yes.
ಅಲ್ಲ, no, my lord, each compilation I have prepared, my lord.
ಹೇಳಿದೆ ನೋಡಿ.
ಇಲ್ವಾ?
ಇಲ್ಲ, compilation.
ನೋಡಿ ಈ ತರದಿದೆ.
You can give it later.
I'll give it, my lord. I'll give it.
Will reserve,
Very well.
ಹೇಳಿ. He wants to submit.
Very well.
Yes, sir.
Insofar as the regulations are concerned, I would not like to comment anymore. But as far as the act is concerned, the Bombay High Court and the Supreme Court has dealt with the act and upheld the provisions of the act. Now, what they've
No,
challenged.
regulations are framed in exercise of power conferred under the act by
Yes,
them.
yes.
So they will have to perform such regulations which can be followed, implementable. I am not on the act.
No, because they have challenged section
No,
50 to 65 of the
don't
act.
worry
saying-
about that. Act we will not. Regulations are from the act.
Yeah, because
That
I'm
subordinate
only concerned
legislation
about-
will consider.
I'm only concerned about the act because all they point out is that the the penalties prescribed are very high. Because the penalties are prescribed very high because it is food which is concerned, which is right to fundamental. Right?
Absolutely. Penalty should be high if the regulation is correct.
Exactly. That is all I.
If you ask every restaurant to have a forensic lab with it,
I understand. I would,
then
it becomes a little difficult.
international standards ಗೆ ಹೋಗ್ಬೇಕು. 2012 ಅಂತೂ ಅದು ಇರಲೇ ಇಲ್ಲ. Today you can see some semblance of those standards, but where will you regulate all this? ಕೊಟ್ಬಿಡಿ, ಆಮೇಲೆ ತೊಂದರೆ ಇಲ್ಲ. Madras High Court, these regulations. ಆಯ್ತು ಕೊಡಿ.
Insofar as the act is concerned, the union has also filed a compilation of
Act,
judgments.
don't worry, sir. Act we will not.
Very.
Yes,
Act
heard
also
the-
is challenged, my lord. Some of the provisions, my lord, I
Yes.
point out, my lord, it's there. In my note, it is there. Let me not
Heard
waste
the
your time.
learned senior
Judgment
counsel.
ನನಗೆ ತಮ್ಮ ಹತ್ರ ಇಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ. ನಾನು
ಅದು
ಅದನ್ನ
compilation ಕೊಡಿ.
ಕೊಡ್ತೀನಿ, ಕೊಟ್ಟು ಮಾಡ್ಕೊಡ್ತೀನಿ.
Heard the learned senior counsel Uday Holla appearing for the petitioner, learned counsel Anuj so and so appearing for the, along with H. Shanti Bhushan, the DSGI appearing for the Union of India, and Doreraj representing the FICCI. FSSI. Oh, so and so. Heard, reserved. Whatever you want to give Doreraj. Yen bek kodi.
Initially, my lord, Madras High Court have granted interim order. Thereafter, interim order is vacated and that matter is dismissed.
ಅದು ಮಾತ್ರ ಅಲ್ಲ.
So it's impossible for anybody to even comprehend such a
Let me tell you, lordships. Several high courts, my lord, petitions had been filed. None of the high courts had granted an interim order. Matter came up before this court. I gave, my lord, this compilation. That is my note, first two notes on, my lord, what are the regulations, what it is. It came up before a judge who would not have granted an interim order. But he granted the interim order, my lord. Normally, he doesn't grant interim orders. He also was shocked, my lord, when I was shocked when I looked at it. Anyway.
Act ಅಲ್ಲಿ ಏನು problem ಇಲ್ಲ. ನಮ್ಮ
Act ಅಲ್ಲೂ
regulation.
ಸ್ವಲ್ಪ ಇದೆ, ನಾನು ತೋರಿಸಿದ್ದೀನಿ, ನನ್ನ note ಅಲ್ಲಿ
The
ಇದೆ.
power under the act is conferred upon them to frame regulations. If the regulations are framed like this, nothing will happen. Yes, we'll see.
Please,
Reserve.
I'll give
Yes,
that
ಅದು
compilation
ಕೊಟ್ಬಿಡಿ.
and
Yes.
ಮಾಡ್ಕೊಡ್ತೀನಿ. I thought it was here, otherwise ನಾನು ಇನ್ನೊಂದು extra ಮಾಡ್ಕೊಂಡು
No,
ಬರ್ತೀನಿ.
you can give it. Madam, ಇದು book ಯಾವ್ದಾದ್ರು ಇದ್ರೆ ಅದು ಇಟ್ಬಿಟ್ಟು ನೀವೇನ್ ಅಲ್ಲ ಇದು ಎಲ್ಲಿ ಇವ್ರು ಪೆಟಿಷನರ್ ಬರ್ತಾನೆ ಇಲ್ವಲ್ಲ? There is no representation on behalf of the petitioner.
On last occasion, there was an observation that if
Could
they
you-
don't appear, it will be considered.
Dismissed, huh?
Like it will be considered for disposal ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಒಂದು ನಿಮಿಷ ನೋಡಿ. appropriate orders. This court on 4/6/2025 had passed the following order. Like extensively heard on the after. There was no, 4/6/20, there was no representation by the petitioner on the said date. Even today, there is no representation. List day after tomorrow. In the event there would be no representation, the petition would be dismissed for its non-prosecution. No, chance ಕೊಡ್ಬಾರ್ದು. Yes.
95.
95 will take it next week. ಇದು CD ಇದಾ?
ಹೌದು.
ಎಲ್ಲಿ ಯಾರು ಅಂದಿದ್ದು? Yes, we'll take it on 1st July.
1st July. Obliged.
90.
96.
There was interim order directing the.
Senior citizens.
Petition. There was a direction by this honorable court to the jurisdictional police to assist the senior citizens to enter the premises. They have been dispossessed.
Lordship, I am ready for arguments. I am ready. Last occasion I was absent.
It was
My colleagues represent.
Tomorrow in preliminary hearing.
Please.
Yes.
Tomorrow better some day.
Tomorrow in preliminary hearing.
Right,
Yes.
tomorrow ನಾನು
Either I'll vacate the interim order.
Out of station. So I am ready to argue the matter. ಐ ಆಪರೇಷನ್
ನಾಲ್ಕು ready today argue the matter.
ಅಲ್ಲ ಸ್ವಾಮಿ ನನಗೆ ಐ ಆಪರೇಷನ್ ಅಂತ ಟೈಮ್ ತಗೊಂಡಿತ್ತು 1 week ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ. I am not able to read now also. Last week only I got eye operation. All the time I am ready for
Anyway,
address the
where
arguments.
is the government? Yes, Purti. Why police is not assisting? The learned AGA to secure instructions as to why the jurisdictional police is not cooperating to implement the order. If they would not do so, it would fringe on the borders of contempt. List the matter. ಯಾವತ್ತು ಬೇಕು?
Day after tomorrow.
List the matter day after tomorrow.
Day after tomorrow.
Yes.
Because it's an ex parte order.
No problem.
Yes, I am ready for merits of.
Police cannot say it's ex parte order.
Lordship, kindly see. Petitioners.
You can't see andre.
Petitioners are the first wife children. The second wife children and respondent is making so many criminal. I produced the photograph. ಬಂದು ಹೊಡೆದಾಗ
ಏನು ಹೇಳಿ ಈಗ?
ಅಲ್ಲ ಪೊಲೀಸ್ ಯಾಕೆ ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಪೊಲೀಸರೇ ಬಂದು ನೋಡಿದಾರೆ ಅಲ್ಲಿ. ಕ್ರೈಮ್ ಮಾಡಿರೋದು ಅವರು, ನಾವಲ್ಲ.
I am the owner of the property.
You ask your client.
He is not the owner. Suit for partition is there. We are taken loan. It is the
property.
first wife property. It is the first wife property.
False.
First wife property.
Yes, it is the first wife. That is
TVR, who are you?
Children, we are children
Of
first wife.
now who is the second wife?
All are present here, Swami.
ಯಾಕೆ ಬೇಡ ಅದೆಲ್ಲ ಕೇಳಲಿಲ್ಲ ನಾನು. First wife, second wife ಎಲ್ಲ ಹೇಳ್ಬೇಡಿ ಇಲ್ಲಿ.
ಅಲ್ಲ, because partition suit is pending. Assistant Commissioner passed an ex parte order to pay 5 lakhs. Act says in the section 9. He
Only
cannot
10,000 rupees.
10,000 rupees. How can he first file? And also, kindly see the order sheet. No opportunity has been given. He has been transferred. Newcomer come and pass an order.
Opportunity has been given, my lord. It's a self-acquired property, my lord.
No, my lord. I am ready to argue. Now itself I am ready to argue.
ಅದೇನೋ ಕಣ್ಣು ಸರಿ ಇಲ್ಲ.
ಕಣ್ಣಿದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ ಅವ್ರು ಪೊಲೀಸರು ಬಂದು ನೋಡಿದ್ದಾರೆ. ಐ ಪ್ರೊಡ್ಯೂಸ್ ಫೋಟೋ ನೋಡಿ ಸ್ವಾಮಿ, ಇದೆ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಹಾಕಿದೆ.
ಏನ್ ಕಣ್ಣು ನೋಡಿದಾರ?
ಅಲ್ಲ ಕಣ್ಣು ಆಪರೇಷನ್ ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಆಗಿದೆ.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
ಅದಕ್ಕೆ ಪೊಲೀಸ್ ಬಂದು ನೋಡಿ ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ಲ.
ಆಯ್ತು, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
ಅದಕ್ಕೆ ಕೈಂಡ್ಲಿ ಕನ್ಸಿಡರ್ ಮೈ ರಿಕ್ವೆಸ್ಟ್ ಅಂಡ್ ಕೈಂಡ್ಲಿ ದಯವಿಟ್ಟು ನಾಡ್ದು ಮಾಡಿಬಿಡಿ ಸ್ವಾಮಿ. ಐ ಟೇಕನ್ ಸೋ ಮೆನಿ, ಆಲ್ ದಿ ಟೈಮ್ ಐ ಆಮ್ ಪ್ರೆಸೆಂಟ್. ಇವನ್ ಧಾರವಾಡ ಬೆಂಚ್ ಅಲ್ಲಿ ಇದ್ದವನು ನಾನು ರೆಡಿ ಹೇಳಿದೆ ಸ್ವಾಮಿ ಆನ್ಲೈನ್, ಬಟ್ ಅವ್ರು ಬಂದಿರಲಿಲ್ಲ. ಟ್ವೈಸ್ ದೇ
ಮ್ಯಾಟರ್ ಡಿಡ್ ನಾಟ್ ಕಮ್ ಟು ಧಾರವಾಡ.
ಇಲ್ಲ,
ಟ್ವೈಸ್ ಮ್ಯಾಟರ್ ಕೇಮ್ ಬಿಫೋರ್ ದಿ ಧಾರವಾಡ ಬೆಂಚ್. ಲಾಸ್ಟ್ ಐ ಆಪರೇಷನ್ ಇದಕ್ಕೆ ಅದ್ವೈಸ್ ಡಿಸ್ಮಿಸ್ ಅಂತ ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀರಾ ಸ್ವಾಮಿ.
ಐ ಆಪರೇಷನ್ ಇದ್ರು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ
ಮಾಡಿದ್ರೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಆರ್ಡರ್ ಶೀಟ್ ಸ್ವಾಮಿ.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ.
ಸಬ್ಮಿಷನ್ ಮೇಡ್ ಬೈ ಮೈ ಜೂನಿಯರ್ ಕೊಲೀಗ್.
ನೋ ಡೋಂಟ್ ವರಿ, ಪೀಸ್ಫುಲಿ ಯು ಅಂಡರ್ಗೋ.
ಐ ಆಮ್ ಆಲ್ವೇಸ್ ರೆಡಿ.
Peacefully you undergo eye operation.
2:30 ತಗೊಂಬಿಡಿ ಸ್ವಾಮಿ. 2:30
day after tomorrow.
Because very old matter. 219 the further argument.
ಆಯ್ತು ಸರಿ. 2:30
much of it.
97.
Passport, my lords.
ಸಿರಾಜುದ್ದೀನ್ ಬರೋಲ್ಲ?
No, my lords. Passport, my lords.
Passport.
The lady possessing 2 passport, my lord, Bahrain national, my lords.
Lady possessing 2 passports.
Yes, my lords.
Why did you possess 2 passports?
My lords, at the time of childhood, my parents has filed an application and passport was issued in while I was in Bahrain, my lords. I am Bahrain national, my lords.
You are a Bahrain national?
Yes, my lord.
How are you staying in India?
Let's, after the demise of my father, I came here to India, my lords, and thereafter.
When did you come?
In
1991.
Yes, my lords, 91.
ಆಮೇಲಿಂದ how are you staying here on Bahrain passport?
No, my lords, I was a child, minor child, my lords. I came with my
All
mother.
right, sir. Now 1991 minor child ಅಂದ್ರೆ ಇವಾಗ 30 ವರ್ಷ ಆಗಿದೆ.
ಹೌದು, my lord.
ಆಯ್ತಾ? How are you staying in India without passport? Indian passport ಕೊಟ್ಟಿದಾರಾ?
Indian passport ಕೊಟ್ಟಿದಾರ. I
ಯಾರು
applied for
ಕೊಟ್ರು? ಎಲ್ಲಿ
Indian
Bahrain
passport.
ಕೊಟ್ರಾ?
No, my lords, here, because I was born there and I came along with my mother here in India. ನಾನು ಇಲ್ಲಿಗೆ ಬಂದೆ. Thereafter, I was not knowing that passport was issued in the Bahrain, my lords. After in 2017, I applied for a passport.
ವಾಪಸ್ ಹೋಗಿದ್ದೀರಾ?
No, my lords, by permission of your courts, I am ready to surrender my passport here. I am ready to go, my lords.
What happens to all these years of holding dual passports?
It came to my knowledge recently in 2017 after applying.
Recently 2000?
After in 2017, I applied for passport, my lords. I got issued the passport, my lords. That is the reason.
Please.
Last time, your lordship asked me to ready to surrender the passport and all, my lords. I filed an application. The passport authority is not ready to take my passports and Aadhaar card and all, my lords. I am ready to surrender.
Aadhaar card ಮಾಡಿಸಿದ್ದೀರಾ?
Aadhaar card, PAN, passport, everything is here, my lords.
Sir.
I am ready
Aadhaar
to
card
surrender.
ಮಾಡಿಸ್ಬೋದು ಬಿಡಿ.
Please. Lord, the petitioners happens to be a Bahrain national who comes to India.
No,
in
Bahrain national comes to India when?
1984, 1987.
1987.
Please, she was born
On Bahrain passport.
on Bahrain passport.
1997. Yes.
She comes with her father on her father's passport.
Father had Indian passport.
No, father is a Bahrain national.
Mother is Indian national.
Mother is,
All right.
mother goes to Bahrain. This petitioner is born in Bahrain. They come back to India.
All right.
Since then, my lord, she is in India. If your lordship may kindly turn to page 14 of my annexure R2.
Objections. Yes.
It says declaration, my lord, the passport is it should not have been.
Why you don't verify anything? Self-declaration ಕೊಟ್ಟ ತಕ್ಷಣ self assessmental tax determine ಮಾಡ್ದಂಗೆ. Yes. Now if she wants to go back and never come back. No, it has gone because you can't hold two passports, Indian passports, passport will go.
All that, 2017, she wanted to go to Bahrain. She goes to Bombay. And from there she wanted to go.
Bahrain ಬದಲು ಬಾಂಬೆ.
Bombay goes. The authorities there says, see, you have two passports, so you can't go. That is the first time she is born.
That is 2017.
2017. Thereafter, my lord, from there, they want to surrender the passport and all. Now, my lord, in the next flight,
Next flight.
if they are going, we will revoke her passport.
15, 20 days, other maximum 1
Next
month.
flight is not after 20 days.
Maybe tomorrow, my lords, but
ಮತ್ತೆ?
1 month, because I have 3 children, I have made all the arrangements.
They should pack
5 children.
5 children.
Yes, ma'am, 5 children. I have made all the arrangements for children.
Arrangement for what, sir?
Now, my lord, overstaying is one. She will be penalized for that.
No, if you want, we will see, maybe ignorance of law, but you should quit India.
Yes, my lords.
ಯಾವಾಗ ಅಂತ ಹೇಳಿ.
By end of this month, my lords, I'll be.
June 30th ಒಳಗೆ pack the bags. We'll do that.
Oblige.
Because
No, my
of before staying without
No, my lords, I will come with
authority.
valid visa and valid passport. If the government of India issue visa to me, I will come because my children are here, my lords.
We cannot stop the government of India in considering, but till
Only
then.
in accordance with law, I will come.
Ana nahi, jana nahi.
Ana hai, jana nahi.
Aya to jaya nahi hai. Yes. Abhi jaya to ana nahi. Yes.
Only visa is issued, my lords.
We'll pass that order. Disposed. Affidavit on the haki.
Already I filed an affidavit, my lords.
See, do one thing. Passport, Indian passport you produce, affidavit of undertaking you file, that you will not come back unless the law permits, will permit you to go out.
Tomorrow it may be. I'll
Tomorrow or day after tomorrow.
No
Everything.
tickets. First of all, visa should be issued to me, my lords. Once I surrender a passport, then only the Bahrain will issue a visa for me.
I will give you 15 days time. Will keep the matter pending. Then I'll post it on 27th June. By then, make all your arrangements, produce the tickets, and only in accordance with law you can come back if law permits. Well, ಮಕ್ಕಳಿದಾರಲ್ಲ ಮತ್ತೆ the children are there. This is a mother, right?
Yes, my lord.
Children are there.
That the passport authorities may revoke. They approach and make a representation. If that is there, we will revoke it.
Yes. Already I was given a
There is no
representation.
surrendering, sir. They have to revoke. Should I now pass an order on that? Yes. All right. The petitioner, a citizen of Bahrain, is now at the doors of this court seeking her exit.
Yes, my lord.
ಅದು ಇಲ್ಲೂ ಪಾಸ್ಪೋರ್ಟ್ಗೆ ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಾ seeking a direction to permit her to surrender the original Indian passport, Aadhaar card, PAN card, or all other statutory identification documents that she has in her favor. The learned counsel Sirajuddin, appearing for the petitioner, submits that the petitioner comes to India in the year 1997 when she was a minor along with her father, and has continued to stay in India through 1987, sorry. Continued to stay in India all along, holding an Indian passport as well as a passport of Bahrain, which is granted on the strength of her birth in Bahrain. The petitioner appears to have realized in the year 2017, when she applied on self-declaration for grant of a passport, the passport authorities, without even looking into the facts, have straight away granted an Indian passport, notwithstanding the fact that the petitioner is a Bahrain national and did possess a passport of Bahrain. Now, the learned counsel Sirajuddin submits that the petitioner wants to ceremoniously exit the country and travel back to Bahrain, and would not come back unless the law permits. The learned DSGI submits that if an order is passed in the wake of the prayer that is sought, the passport of the petitioner would be revoked, considered to be revoked. In that light, it is the passport authorities are free to pass necessary orders in accordance with law, revoking the passport, and the petitioner shall file an affidavit of undertaking before this court that she would leave the shores of this nation within 15 days.
Within the end of this month.
15 days. By the end of this month, i.e. 30th of June 2025. The said affidavit, along with other documents, be placed before this court on the 27th. List the matter on 27th at 2:30 p.m.
Obliged.
Your Lordship may ask why is that she's going back?
Huh?
Your Lordship may ask why is that she's going back?
Why she is going back? She has ancestral property there, my lords.
ಅದು
And
ಬೇರೆ ಇದೆಯಾ?
without, yes, my lords, without a person of a family member is present, no property can be disposed. That is the law there.
The story is.
What about the children? How are you leaving them and going?
Children, my lords, I will come through visa, my lords. ಆಮೇಲೆ ಇಲ್ಲಿ ಇರ್ತೀವಿ. After I'll settle
ಇರ್ತೀರಾ?
afterwards I'll get back my children there, my lords.
Oh, you'll take the children there.
The story is this, my lord. Father married somebody else.
ಗೊತ್ತಾಯ್ತು ಅದಕ್ಕೆ.
And brother is staying.
Obliged.
27th. Yes.
98.
The petitioner in this case,
ಯಾವ್ದು
my
ಮೇಡಮ್
lord.
ಇದು?
There's a case of the para swimmer, my lord. Cash award of 6 lakh rupees is what
Oh,
we have
yes.
asked, my lord.
ಇನ್ನ ಮಿಕ್ಕಿದ್ದು 1,28,000 ಏನೋ ಕೊಡ್ಬೇಕಲ್ಲ? ಯಾವಾಗ ಕೊಡ್ತೀರಾ? ಯಾವಾಗ? ಇಲ್ಲೇ ಅದಕ್ಕೆ ಕಾಸ್ಟ್ ಇಂಟ್ರೆಸ್ಟ್ ಎಲ್ಲ ಸುಮ್ಮನೆ ಯಾಕೆ?
My lord, the matter is 2 years old, my
Wait,
lord.
madam. Friday ಒಳಗೆ ಕೊಡ್ತೀರಾ? ಕರೆಕ್ಟ್, ಈಗ ಫ್ರೈಡೆ ಒಳಗೆ ಕೊಡ್ತೀರಾ ಇಲ್ಲ ಅಂದ್ರೆ ಒಂದಷ್ಟು ಕಾಸ್ಟ್ ಆಮೇಲೆ
With
ಅದಕ್ಕೆ
interest, my
ಇಂಟ್ರೆಸ್ಟ್
lord. Yes, my lord.
from the pocket of the officer who has held the file till now?
My lord, he does not have both his arms, yet he swims and he's won so many awards for the country, my lord.
I think the state ಸುಮ್ಮನೆ ಯಾಕೆ ನನ್ನ ಬಾಯಲ್ಲಿ ಯಾಕೆ ಬೇಡ ಬಿಡು. ಇದರಲ್ಲೂ ಮಾಡಲ್ಲ and you swindle money all over. List the matter on Monday. In the event they remain Tuesday, in the event the amount that the petitioner is entitled to would not be dispersed to the petitioner by the next date of hearing, exemplary costs along with interest shall ensue and to be recovered from the pocket of the officer who has held the file till date without disbursing the entire amount. Next,
Grateful.
Tuesday in preliminary hearing.
99.
ಏನು ಕುಕ್ಕೆ ಸುಬ್ರಹ್ಮಣ್ಯದ
Ghati Subramania.
further hearing? Oh, sorry, further hearing.
Lord, there is, this question did come up as to whether, my lord, this Tirtha Prasada could be served outside the precincts of the temple. The Agama Pandit, my lord, has given a report.
But it cannot be.
It cannot be done and it has to be done.
Cannot be.
ಅಲ್ಲ,
ಆಗಮ ಪಂಡಿತ್ ಬೇಕು, ದಾರಿಲಿ ಹೋಗಿ ಪ್ರಸಾದ ಕೊಡಕ್ಕಾಗತ್ತೆ ಆಚೆ?
ಅಲ್ಲ, ಇವ್ರು
ದೇವಸ್ಥಾನದೊಳಗೆ ಕೊಡ್ಬೇಕು.
ಅಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಅದೇ ಹೇಳಿದ್ರು, ಆಚೆ ಹಾಕೊಂಡ್ರೆ ಮಾಡ್ಬೋದು ಅಂತ. That is,
ನೀವು ಪ್ರಸಾದ ಕೊಡ್ತಿದ್ದೀರಾ?
ಹೌದು.
ಪ್ರಸಾದ ವಿನಿಯೋಗ ನೀವ್ ಹೆಂಗ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Item, you deliver it inside the temple will give. ನೀವೆಲ್ಲಿ ಪ್ರಸಾದ ಆಚೆ ಕೊಡ್ತೀರಾ?
ಅಲ್ಲ, ಆಗಲ್ಲ, ಆಚೆ ಕೊಡಕ್ ಆಗಲ್ಲ. Lord, the prasada is, my lord, sold inside the temple. They are saying.
Correct, sir. You are selling prasada?
Yes.
And that ladu you sell inside the temple, is it?
Yes. Idu Panchamrita, ladu, all those things, my lord. And there is no shop, as please see the photograph. My lord, there is a table which, my lord, we serve. And at the end of the day, my lord, the table is kept in one place and we go. There is no shop as such as. I have produced the photographs. The lords will get it at page number 13. So,
yes.
So therefore, my lord, question of shifting this outside may not, my lord, be feasible. And outside, my lord, directly.
Yes, sir. Idu Ghati Subramanya.
Ghati Subramanya.
Not Kukke.
Not Kukke, not.
Subramanya Swami anyway. Kukke no Ghati no.
Adaldene, my lord.
Aಯ್ತು sir. The learned senior counsel Devdas seeks. Oh, sorry, sir. Learned additional advocate general C. Devdas would seek 2 weeks' time to verify the documents that are now filed, now handed over to him. Entry modidiyala. List the matter on 1st July. Entry order subsisting will continue till the next date of hearing.
I have just filed one compilation that may be.
Madi.
Alla, that may be taken on record.
ಏನು ಪ್ರಸಾದ ಹೇಗೆ ಕೊಡ್ತಿದ್ದೀರಾ ಅಂತ?
ಅಲ್ಲ, ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ. ಅವ್ರು they had made 30 ಲಕ್ಷ ಬರ್ತಾ ಇದೆ ಅಂತೆಲ್ಲ ಹೇಳಿದ್ರು. ಅದಕ್ಕೆಲ್ಲ ಡೀಟೇಲ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಎಷ್ಟು ಬರುತ್ತೆ?
ಅಲ್ಲ, ನೋಡ್ಲಿ, ಅವ್ರು ನೋಡ್ಲಿ.
ಆಯ್ತು ಸರಿ. First we'll take it on first.
Yes.
That's all right.
100.
ನಿನ್ನೆ ನಿಮಗಾಗಿ ಕಾದಿದೆ. Yes, sir. Correct, by detailed investigation. Murder is reduced to assault. 302 is reduced to 323. CBI ಕೊಡ್ಬೇಡ ಅಂದ್ರೆ ಹೆಂಗೆ ಹೇಳಿ?
The entire material what we have collected will prove that the petitioner himself is at fault because he has.
My lord, about just that one issue.
Don't get touchy. Wait.
641 will.
Page 641. ಯಾವುದು ವಾಲ್ಯೂಮ್ 2 3 ಅದೇನು?
This is one set, my lord.
Convenience compilation.
No, my lord. This is the petition, my lord. I've just made it one set, but in the filing counter, they don't allow us to do this. They ask us
That's
to file.
better. Ad kodi ಇಲ್ಲಿ. Give that. Pagination ಎಲ್ಲ ಸೇಮ್ ಇದೆಯಲ್ಲ? ಕೊಡಿ.
They do not allow us to file it this way.
Don't worry. Court will allow.
Only around 5 or 6 pages.
506 pages, sir.
5 or 6.
5 or 6 pages. Only 506 pages I will rely on, Andre? Yes.
641.
Yes.
The forensic report dated 11/12/2023. The incidents are occurred on 17/12/2022.
641.
It's true that 13 injuries, small injuries have been. The reason of the death is due to the head injuries. But it is at the last, the cause of the death mentioned last lines of the page. Postmortem report so and so. The deceased died due to the cerebral injury as a result of blunt force promotional to the head. It is more likely to due to the fall. That is one thing. It is also
More likely due to the
fall itself, the injury. And further, my lord, one Gurua has given a statement before the
page.
Gurua statement. Attendance. So I say it has been not noted at the note sheet. It is it.
ಓದಿಲ್ಲ ಅಂದ್ರೆ ನಾಳೆ
ಗುರುವಾರ ಮೇಲೆ Thursday.
ತೊಂದ್ರೆ ಇಲ್ಲ. Thursday.
I mean,
at 2:30 p.m.
Only around 7 pages.
2:30 sharp, I'll take it. You read and come.
I want to point out one thing about this Guruva witness that the state is trying to rely on, because let the AGA just secure information about this fact as well. Lord, he says that this Guruva, who is the eyewitness, was not present in the scene of occurrence. Lord, I have produced the attendance register of the very same witness CW50 that they rely on, saying that I was working in a different estate. Lord, he gives me a attendance register of that month of December 2022, wherein he says I was not working there, and he sealed and signed it. But he has given a statement contrary to the police that I was apparently working there at the scene of occurrence. My lord, and one more strange aspect about this is, my lords, they tried to build an alibi story. The police tried to build it by saying that there was a Hoysala call, my lords. That is a 112 call which was made. My lord, this very same person who is a police constable who has come in the Hoysala, who has said to have come to this location, Gangadhar Pujari is his name, my lord. His CDR is produced. My lord, where is Gangadhar Pujari at that time? My lord, he's in Bantwala. And where is the scene of occurrence? My lord, this is Kurunja. That is 60 kilometers away.
Lord, even if this accept of presence of Gurua came to be means accepted, is the attendance register is manipulated, which is sent to the forensic, and forensic report was being brought, my lord. And his presence and the CDR.
We'll take it on Thursday.
My lord, and this forensics report that they're relying on, they are trying to say that an X, which marks my attendance saying I'm present, is marked to saying that I'm absent.
It's all
How will it benefit?
You have filed your synopsis and other things here.
But I have filed my synopsis, my lord. Or if I'm permitted, I'll just take my set back. I'll
Please take
file
it back.
another.
Take it back. And either a compilation of
I'll do that, my lords.
better, and refer to the pages.
I'll do that, my lords.
Yes.
101.
Or if I'm permitted, I'll just file a compilation of all the necessary documents.
Yes.
Along with the page
Do
numbers.
it.
my lords.
Yes.
Grateful.
I appeal for the petition numbers. Challenges to final notification. A project was prior.
Thursday.
Thursday.
We'll continue, Guruvar.
In the preliminary hearing notes, I've sought for an interim order.
Then let it come in preliminary hearing.
May kindly.
List the matter day after tomorrow in preliminary hearing.
May kindly.
Yes.
List number 2.
Oh, adu ideyalla. Non-compliance.
I appear for the respondent number 3.
ಇವತ್ತು ಇಲ್ವಾ?
Number 1 for dismissal.
Comply ಆಗಿಲ್ಲ? In terms, JY. In terms of the earlier order. Yes. Next.
First time matters. Till number 2.
Same format order.
2
Number 8, my lord. Serial number 2, my lord. I appear for petitioner. Serial number 2.
ಏನು?
Lord,
Two ಏನು?
the complaints is regarding to some RJ 169 of 2022, my lord.
ಅಯ್ಯೋ ಇಲ್ಲ, ಅದಕ್ಕಲ್ಲ ಕಂಪ್ಲೈನ್ಸ್. ದಿಸ್ ಇಸ್ ಸರ್ಕ್ಯುಲರ್ ಇಂದ ನನ್ನ ಮುಂದೆ ಬಂದಿರ. ಡೋಂಟ್ ವರಿ ಅಬೌಟ್ RJ ಎಲ್ಲ. Go and comply with the office objections. Same 2 weeks time is granted. In the event they stand complied, the matter be listed on the next ensuing Monday. ಏನ್ ಮಾಡ್ತಿದ್ವಿ ಮೇಡಮ್? Yes, next.
Much obliged.
7, my lord.
The objection is my lord to serve copy on the caveat, my lord.
Sir ಮಾಡಿ.
ಅಲ್ಲ caveat petition filed by me itself, my lord, through other counsel. Petitioner filed ಮಾಡಿರೋ caveat, my lord. On petitioner.
ಭೈರವ್ ಜೀವಿ ಅಂತಿದೆ ಕೇವಿಯೇಟರ್.
GV on behalf of petitioner he filed, my lord.
Behalf of petitioner ಕೇವಿಯೇಟ.
Caveat.
ಯಾವ
8/4/2025.
Behalf petitioner you file ಕೇವಿಯೇಟ.
Yes, my lord. Through some other advocate petitioner filed.
ಡೈಜೆಸ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ, through some other advocate, my lord. The petitioner has filed a caveat petition, my lord, with respect to the civil suit, my lord. That is caveat filed in favor of the petitioner, my lord, against the BDA and the respondent, my lord. ಅದು ನಮ್ಗೆ against ಆಗಿ notify ಆಗಿದೆ, my lord.
I have heard of respondent filing caveat, petitioner filing caveat.
ಅಲ್ಲ, my lord, ನೀ ಹಿಂದೆ ಮಾಡಿದ್ದು ಈಗ ರೀಸೆಂಟ್ ಆಗಿ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ, ನನ್ನ against put up ಮಾಡಿದ್ದಾರೆ, my lord.
ಅದಕ್ಕೆ 5 ಗಂಟೆ ಆಗೋಯ್ತಲ್ಲ, ಮೆಟಬಾಲಿಸಮ್ ಸ್ಲೋ ಆಗಿದೆ, ಡೈಜೆಸ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೆ. Yes. Tomorrow ಏನಿಲ್ಲ.
ಅಲ್ಲ, my lord.
Come on Thursday. Yes.
Serial number 8, my lord. BCCI charges, my lord. BWS is my lord.
Covered,
Covered, my lord.
Ketan, ನೀವು ಯಾರಿಗೆ?
Number 6, my lord. Officer is this, my lord.
ಎಲ್ಲ ಒಂದೊಂದೇ ಆಗಲ್ಲ ಇಲ್ಲಿ.
Copy is not served to the ASG officer.
Sir.
ಇಲ್ಲ ಇಲ್ಲಿ
ಇಲ್ಲ.
NHA kindly hear me.
Serve ಮಾಡಿ sir.
ಇಲ್ಲ NHA ಗೆ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಪ್ಯಾನಲ್ ಇದ್ರೆ I may be permitted to serve.
ಮಾಡಿ ಅವ್ರಿಗೆ ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು ಮಾಡಿ. Yes.
I may be permitted to serve Shobit Shetty, my lord.
ಇಲ್ಲ ನೀವು ಏನಿದೆ ಸರ್ವ್ ಮಾಡಿ.
ಇಲ್ಲ ASG ಗೆ, my lord, sir.
ಯಾರಿಗೆ ಬೇಕು ಕೊಡಿ ಸರ್, ಎಲ್ಲದಕ್ಕೂ ಆರ್ಡರ್ ಬೇಕಾ? Yes.
Kindly out next Tuesday, my lord.
It will come on Tuesday. You comply with it. Yes. AWBDS is close.
Second time matters 10 days, lord.
10 days, same order.
Serial number 5, my lord.
Wherever interim order is there, they will continue. Yes.
My lord,
Time matters 1 week.
My lord, serial number 14, my lord.
ಏನು?
Annexure.
My lord, serial number 13, my lord. I have complied with all the office objections.
Accepting the submission of the counsel for the petitioner, office objections overruled. First time,
First time ಅಲ್ಲೇ ಮಾಡಿದ್ದೀನಿ.
List on Tuesday in preliminary hearing. Next.
My lord, serial number
Same
14.
order in 14.
Serial.
Grateful, my lord.
My lord, may I request serial number 5, my lord.
5, you missed the bus. Wait, sir.
Third time matters.
Serial number 15, my lord, I request
Serial
for
number?
Thursday. 15, my lord. Few objections I'll come.
Comply ಆದ್ರೆ
urgency.
ಬರುತ್ತೆ Tuesday. Yes.
Third time matters 1 week.
1 week, same.
For serial number 24.
Serial
Why senior waiting?
Serial number 22, my lords. We made a prayer to initiate a contempt and then the office raised an objection.
Contempt on what, sir?
Lord, based on the interim, there is a stay of dispossession. In spite of the dispossession, there is a measure drawn, possession has been taken, revenue.
Office objection ಏನು?
Office objection says that prayer C, we said initiate a contempt proceedings against the land acquisition officer. They say that
Will not press prayer C ಅಂತ ಹೇಳಿದೀರಾ? Last time record ಮಾಡಿದ್ದಾರೆ MI Arun Saab. Yes. The coordinate bench on 27/6/2024 has passed the following order. In that light, list the matter in preliminary hearing B group on next Tuesday. Tuesday ಅಲ್ಲ, Thursday next. Yes. ಈ ಕಡೆ ಬನ್ನಿ. 24 ಏನು?
For not serving copy.
Serve
We
ಮಾಡಿ.
have served the copy and we have
Sir,
not.
serve ಮಾಡಿ. Yes.
Your lordship, we have been served. We are filing the memo.
Registry. Yes.
Fourth time 1 week.
1 week finally.
A date might be fixed.
Peremptory order. It will come. You complied Tuesday.
That serial number 5, my lord.
Further hearing ನಾಳೆ ಬರುತ್ತಲ್ಲ. Further hearing.